I'd like to call this regularly scheduled March meeting of the Tennessee Real Estate Commission to order. First on our agenda is our roll call. Ms. Maxwell.
Before the roll call, let me read this statement about the posting of the agenda. This meeting's date, time, and location have been noticed on the Tennessee Real Estate Commission's website, included as a part of this year's meeting calendar since September the 7th of 2012. Additionally, the agenda for this month's meeting has been posted on the Tennessee Real Estate Commission's website since February the 28th of 2013. Also, this meeting has been noticed on the 10Gov website since February 22nd, 2013. Now ready for the attendance. Alexander, Collins.
Here.
DeChara.
Here.
Flitcroft. Grease.
Here.
Haynes.
Here.
McMullen. Northern. Stevenson.
Here.
We have 5 present members.
My understanding that Commissioner McMullen and Commissioner Northern will be here a little bit later this morning. They had some other things they had to do this morning, but having a quorum, we'll continue with our agenda. At this time, I would like to call on Commissioner Collins to lead us in our invocation.
Heavenly Father, we give Thee our thanks for this day. Thank You for the freedom we have to come together and assemble. Dear Heavenly Father, we pray that everything that we do in this meeting today will be approved in Thy sight. We thank You for the opportunity we have to serve this great state. Be with our troops overseas. In Christ's name, amen.
Amen. Next on our agenda is to adopt our agenda. Are there any additions or corrections to our agenda?
Motion we approve.
Motion from Commissioner DeShaw to approve our agenda. Do I hear a second? Second by Commissioner Collins.
Mr. Chairman?
Did you have something, Commissioner Grease?
I suspect we ought to move the discussion on E&O insurance up to close to the top, if not to the top of the agenda.
It's since we have Wayne Pugh here, Ms. Maxwell, when do you think that would be to go ahead and do that first?
Yes, Mr. Pugh, I think, has to be at the legislature, so he would like to go first. And Commissioner Northern had mentioned a desire to add something about the reinstatement policy to the minutes. I don't know if that's to the agenda. I don't know if that's something he wants to do at the current time or not.
He indicated to you he wanted to do.
Add a discussion about the reinstatement policy to the agenda. He has not confirmed that, so I don't know whether he wants to do that at this time or not.
If it would be okay, we have 2 things. I know we have a motion and a second. Motion by DeShaw and seconded by Collins to approve our agenda, but if it's okay with you two, we will let Wayne Pugh about E&O go first, and then we'll add the issue that has been given to us by Ms. Maxwell about the reinstatement policy. We'll just go ahead and put it on the agenda. Let's put it on the agenda when Steve McDonald's education report. We'll put it right after lunch. During his education, at the end of his education report, we'll talk about reinstatement policy.
That's fine, thank you.
We'll add that at that time to the agenda with those 2 additions. All in favor? Aye. Opposed, no. Motion carries. The agenda has been adopted as amended. Next is the approval of the minutes. Are there any corrections or additions to the minutes?
Motion to approve.
Second.
Motion by Commissioner Collins to approve, and a second by Commissioner Grease. All in favor say aye.
Aye.
Opposed, no. The minutes from our February meeting are approved. As the agenda has been amended, I'd like to at this time turn the floor over to our General Counsel, Mr. Wayne Pugh.
I am Wayne Pugh. I'm the Deputy General Counsel for the Regulatory Boards Division. I do a lot of the legislative work, or act as a liaison between the administration and our liaisons with the legislature. As you're aware, we have a bill in front of the General Assembly this year regarding the E&O policies. Actually, this bill came about as a result of our discussions on changing the contract to go away from a master policy plan to an individual plan. And during the discussions, the representative assured the Commission that he would run a bill this year to provide for an automatic suspension of anyone who did not have the E&O policy when they should have. That bill is in front of the Commission at this time, or in front of the General Assembly at this time. They've made one amendment on some concerns we have, which addressed a number of concerns, but there is still a portion of the bill that causes great concern to the administration, our administration, to the workload. Do they have the bill? Do they? You have the bill in front of you, or it's in your iPad?
Yes.
You've gone to iPad since I was the board attorney.
They have it in copy, too.
It's in Section 1. It's the first sentence under G. Each licensee shall be notified of the required terms and conditions of coverage for the policy at least 30 days, but no more than 90 days before the policy's renewal date. Now, there are two changes from the current Section G. Current Section G says that they will be provided notice of the terms and conditions 30 days prior to their license renewal date. We know everybody's license renewal date. That is something that our computer system captures. Our computer system, as it is right now, correct me if I misspeak, Eve, does not capture and run in the 30-day advance or 90-day advance of when the policy expires. Now, on people with state insurance, I mean, we could handle that. But it's the alternative coverage people that is really causing a problem. And there's some 7,000
Of alternate,
alternate or
there are about 6,000, a little over 6,000 alternate people right
Okay.
now.
that we would have to provide notice 30 to 90 days prior to their policy renewal date, which we are not equipped to do from a computer standpoint that's just going to flag it out. It's going to require a lot of manual labor from the board staff. Now, the whole purpose, when we started discussing alternative ways of providing for insurance, was to reduce workload. Well, everybody here has seen what it requires when we get into that situation and we get into where people have let their insurance lapse. How many people let it lapse? How many hearings and things that we have to schedule, and what kind of work it requires for the staff to make the reports. We're getting, basically what this bill is doing is just shifting it from one area to another area. And actually, I think, according to Eve, it may actually make it a little bit more cumbersome. Now, I have proposed language to the lobbyist that's carrying the bill that to change that first sentence basically to read that the Commission shall provide notice of the required terms and conditions of coverage for the policy upon request. If a licensee requests it, we'll provide that information, and by posting the information on the website. He is advising that his people, and I'm assuming that is the TAR, the leadership of the TAR, is having a problem. They want something about the notice. But I'm bringing this in front of you today to let you know that this sentence causes us a great deal of problem with the work.
Mr. Pugh, do the alternate coverages not have to run the same time frame as the state coverage?
Not
Don't they have to
necessarily, I
be
don't think, do they?
run the same?
No.
They don't? Okay.
Would that help?
They ran the same coverage.
Same time frame.
I'm not sure that would be possible. I mean, we enter into a contract. Insurance is a contract, and we enter into a contract with the carrier to provide that. So you have a contract that has a term. to make everybody, and I'm not sure how you would go about trying to make everybody have the same term.
Well, I'm one of those that has alternate coverage, and when we got ours quoted, we told them it had to run the same as the state, so we had to have the same expiration dates as the state policy did. And that wasn't a problem. What they did was just, for the companies that came on later, they just prorated it so that it came out at the same time that the state expired. Because mine's on the same time frame as the state policy.
Period and everything? Or is it a 1 year with a,
It's a 2-year,
it is a 2-year
it's a
straight
2-year policy.
I don't know. That is not, I'm just looking at it from a statutory, if we put it into a statutory thing, that they have a statutory obligation to do it, it will create a problem for us to do that. I'm not sure. I know everybody's talked about the new computer system coming in, if the new computer system is going to capture that type of information or not. Personally, everybody that carries insurance is going to get a renewal notice. Your insurance company is going to send you a renewal notice. My motorcycle insurance is due now. They certainly send me a renewal notice to let me know to pay the premium. So everybody knows when their insurance is going to expire. We're happy to provide the information. If you pick up the phone or send us an email or whatever, to provide the information, and we'll certainly have the information on the website. It's just we have a problem with being statutorily obligated to send notices out 30 and 90 days ahead of time.
So how does TAR, they got a problem with your new language?
They did. I submitted it to Russ Farah, is the lobbyist who's working with TAR, and he said they have a problem with that language. So I want to get the commission. This bill is up in House Committee today at 12:30. The last time I spoke with him, he was contemplating whether to roll it to see if we could still work on something. Russ's position was he wasn't sure he understood why we couldn't do the 30 to 90 days, since we take action when somebody doesn't have insurance. My understanding with Eve, she can run a monthly report that tells us whether you do have it or don't have it, but that is all it's telling, and that's running off the expiration date of the policy, whether it's expired or not on that day that report is run. It does not give you a glimpse to the future, the 30 to 90 days.
Wayne, with the system that the state has now, that we're operating under, how would the wording need to be modified to accommodate what we could feasibly do with the other? There's about, I'm sitting up here calculating, it's about 27% of our licensees have alternative E&O coverage.
And remember, this is saying we have to send it to every licensee. I'm going to, Eve, if you'll help jump in here. I mean, we do send license renewal notices out, do we?
That is correct, yes.
We could put something on the license renewal notice. I mean, we can't put, because we send postcards, I believe, we can't put all the terms and conditions, but we can certainly make statements that to go where you could go to find it, which would be on the website, or contact us and we'll give it to you.
They happen to say why they didn't like your language?
Russ is just telling me that his people have concerns about the notice, and maybe Commissioner Grease can.
Before I talk about that, so back to your earlier point, anytime my personal E&O insurance is up, I get a notice from at least 2 companies saying, you've got a choice. How do those companies know when my policy's up?
I don't think that you get notice from 2 companies.
Well, Rice will say, you got to pay it, and Williams or somebody will say, you don't have to go with Rice. I mean,
You're with the state? Or
You get competition giving you
Well, I don't
email.
have to be with the state, and so Williams is trying to get my business. So as an example. So my question is...
how they know, other than they must mine our information? Or
They get the, say Williams or Crees, they'll get the information from the licensee search information. You can go on there and you can get a list of all of our licensees that are active, and so they'll get that and just send out a notice to everyone, regardless of, what kind of insurance you have, trying to get your business at 1/1, or, sometime prior to the expiry of the state coverage. But the alternate carriers.
Is that what you were saying, Commissioner Greaves,
Yeah,
or are you getting do you have alternative coverage?
No, I don't. I have state coverage, but Williams still, or someone tries to solicit my business saying you don't have to go with the state plan. So they know.
Well, they know when the state coverage expires because that's public contract, and that's easy to determine.
They can mine it and find out whether I'm on a state plan or a private plan, right? But they can't find out if I'm on a private plan when it expires. That's not possible, is it?
They're just sending that out. The notice that you're getting, they're sending out to everyone on our active licensee list, so that they'll go into licensee search off of our website, and you can request a list of all of our licensees, and they'll go in there and get the list and just send it out, just like you'd send out a mass mailing to anyone. So it would go to all the licensees, regardless of the type of insurance that you had.
So when I talked to Russ Farah, his people, whoever those people are, have this issue, a couple of issues, I think, but one of them is due process. If we automatically suspend a license because they haven't paid errors and omissions insurance without at least giving them some notice we're going to do it, he can make the argument there's a due process issue that if we had a hearing could be problematic. He also doesn't understand, or they don't understand, why the technology is not there so that we can individually notify them. And my argument is I'm not sure our job is to be a nanny state up here, and all those people who have insurance ought to be independent contractors and mature enough to understand they've got certain responsibilities every year if they're going to operate their business. But the trade association he represents, has to look out, in their opinion, for, I guess, the good of the lowest common denominator. I'm not sure. But back to Wayne's suggestion, if it's posted on the website and it would show up like every month people whose insurance are about to expire, what do you visualize that on the website?
What the statute calls for is we have to give notice of what the required terms and conditions are. That's what the notice is talking about. Because the Commission has the authority to determine what the terms and conditions of the E&O coverage will be. So we have to post those terms. We have to give notice of what you are requiring as far as E&O coverage. I think it was about 4 years ago that we changed some of the things that we were requiring, or maybe it was the last time.
Last time.
We changed a couple times. But we have to provide people with the knowledge of what is required, so if they want to go out to get alternative coverage, they know what is the Real Estate Commission is requiring of E&O. That's what it is. That's what the notice is for, is the terms and conditions of what is required.
So we don't publish a manual anymore since 2008, right? But it's on our website. So if people want to reference that, they go to the website now, correct, to see what the statute is and what our regulations are. I don't know why the conditions required for acceptable E&O insurance wouldn't fit the same category as go to the website, find it. I mean, I like your suggestion on that.
I do too. I think it makes sense.
As opposed to it's either that or a paper postcard or mailing. Is that? I mean, those are two alternatives. And
Well, the way the language is now, the way they want to amend it is that it's 30 or 90 days before the policy renewal date. Policy is not defined. You can look at it two ways. It's the state-insured policy or it's the alternative policy. I think the better reading of the statute, since we're talking about what the required terms and conditions are, when you use the word policy, it could mean the state or it could mean your alternative coverage. And they're wanting us to give the notice 30 or 90 days before the policy renewal date. That's where it comes into a problem. We probably have it somewhere in the information that we have in the computer, but it is not. We don't have a means to run a report 30 to 90 days ahead of time telling us whose coverage is going to expire. To do that, the staff would have to go through each license file, which we're back I mean, we're running reports now on the E&O. After the first of the year and stuff, we're starting to run reports and
Right.
getting information from Rice about who, it's just very, very labor intensive. And we have no good means for the foreseeable future of combating that.
What if
That's
we
why-
just ran the notice for our state policy renewal date? I mean,
You got to give notice to everybody. I mean, everybody does need to have notice of what the required terms are. That's why I propose we'll give it. If you call us, if you get a renewal notice on your insurance, and you say I want to renew, but I need to make sure that there have been no changes, you can call the office. We'll send you the information, or you could go to the website and it's posted on the website.
Well, it seems to me you could post requirements on the website for calendar years 2013, 2014, and it would be universal. I mean, the minimum requirements are going to be the same for everybody. So,
Right. It is. Those are the required terms and conditions of what you're looking for.
that's what you think Russ's issue is this fact we don't.
I proposed that language, and he came back and says if people still have a problem with that, they don't want to put that language in. I think it solves the problem for everybody that we, in regard to your concerns about due process, they've addressed that in another portion where if someone wants to, after they've gotten notice or something, they can request a hearing. I think they've addressed the due process concerns in it.
I guess one of my ways of thinking is that we are now in the year 2013 and everything we do is technology driven. So why is there such an issue with the notices being posted on the website? I mean, that's where everybody's going for everything anyway.
Are you talking about my proposed language?
Yeah,
that we post the
I
terms and
agree
conditions
that-
on the website, and if, well, some people may not. I mean, there are still people, I'm a bit older, but I am making the transition to technology. And I'm actually trying to reduce paperwork in our office and trying to make great strides in that. It's 1 foot forward, 2 feet, or 2 foot forward, 1 step back. But there are people that are not going to have that, maybe some in the rural areas that don't have, or something. But that's the purpose of putting it in there. All you have to do is call us. All you have to do is communicate with us, and we will send you that information. And I guess I look at it, Commissioner Grace, as the individuals ought to know when their insurance is up. Either that or the companies will know if they have a global policy. Know when it's up and know to go out and renew their insurance. We need to be able to provide the information or have it readily available to them of what the required terms and conditions are, which I think we can do if they request it, when they know when their policies are going to be have to be renewed, or it's on the website. You can go to the website.
I like what you say. I mean, it just makes sense.
What's the bottom line?
Bottom line,
Yeah.
the bottom line is if they run the bill like this right here, it's not going to reduce the workload for the administrative staff. It just continues as the whole purpose of our discussions on redoing the insurance policy was to reduce the labor involved in trying to regulate this aspect of the code.
Was he going to pull the bill if we say we don't like that wording? Are they going to ask you to testify? Will you
I
be
don't
there
know.
and say that the administration doesn't like the wording on
I can say
line
the
G?
administration, I'm hoping to get some kind of position from you guys today that I can, actually, I want to go back and communicate with Russ.
The Real Estate
And say
Commission.
the commission does not like this language either, or would prefer that we go a different direction than this.
And at that time, you will also say why we don't
Yes.
like the language.
Yes, oh, absolutely. Now, this bill is scheduled for committee in the House today.
Have you got other concerns?
No, that is the biggest concern. Everything else has kind of been addressed. We had a concern when it was originally proposed whether it was going to capture everybody or just those with alternative coverages, but they've addressed that in an amendment. I believe we put that amendment.
see
in
it.
in their package. So
See,
that has been.
It may make sense to roll it a week if Russ has to get a blessing from a small group of people, his people, and I think they ought to understand, and they're reasonable people, that we're not trying to keep anything, we're just trying to be more efficient about how we let people know what the requirements of errors and omissions insurance are. I don't think that's unreasonable to expect.
And there were conversations since Friday about whether it should be rolled this week or not. I think Russ' concern may be a little bit, I mean, we are really on the fast track for this legislative session. They are trying to push through things. But could they roll it a week? Yeah, I really think they
It's
could.
not scheduled for the Senate yet, I don't think.
No, it has not been scheduled. It hasn't moved in the Senate. It's only moving in the House right now.
If this bill were to go forward with this wording, what would it entail the commission to do to comply with this?
I'll let Eve address that.
The way the insurance is entered now is that on the main portion of a licensee's screen, you can see if they have 1, which is state coverage, 2, which is alternate coverage, and then if there's nothing listed, they're uninsured. To find out what their policy term is, and whether it's from 1/1 or 10/1, you have to actually go into the note field, because there's not a spot on the front part that will pick up that information. So we actually go and enter it into a note field so that it's not picked up. If you run a program, it's not going to pick up that information in a note field, because that's not something that's going to be normally fed into the program. And I don't even think that at this point it could be fed into a program that would then generate that information. So it would entail us going into every person's computer file, and then, opening up the insurance portion, and then opening up basically what's the note field that then lists the specific policy dates, through the years, and going there and seeing what their dates were of expiry.
And with a little more than 6,000 of our licensees having alternative insurance, insurance, I would imagine, would take 2 or 3 people working all day long to do that, would it not?
Right, and that's it's also a number in flux, because as people transfer, say someone transfers to Commissioner DeChara's firm, well, then she's got a blanket policy. So they then would, then you'd have to note that was a different, if hers was different, hers is 1/1. But if you had, say, a CRY-like, they've got a 1/15 date. So when you work for CRY, then your date changes for renewal. So, there's a constant flux of that movement in there as people transfer firms, and as I say, some have a blanket policy, some have just gotten alternate coverage. So it varies from firm to firm and person to person, and it moves as people move. So you couldn't just say they've got state today, and that's what they're going to have, 6 months from today.
So, Wayne, one more question for you. I know you can't speak for us, but do you think that his group of advisors' issue is not necessarily the posting of what the minimum requirements are for, insurance, but are they thinking we're supposed to give them a notice 30 to 90 days out that their insurance is due?
I can't really speak to it, but that is what I'm assuming, that they want an extra little notice or something.
It's just not. It's not feasible for us to do. That's what I'm hearing.
We could charge them. They wouldn't like that either.
Commissioner Grease, you have, I think, done more study and had more conversations about this issue. I'm going to look to you for some guidance here as to what you think the position that this commission should give to Assistant General Counsel Wayne Pugh to move forward.
First of all, I want to say I'm sure that Russ Farah is trying to do what he said he would do to help this commission. He's making a good faith effort to get done what he committed to do. And what I don't know is what the issue is with his Governmental Affairs Committee or whatever committee it is that is advising him. If it's just what are the minimum requirements, we ought to be able to solve that based easily on Wayne's suggestion. Post it. I mean, we do that all the time with just about everything now. If the issue is they want notice individually, well, we can't give it. I just don't think we have the budget, the time, or the expertise, frankly, with what we've got to work with right now to do it. You know, maybe the question needs to be posed to Russ. You know, what is the issue? Is it these guys want individual notice to people who don't have state-run insurance? And if it is, I don't know how we can accommodate that. If it's everybody knows what the minimum requirements are, we can accommodate that easily, and your suggestion ought to work. I mean, that's how I see it at the moment.
I see it the same way you see it. That just makes logical sense.
I think the six of us who are here now, but five of us have been listening to this discussion about this issue. I mean, are you comfortable with the way John has summed up the discussion and
Or do you
let
want us to
Mr.
make a
Pugh,
motion to vote?
I mean, you want to, you want on record that if you want to put that in form of a motion, John, what you said.
Well, I don't want to, you know, it's a little bit of a negotiation going on. I don't want to bind anybody's hands on this, and frankly, the effective date of this bill, if it passed today, is July 1st, 2013. Well, 80% or more of our licenses are already paid up through December 31st, 2014. So we might have some time. I'm not trying to get into an adversarial relationship here. That would be a way to skin the cat. It's just I don't understand exactly which one of those two scenarios is what Russ's membership is hung up on. You know, can you go back and give Russ a sense of the commission and say,
And that's what I'm really here today, to get a sense of the commission as to what their position would be, and then I will go and have
I
discussions.
don't know that we want to go on record with the motion necessarily. I don't want to take a hard position. I'd like to get this worked out for everybody's best interest if we can. And if Russ needs to roll it a week while he goes back and talks to his Governmental Affairs Committee and says these are the issues, I'm all about that.
I'd actually make a motion to instruct me to go have conversation and express the commission's concerns with how the bill is drafted right now and our capability of complying with that statute.
So, Mr. Chairman.
Would you like to put what Mr. Pugh just said in the form of a motion?
I'll second.
Mr. Green?
I'll second it.
A motion and a second for Wayne Pugh to continue with this. I know, have a motion and a second, any discussion. One of the things I would comment, you know, the intent of what we are wanting to get done is, since our statute says that every licensee shall have E&O insurance, that we just want to have the ability as a commission to suspend someone's license who does not get it. And that's the bottom line, that what we don't want to be mean, we just want every licensee to comply with the statute under which they operate.
We wanted to be able to do it in an efficient manner without causing tremendous workloads upon staff.
Yes.
And without causing lots of expense to the licensee. I mean, because it's tremendous expense if they forget about it or whatever, but if their license happens to be suspended, they're going to wake up pretty quick and realize what it is they have to do, and then they don't have to spend the thousands of dollars that it takes to
Once we go to a formal hearing.
formal
and start
hearings,
incurring
et cetera, et
costs
cetera. So, I mean, it benefits both sides.
Any other discussion on the motion?
Mr. Chairman, I don't want to do anything to hold this bill from going through passage. And we can do something to keep it, to not let it stop the process. I'm in favor of it. Otherwise, I'm not up to date enough to vote one way or the other.
Mr. Chairman, I have one more comment, too.
Okay, Mr. Garish.
So the way this is written, if I understand it correctly, if they don't buy their E&O insurance, we'll flag that, and at the end of the current month, we'll know it, correct? I mean, we'll know if they haven't paid their E&O insurance. At which point, we'll send them a notice, right, saying you haven't paid your E&O insurance? Or do you understand that to be in this bill?
It's suspended automatically. I mean, the notice would be that you have no E&O coverage. Your license is suspended until, basically, I think what the bill says, until you provide proof that you have E&O coverage. It's kind of like a criminal contempt. You're in contempt as long, well, not criminal, civil contempt. You're in contempt until you comply with the condition. And as soon as you hold the keys to the jail, as soon as you comply with what you're supposed to be doing, it's over.
But we tell them their license is suspended. Do you expect we would do that?
That's what the bill says.
Okay, and for the first 30 days following that notice, if you buy your errors and omissions insurance, there is no penalty. Is that also your?
That's right.
So, I mean, in a sense, we are giving them notice. It may be after the fact, but they got 30 days to cure it without a penalty. That TAR ought to take some solace in that, I would think.
There's no penalty under the bill up for 30 days,
Right.
and it's only after.
What's the penalty after 30 days?
$500.
How much?
500.
500, okay.
Well, 30 to 120 days is $500.
500 and then $100 per month. I think they're following what you guys have been doing.
Motion and the second, basically, Commissioner Collins, is to allow Mr. Pugh to move forward with negotiations, and if it takes rolling this for another week, and I mean, our intent is to get this bill passed and signed and in the statute by the end of this legislative session. Ready for a call for the vote on the motion? All in favor say aye.
Aye.
Opposed, no. Motion carries.
Show one abstention.
And one abstention, since Commissioner Northern was not involved in the discussion and came in right toward the end of it. Anyway,
We'll have a no vote on that.
you going to have a no vote?
Yes, sir.
Okay, motion carries 4 yes and 1 no and 1 abstention. Wayne Pugh, go forth. Thank you for coming down.
Thank you.
Good luck.
Getting back to our agenda, next we have an informal conference. Charles Rayburn Jones, timeshare salesperson applicant with principal broker Pam Johnson. Now, I know, if y'all would just sit down for a second. Commissioner Grease had, Commissioner Grease, why don't you just tell him? Yeah, thank you, Commissioner Northern.
I'm not sure I'm as eloquent as you. Occasionally, there'll be people who would like to get a real estate license who have some event or events in their history that might preclude them from getting that license. And Real Estate Commission has a mechanism where they can come before us in an informal hearing and get the sense of whether the commission would grant them a license if all the requirements were passed, even though they did have that history that might otherwise cause a problem. So, as I understand it, Mr. Chairman, we have 3 of those today, and we'll get to hear their case why they should be granted a real estate license.
This is correct. Very, very well stated, Commissioner Grease.
Thank you, Mr. Chairman.
Now, I want, Ms. Maxwell,
Yes.
where are we going, which tables
kinda looking around.
are we going to use, since it's the first time we've done this in this new room, where are we going to let them sit?
I guess for today, we'll have them sit there. We may have to rethink that.
Okay, Mr. Jones and Ms. Johnson, if you two would come, or we could set them over here on the end, I guess.
Why don't y'all go up here?
Come up here, come around and sit at the 2 chairs over there. We need to make sure that those mics are on. I guess they are.
I think they're on.
Yeah, sit up here. Yeah, it is. It's on. If it turns red, it's on. There we go.
And they are very
Okay. You need to swear?
Ms. Maxwell? No. Okay. Julie, Ms. Crop, you're charged.
Solemnly swear or affirm that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
I will.
Yes. ahead, Ms. Maxwell.
Mr. Jones is here today with his principal broker, Pam Johnson. Pam Johnson is the principal broker at Wyndham Vacation Resorts in Sevierville, Tennessee. Ms. Johnson has had no complaints since she's been the principal broker at Wyndham. Mr. Jones has disclosed a number of convictions, a burglary conviction and a forgery conviction, and then a residential burglary conviction. These charges were filed on September the 29th of 1989, and the convictions occurred on August the 29th of 1990. At the time that the charges happened, Mr. Jones was a 22-year-old, he was 21, 22-year-old, who went on an alcohol, as he describes it, an alcohol-infused crime spree, breaking into cars. He was in college, and he had left his student loan money in his car and wondered if other people did the same thing. And so he and a friend of his, who I think now is his brother-in-law maybe, decided to start breaking in cars. And they went on, as I say, sort of a 2-3 week spree. They broke into a number of cars and stole really whatever was available in the cars, golf clubs, champagne, wallets, cell phones. In one car, they stole some video cards to something I'm assuming like Blockbuster, some sort of a store like that, and they went and used the cards to rent a number of movies that they did not intend to return, which is how Mr. Jones ended up with the forgery conviction. Mr. Jones, once this all occurred, he ended up, he pled guilty to the number of counts, and then he was put on probation. His probation was revoked because he was pulled over for a DUI, and he wouldn't blow at the test, and so it ended up being that his probation was revoked, and so he ended up serving some time in jail and was on probation. His probation was completed on 7/3 of 1996, and since that time, Mr. Jones has worked as a telemarketer and a salesman, a business owner, and at a large corporation and is a music minister. He's been married for 12 and a half years and has developed a deep faith since that time. And I'll let him fill in any other parts of his events.
Very, very well put. That describes a whole lot of it. First of all, I'd really like to thank all of you all for giving me the opportunity to come out. And there's so many times, since that time that I have went to apply for, jobs or saw jobs that were available and just gave up and didn't even try because I figured, well, there's no use trying. But this time around, I really wanted to work for Wyndham. I've wanted to work for Wyndham for a long time. So I have went the distance and been very forthright with everyone who I've interviewed with and with Pam about everything, and with you as well. And to give a brief history about it, I was raised in a fundamentalist upbringing, very, very, very strict. Just to give you an idea, it's just I was raised in a very, very, very strict upbringing, and it caused me to be restrained. I was raised to believe that if you believed in God, you were going to be free, you were going to have joy, you were going to have happiness. But I did not. I was just wrapped up in knots all through and through, trying to keep up with all these rules I had for myself. And it led to me having an emotional breakdown in 1986. And at that point in time, I got on prescription medication, which I was not on for years until just recently. And I chose alcohol as my way of medicating myself, after that. And my brother-in-law and I met about the time that he was very dissatisfied, with our church and religion, and as I was. And so we kind of competed with each other. I was trying to impress him. In school, I did not fit in. so much, but he was with the popular crowd, and being with him was just, it made me want to feel like I was fitting in. Well, we began to drink. I began to experiment with alcohol for the first time, and just really liked it. It helped me to just relax and unwind, and just be able to socialize and do a lot of things I didn't do before. And then there came a point in time, one fateful weekend, we didn't have any beer, in the house, and we wanted beer, and that was primary motivation. And I had just left my student loan money, in my car all night long with the car unlocked, and I wondered if anybody else did that. So we headed out into the parking lot, and we started just opening up cars, whatever cars would open. And first car we opened had $10 in it, which we bought a case of beer with, and it had those video cards, which I used to go down and rent into movies, and I signed for them. I signed the man's name. So since that time, there's been no other problems, whatsoever.
Make the point that all the charges were from that episode.
Yes, all the charges that you see were from a 2-week period in my life. That if I could go back in time, I would. That's the one thing. If I could erase any point in my life, it'd be right there, because I sure had paid for it. And there's so many other places I could have worked. There's so many other things I could have done. And I understand that. I did what I did, but in my I think the way my father described it, who passed a couple of years ago, I read through a transcript he had written during that time and trying to help the court, help me, with the court. A delayed adolescent rebellion is the way he put it. If what I did would have happened back when I was 13, when a lot of preachers' kids, rebel, I would have, maybe been sent to juvenile or something like that, and, or whatever. But it just so happened to happen when I was 21. I was absolutely perfect up to that point. Straight A's. I had music scholarships to Belmont College here, and but since then I have that's what happened in terms of my convictions, and I've went on with my life. And when I served as a music minister, I played out at TBN here in Hendersonville, and had an opportunity to serve there for a while. And I met my wife out there. We've been married 12 and a half years, and we've never owned a home in the time that we've been married, and we have a chance to buy one in Dandridge, Tennessee, and I just want a better life. Here at 45, I'd like to live somewhere where I could actually have retirement, and in terms of any danger to me, I totally respect anyone coming in and needing to come in with a condition like this. I totally understand it, but if you called previous employers that I've had, where I've had access to financial records, very sensitive data, credit cards, we're talking probably thousands of transactions. Not a problem, not one time. So I know I've said way too much. I tend to talk too much, but Pam tells me I do. So that's it.
Thank you, Mr. Jones, for sharing that. I know it's probably not the most pleasant of subjects to bring up something that happened over a 2-week period 20 years ago, but does any commissioners have any, before we hear from his principal broker, Ms. Johnson, does anybody have any questions of Mr. Jones before we have Ms. Johnson?
I've got one question. Mr. Jones, you referenced that all of this occurred in a 2-week period, but the probation was revoked a couple of years after.
That is correct. That is correct. Yes, I can. When I went on probation, one of the stipulations of my probation was that I not drink, and I simply could not. I was an alcoholic, and I continued to drink. And yes, I did. Now, the charge that I had, because I did not blow, was actually reckless driving in Nashville. But yes, I did commit the offense of DUI. Absolutely, I was drunk, and I fell asleep, just passed out over on Bradley Parkway and Lebanon Pike, and rolled down the hill there, and there was 3 flat tires on that rental car. And so, yes, I did do that, and because I drank on probation, my probation was revoked, and I started over again. And I also went to jail again for 45 days. So, it wasn't long after that never drank again. So
Are you participating in any program?
I am not, but I'm alcohol free.
If we, Mr. Northern, if we vote to let him sit for the test and get his timeshare license, he will be in the school of Ms. Johnson. He'll be in Ms. Johnson's class. Anybody else have any questions of Mr. Jones? If not, Ms. Johnson, do you have anything you'd like to add?
I'm sure it's quite clear that the reason I'm here is because Wyndham feels like, this was a terrible episode quite some time ago, and to take 2 weeks out of a person's life in which they were a very poor criminal and have them suffer for it is probably not a great policy, and we want to give him a chance because he has proven himself subsequently to be a really good salesperson. Thank you.
I have a question for her.
Commissioner Collins.
On your letter of recommendation, there's 5 blanks, I believe. The first one, how long have you known the applicant?
Oh, you know what? I normally don't fill that in.
How long have you known the applicant?
Since his initial application at Wyndham,
How long has that been?
it was in early February.
And in what capacity did you know them?
Just I met him when he applied for a job with us.
When did you learn of his convictions?
During the pre-hire interview.
And question number 6, do you feel the applicant would be trustworthy in handling of other people's money? And you didn't answer that one way or the other.
I meant to.
Well, you didn't.
I'm sorry, sir. Certainly, Commissioner would have put yes. He's perfectly capable of handling the money of others. But I'll remind you, too, that our system does not leave much room for impropriety there.
I wasn't talking about your system. I was just wanting to know how you felt about him.
I'm sorry. I certainly
Okay,
meant to
thank
fill
you.
that in. Thank you.
Anybody else have any questions of Mr. Jones or Ms. Johnson?
Mr. Chairman.
Mr. Commissioner Grease.
Thank you. Ms. Johnson, I have 2 questions for you.
Yes.
One of them has to do with this applicant, and one of them just has to do with your business as it relates to errors and omissions insurance.
Oh, thank you.
Okay, but first of all, can you give me a sense of what this gentleman's scope of work will be? I mean, will he be out driving people around?
No.
What do you see it as?
At our place of business, all of our customers come to us. Many of them are already Wyndham owners, and those that are not are invited off the street by acquisition agents, or they're invited on the phone by a marketing company, Acme Marketing. Our business, the only time that people leave our site or our building is 25,000 square feet, and everything takes place there, except when people who are unfamiliar with our product go and visit our models, which is a quarter mile away. However, in his case, that's a walk through the building.
So he will, is he going to be an acquisition agent, as
Oh,
you
sir.
described?
He's going to be a timeshare salesperson.
Okay, so is that mostly done on the phone, or is that mostly done face-to-face?
Not done on the phone at all.
Okay, they come in.
The only phoning we do is follow-up. But no, Wyndham invites people to come in, sit with our representatives that are basically our advertising medium, learn about our product, buy it.
One other question.
He hadn't finished that.
Oh, okay.
Okay, thank you for that answer. As far as errors and omissions insurance goes, how does Wyndham handle that? Is it private, or do you use a state plan?
We have a blanket policy, and I don't know if it's like Commissioner DeShares or not, but I learned years ago that the insurance that Fairfield at the time paid for covered each individual that was licensed through our firm, and subsequently we went with the alternate errors and omissions insurance, and I promise you we know exactly when it expires. And I think I can speak for at least probably 10% of the people involved in the alternative programs. They know when theirs expires too.
Thank you. I talked to Cry Like, who's got a big chunk of that private insurance, and they know exactly. I mean, they're covered from the time the agent signs their independent contractor status until they check out to go to another firm. They're covered, and it's not an issue.
Yeah, I'd like the commission to save all the money they can by not sending out personal notifications on stuff that we already know.
Thank you.
Commissioner Collins.
He's working for you now in any capacity.
He's been through our Wyndham training, and so what he's doing at this point in time is riding or shadowing. He is allowed to sit with licensees as they describe the product in order to hone his professionalism in our product.
He's on payroll now.
That would be, yeah, because we don't have independent contractors. Our people are employees, but his status changes somewhat once he is licensed, and then he is eligible for commissions.
Mr. Jones, Ms. Johnson, is he going to be working out of the Pigeon Forge or the Gatlinburg office?
No, actually, he's going to wind up in Sevierville on 66 at the Lodge.
Okay.
But all the initial licensing comes through me because I do all the training.
We haven't seen you in a little while.
I know it, and I didn't want you to miss me too much. I thought I'd better show up today.
We forget who you are. Anybody have any questions or comments? Do I hear a motion as to
I
what?
make a motion, we approve Mr. Jones.
Have a motion by Mr. Shaw to approve Mr. Jones getting a timeshare license. Do I hear a second?
Second.
Seconded by Commissioner Grease. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously. Mr. Jones, go forth and make a lot of money.
Thank you.
Thank you all very much.
Thank you, Ms. Johnson. It's 5 after 10. Do we want to take a break now, or do we want to go ahead with our next informal? General consensus is to move forward. John Westmoreland and Principal Broker William Cates, are you here? Okay. Not this morning.
Raise your right hand. I solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
Ms. Maxwell?
John Kevin Westmoreland is here this morning. He would like to be an affiliate broker, and he's here with his principal broker, Mr. Cates, who has no complaints to date. And Mr. Cates is the principal broker of Remax Crossroad Realty and Auction in Livingston, Tennessee. Mr. Westmoreland has disclosed that he had a federal conviction for misprison of a felony, and that occurred on 1/18 of 2002 as conviction. The misprison of a felony is basically the failure to report a felony. And it's sort of an archaic, quite frankly, an archaic charge that but he was brought in, I guess, on some sort of a sting, and there were 30 individuals that appeared in federal court, and they were brought in on both drug and conspiracy charges. The judge asked Mr. Westmoreland if he had conspired to buy, sell drugs, and he said no, he was not involved in the conspiracy. He didn't sell any drugs. And the judge then dismissed the conspiracy charge against Mr. Westmoreland, but he was then re-indicted on this misprison of a felony charge. And it is a federal conviction for felony. He was ordered to serve 27 months in prison to be followed by 1 year of probation. He was released early. He served 23 months, and he was released from probation on 2/10 of 2005. He says that he did use drugs recreationally, and that was how he got caught up in the sting that occurred, but that he'd never sold them, and I'll let him sort of fill in the rest of the details about this.
Basically, December the 18th, 2000, I was arrested and charged in a conspiracy, as Ms. Maxwell just said, and although it didn't show my TBI report, that's the only charge I've ever had in my life. I don't drink. I use drugs recreationally. I hid it from my family and people that I worked with. No one knew it but me and one other guy. And I would call him on rare occasions to buy enough to use in my home. No one knew it. It weighed less than what a dime weighs. And I'd give 2 years of my life over a bad decision. I don't use it now, and basically I try to live my life today to day and do the right thing and disclose everything.
What have you been doing since you got out? You said 23 months? That's maximum 23 months. Where did you serve your time?
Manchester, Kentucky. I served it in Manchester from February the 1st of 2002 to December the 3rd, 2003. Then I was on probation for a year. And then when I came out, I went to work for DHL, the old delivery route. And then I own 24 rentals that I rent. And we have a family business of 5 apartment complexes we rent in the rental business.
There in Livingston? You live in Livingston now?
Clay County.
Clay County. Does any commissioners have any questions of Mr. Westmoreland?
I'll ask one quick question. That's pretty straightforward.
Yes.
Have you anticipated somebody you're working with finding out about this conviction and what you would say and how you would handle it?
I've always disclosed it, and I've worked in the auto industry the past 4 years, and of course in that business you take people's personal information over the phone. You deal with it every day, and I've got recommendations from some of the people my superiors and people that I worked with, and I probably handled thousands of people's personal information, credit applications and such, without any issue. And I would have not been caught up in a conspiracy if it wasn't been for the job I had at the time.
So let me follow up with my last question. Have you talked with your prospective broker about if somebody you're working with says, I don't want to work with this guy anymore because I understand he's a convict or former convict, how will the two of you handle that?
I don't know.
I think we'll just tell the truth, sir. I think that's the truth's always the way to go.
I'm with you, but if they don't want to work with him, will you reassign those people?
Absolutely, absolutely. That's why we're here. There's nothing really, I guess when they went back and did the TBI check, there's really not anything in there, but what we felt like is in the area, the small town, it's a small town, that when he starts doing well, people are going to come forward and try to incriminate him again. And I believe everyone's due a second chance, and I've talked to him for about 3 years for coming on with my company because I think he's an honest man. He needs another chance, and I told him, I said, well, all we got to do is go down there and just share your heart. So I'm in it. I've known the man for 5 years. I believe in him, and I want to see his life change.
Mr. Chairman?
Yes, sir.
I ain't made a believer out of me. I vote to let him take the test.
I have one more question. What will you be doing?
Will be my agent in Salina, Tennessee. So he'll be.
Will you be selling residential, commercial? You're going to be doing property management?
He'll be doing residential, lake homes, land.
Okay, and so, because you said your family has a business where they own apartment complexes?
We have 190 apartments.
So have you been working in that business as
And
property management?
I have 24 mobile homes I rent.
Okay, but you've been working in property management
Yes, ma'am.
already?
Yes, ma'am.
Okay, and do you anticipate doing any more property management?
Just what I own.
Just what you own? Okay.
I have a question of Mr. Cates. Tell us a little bit about your company.
My company is Livingston Crossroads. It was my mom's business. I was a corporate guy with Sprint Corporate for about 30 years. I took early retirement. I didn't really want to be a realtor, to be honest with you. I told my mom. My mom had 4 boys. She looked at us and she said, "Which one's going to take over my business?" And everybody kind of dove under the table, and I saw the tear well up in her eye, and I said, "Okay, Mom, I'll help you, but I don't want to be a realtor." I said, "They never look like the picture on their card." And, I said, "But I will." So anyway, when I got into real estate, I found out how much you really help people. That there's, people, it's a huge decision that they're making to change their lives, and especially in Tennessee, there's many people coming here to retire, and especially up in our area. We're on Dale Hollow Lake. So I took over Remax Crossroads from my mom. She got sick, and she trained me for about 2 years. She'd sit me in the chair, and she'd point her finger at me and tell me she knew I was one of these corporate guys, but let me tell you about real estate. And everything she told me was true. But anyway, I wanted to hire some agents, and she said she wasn't going to deal with that. But anyway, so I did. So I started Livingston Crossroads, and Livingston took it to the next level. This year, I'm number 2 in the Upper Cumberland area up there in sales, and number 2 in the state of Tennessee with Remax. And I just believe if you treat people like you want to be treated, then it just comes back. It's not about the money, it's about...
Now, how many agents do you have?
8 agents. I have an office in Cookeville, and I also am opening a new office in Byrdstown, Tennessee. So I have 3 offices.
What kind of a training program are you going to be giving Mr. Westmoreland?
Just, we're going to go out together. I'm going to teach him how to check out, property, make sure all the disclosures there. I think that's probably one of the biggest problems I see out there in the real estate business is people don't disclose everything. And so I want to teach him, I'm going to take him under my shadow and teach him how to sell real estate honestly. And when he puts the honesty first, then he'll do really well.
You do know if he comes back, you come back.
Absolutely. That's why I'm here.
I'll second Mr. Collins' motion.
We have a motion that was sort of laying around on the floor for lack of a second, but Commissioner DeShaw has seconded Commissioner Collins' motion to let Mr. Westmoreland get his affiliate broker's license and get into this industry. Any discussion on that motion? Hearing none, all in favor say aye.
Aye.
Motion carries unanimously. Good luck, Mr. Westmoreland. Thank you, Mr. Cates. And
Lucky to have a good broker like that.
let's take a 10-minute break.
Fresh air.
The rest. Okay. I'd like to call this meeting back into order. I'd like to next call on Roger Norris and Principal Broker Larry Musgrove. You've seen the drill. You two just come over here and sit on the 2 end chairs. Let Ms. Kropp swear you in.
You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Maxwell, floor is yours.
Roger Norris is here today with his principal broker, Larry Musgrove, who is the principal broker at Treetops Real Estate in Gatlinburg, Tennessee. Mr. Musgrove has no complaints against him. Mr. Norris, I've sent sort of a timeline of Mr. Norris's history with the commission. He was first licensed in 10/26 of 1983. And he had an affiliate broker license, and then he became a sales associate in Florida on 3/30 of 1992. On 7/11 of 1996, Mr. Norris was issued a Tennessee timeshare license, and on the Tennessee application at that time, he answered yes to question 1, and that is, do you now hold or have you ever held a real estate or timeshare license in Tennessee or any other state? And at that time, in 1996, he answered that he had a license in Tennessee, but he didn't say that he had a license in Florida. His Florida real estate license that he had gotten in 1992 was subsequently revoked in 1997, on 6/17 of 1997. He had failed to respond to a complaint that was filed by Kenneth S. Lewis. Subsequently, Trek got a letter from Mr. Lewis, and in that letter, Mr. Lewis stated that they had gotten everything worked out. He and Mr. Norris had gotten everything worked out, that they were friends, remained friends, and that he had called Freck and advised them of this, the Florida Real Estate Commission, and had also written them a letter, and that he thought that everything had been taken care of. In the meantime, Mr. Norris had left Florida, so he was unaware of the complaint moving forward and thought that it had been resolved. And he said that he never received notification of the revocation by Florida. So then again, in 2004, Mr. Norris applied for a Tennessee affiliate broker license, and he responded again to question 1, yes, that he had a Tennessee license, but did not disclose the Florida license. And then he answered no to questions 2 and questions 3, which are the questions that ask, have you ever had your license revoked, suspended, or reprimanded by any state or local government or by a regulatory body? And that was in 2004, so he was issued a Tennessee affiliate broker license. On 5/30 of 2007, Mr. Norris turned in an application for his Tennessee broker exam, and he answered no to questions 2 and 3, which were the questions about reprimand or revocation, and he answered yes to question 1 regarding licensure, but only disclosed the previously held Tennessee license. On 7/3 of 2007, Trek received a notice from Morello out of their data bank that Mr. Norris had a Florida license and that his Florida license had been revoked. Trek verified that information on 7/5, and on 7/6, Mr. Norris took and passed the broker exam. On 8/3 of 2007, Trek had notified Mr. Norris, and on 8/3 of 2007, Trek received a letter from Mr. Norris that explained that he had written Freck and asked for the information regarding his license revocation, and the information was faxed to Trek on 10/31 of 2007. Trek opened a complaint against Mr. Norris for failure to answer the question truthfully. And then Mr. Norris's letter, we got another copy of that. And Mr. Norris responded to the complaint. It was referred to the legal department. We received his application for broker, which is what's generated by PSI, on 11/27 of 2007. There was several attempts to schedule informal conferences, which we were not able to do. And Mr. Norris was issued a broker license in 2/1 of 2008, and on 8/13 of 2008, the Commission heard the complaint involving Mr. Norris's failure to answer the questions 1, 2, and 3 that involved his Florida license accurately. And at that time, the Commission issued a consent order to Mr. Norris, and he could either have his license revoked, pay a fine, or he could surrender his license. Mr. Norris requested a formal hearing following that consent order, and on 6/12 of 2009, he received a notice of hearing and charges, and he had a formal hearing that was scheduled for 10 of 2009. On 10/1, Mr. Norris voluntarily surrendered his Tennessee license, and that was accepted by the Commission. So he surrendered it pursuant to a final order that was entered into and approved by the Commission. The final order stated that if respondent wishes to be licensed in the future, he may be required to appear before the Tennessee Real Estate Commission. And that was a part of the order that he signed when he surrendered his license back to Tennessee in 2009. And that is why Mr. Norris is here today, is because the final order contained that language that he may be required to appear before the commission if he wants to be licensed again. At this point, Mr. Norris is requesting that he be able to obtain a timeshare salesperson license. He's already passed the exam. He's answered yes to questions 1, 2, and 3, and disclosed his Florida license and all the things that were incident to that license. And so at this point, he is here with his principal broker to fill in the rest of the gaps or answer any questions that the commission might have.
Has he addressed Florida yet?
Yes, he has. He's addressed Florida. I mean, he addressed it in this application, and he addressed it when we filed the complaint against him.
So he doesn't have a pending of complaint in Florida?
No. That was that occurred back in 1996 and in 97. So it occurred a number of years ago.
Mr. Chairman.
Mr. Northern.
In 07 and 08, I was involved with discussion of this particular, or the incident involving the answer to the question and the Florida licensure revocation, and actually did, I believe, phone conferences, or we tried to set up phone conferences, and because of my prior involvement in the outcome, I'm going to abstain from participating in this discussion today.
But the records show that because of the prior knowledge that Commissioner Northern has on this particular subject, that he is going to recuse himself and abstain from any discussion, any voting on this matter. Thank you, Commissioner Northern. Would you like to enlighten the commission of anything that Ms. Maxwell perhaps did not share with us, Mr. Norris, because you have been right in the middle of every bit of this all this time, and just fill in the blanks.
Well, what I was doing, I did a transaction without using the broker, and I was compensated for it. And when I heard there was any grievance over it at all, I just give the guy his money back. But he got the property in question. He kept the property. He still owns the property today. He's happy with the property, and he saved thousands of dollars. Wasn't the right thing for me to do. I did it more or less out of friendship than anything else. His wife passed away in the midst of all this, and he had some, I don't know, I guess he was grieving and what have you, so that's why I gave him his money back, and I shouldn't have done it to start with, and I know that. And I've been, as far as the timeshare industry goes, I've been a part of thousands of deals through the years.
I'm sorry. I'm just going to...
Little red lights on.
I know that it's barely hear him.
Yeah, you need to speak up.
It's a soft-spoken man.
Yeah, just talk a little louder, Mr. Norris.
Oh, now.
Here it went.
Play like you're an auctioneer, get right into that. Eat that microphone.
But anyway, I got out of the business a few years ago, tried to take early retirement, didn't work out very well because the economy has not done all that well in our area. I did general real estate for a short period of time and got out of that as well. But I want to get back in the business if I'm allowed to. And I'm sorry I did what I did. I did it. I know it was wrong. I did not benefit from it in the long term. I'd say, if anything, it cost me thousands of dollars, and I deserve everything I get. But if the board sees fit, I would love to be relicensed and get back into the workplace.
What was the problem with the Florida incident that caused you to want to sweep that under the rug so badly, and you never did disclose it?
I don't remember all the details, but I was back in Tennessee in early 96. A developer moved me back to Tennessee to work for him. And I didn't know my license had been revoked because I had lived in their quarters for a while. I'd moved a couple of times, and I guess it got lost in the mail or whatever, but I never got the thing that it had been revoked. I knew I'd done the situation, but I didn't know my license had been revoked or anything like that. I thought it would just expire when it expired. So when I answered those questions, she said I didn't say I'd ever had an out-of-state license. I don't remember doing that, I know I said I never had a license revoked, though I do remember that very well. And I didn't know I'd had a license revoked at that time. It had never been an issue until that come up. And I'm not saying I didn't have a Florida license. I had a Florida license for about 5 years, I guess. I went down there in 93 and came back in 96. And I worked for Marriott and Orange Lake Country Club while I was down there. I just made a bad decision. And through the years, the 20-something years I was in the timeshare business, it was very good to me, and I'd just like to get back in it if I can.
Commissioner Grease.
Mr. Chairman, we've already heard about one timeshare salesperson. The difference, I think, here is we don't have a conviction or a felony we're dealing with.
I've never had any issues.
Right. But I would like to ask Mr. Musgrove the same two questions I asked the broker for other timeshare salesperson. What do you anticipate Mr. Norris's role is going to be?
Roger, at this point, would be a salesperson for me. I've known him for over 20 years. He has worked for me in the past. He definitely made a mistake, but his reputation in the timeshare industry is very, very good, and I'd like to have him back working for me as a sales representative.
And how many brokers, how many agents do you supervise?
It will vary depending on the time of year, anywhere from about 8 to about 15.
So here's my other question, not related. Errors and omissions insurance, how does your company handle that?
With us, each individual carries their own through the state.
So it's
and they all expire at the same time. Everybody had to renew by the end of December. They all know it.
Sir, I actually got an email from Rice about mine. Mine expired in December, and I haven't renewed it until I get my license back.
But referring to your earlier conversation, I actually read part of that bill yesterday, and the way we stand now, everybody knows when their insurance expires. It's all on the same timetable.
The problem apparently is not the 80%, it's the 20%, and you're in the 80%, so I know you're good. Mr. Chairman, I'll make a motion to put something on the floor that this request be granted.
There's still discussion.
There'll be some discussion.
I just want to get a motion on the floor.
Commissioner Grease makes a motion, we grant this applicant be able to get his timeshare license, and it is seconded by Commissioner Collins. Now, discussion on the motion.
I don't totally understand. It says the commission heard your complaint and voted to issue a consent order for revocation of Mr. Norris's broker's license with payment of $1,500. Did you pay that?
No, I just voluntarily sent them back in before it was ever finalized.
Or the respondent could request a formal hearing that Mr. Norris requested a formal hearing. Notice of the hearing and the charges were sent to Mr. Norris, and it was scheduled. Okay, and then 10-1, final order, but you never came before us on...
Just phone calls. I think 1 or 2 phone calls is all I ever did at that time.
And maybe I don't understand totally what went on, but it seems like that needs to be resolved first.
Mr. Norris, there was an effort to have an informal conference between with the attorney and one commissioner with Mr. Norris. That never came to pass for a variety of circumstances. I think they did have a phone conversation, but and then after the phone conversation, there was a commission meeting in August of 2009 or 2008, and it was at that point that the commission made a decision to issue that consent order for the payment of a sum of money and revocation of his license. And Mr. Norris requested that he be given a formal hearing. The formal hearing was scheduled for 10 of 2009. So, the notice of hearing and charges went out in June or July, and it was scheduled for 10 of 2009. Prior to that, really in September of 2009, Mr. Norris actually, reached an agreement, and the final order was the outcome of that, in which he agreed to surrender his license at that time. And the commission said, okay, if you surrender your license, then we'll take no further action against you at this time. And so that's what he did, and the formal hearing was never took place because he reached an agreement that the commission approved, and that was the end of that situation.
Well, I wasn't on the commission at that time, but it seems that apparently a formal hearing was justified, and he just opted out of the formal hearing, and now he's back wanting his license, or wanting a timeshare license, which is a little different. I'm still not sure that complaint was not satisfied.
Well, for the stipulated part of the order is that respondent admits for the purpose of settling this complaint that the aforementioned acts and conduct of the respondent constitutes a violation, and it says that and it cites 6213-312. So in signing this agreed order and having the final order issued, that resolved that complaint that was against him. Much like we've seen some of the people who've been scheduled for formal hearings who reached some agreement prior to the formal hearing. That's what happened in Mr. Norris's situation, was that prior to the formal hearing, he said, okay, I'll surrender my license, and the commission accepted that in settlement for the complaint that had been filed.
But that complaint was just for the answering of no on his license application?
That is correct, because it was just for the answer that he gave that was incorrect.
Question I have, Ms. Maxwell, was there any cost and associated additional cost to the state as a result of setting up a formal hearing? And I mean, it never did really get that far, did it?
It was never held. And as I say, the final, the agreed order that was then referenced in the final order and is attached as a part of that says that the Tennessee Real Estate Commission shall seek no additional sanctions against the respondent by reason of the violations admitted herein. So when the final order issued based upon the agreed order, that settled the questions that might have arisen or that did arise in the course of that complaint. And it's just that the order was that he surrender his license, which he did. And so now he wants to get a timeshare license. That was a broker license that he surrendered because throughout the course of the years from 1983 forward, he's had both he's had a timeshare, an affiliate broker, and a broker license at different times. That was a broker license that he surrendered in 2009.
I'd like to, where, Mr. Norris, are you going to be working?
Treetops Resort in Gatlinburg.
Okay.
For Mr. Musgrove, which I worked there in my previous working career as well for several years.
Any more discussion on the motion on the floor to grant the timeshare license? Hearing none. All in favor say aye. Aye. Opposed, no. Motion carries.
Thank you.
Welcome back to Treetops. And let the record show that Commissioner Northern abstained, recused himself from any discussion and any vote. One abstention. Commissioner Northern. Five yes, 0 no, and 1 abstention. Good luck. Now, moving right along with our agenda. Our executive director's report, Ms. E. Maxwell. And Ms. Maxwell, before you start, I'd like to just let you know, this is sort of like being in a class. You're going to get 8 hours of continuing education being in here. I know everybody in here's got a cell phone. Leave it turned off. We have breaks. We all have telephones up here. Everybody up here is a realtor. And at breaks, we return phone calls and do our text messaging, whatever. So just wanted to let you know, you pay attention while you're in here. Yes, Commissioner Grease.
I've just noticed that in previous meetings, when people don't pay attention, there's a sense of this commission that maybe that person shouldn't get the credit they came to get in the first place.
That's right. We have that discretion. If we sense that you've just sat out there and played with your iPad the whole time you was here, we have the discretion of saying you don't get your 8 hours, and what you came here to do, we're not going to give you. So with that in mind, let's continue on, Ms. Maxwell.
The first thing on the Executive Director report is the complaint report, and the first sheet is the open complaint report by source, and that shows that this year, so far, we've received 228 complaints, and we received 30 in the last 30 days. We have 84 that are currently open complaints. And that's, are there any questions on that particular?
30 in the last 30 days?
Yes, we've had 30 in the last 30.
Is that a little high?
They seem to come in spurts. If you look through, like last year, I was looking at that last night, November and December of 2011, we had 43 come in. They seem to come in spurts for some reason.
58 in May, June.
Yeah, we had 58 in May, June. So it's hard to say what brings them in one. Sometimes we'll get like 6 or 7 on the internet in one day, and then we'll go for a long time without any. If you see the next page shows the number of dollars that we've gotten in thus far. And in February of this year, we got in $10,500 civil penalty dollars. For the entire fiscal year, July the 1st to the present time, we've gotten $162,967 in civil penalties that have been paid. Total last year, we had $273,662,000. Are there any questions about that page? The next page are the number of complaints that we have open or waiting for response that have been referred to legal. And you can see that we have 8 complaints that are currently in our part of the office that are waiting for a response. That means that they've been sent out by Connell, and we're waiting for the answer to come back from the individual. And after we get the answer, or 14 days, whichever occurs first, we'll send it up to legal, and the legal department will then handle it. And we have 76 that are in legal right now, so we have 84 total complaints. You can see if you look at the bottom, that shows you how many closed complaints we've had for the fiscal year 7/1 of 2012 to 6/30 of 2013. We've had 194 complaints that have been closed to date. We've had 2 revocations, 26 have been closed with a consent order, 6 with a letter of warning, 156 with no action, and 4 have been referred to outside agencies. Are there any questions about any of the complaint information? The other 2 items are the disciplinary action report information. The first is the payment of everyone, and then the other page breaks down the ones that were the result of an agreed citation. So we had 3 individuals who had agreed citations pay this month, and then the other were made up of civil penalties that were levied by the commission. Are there any questions about that? They're on here. And it's right, but they're on to complaints.
Oh, that's why. Okay.
Are there any questions about any of that? The next report is the licensing statistics, and those individuals who made a guess, an estimate.
I was getting ready to ask, yeah. Where we stand?
Where we would be. As of 2/28 of 13, we had 22,945 active licensees. Now, the person who came the closest, and I'm excluding Steve because he got to go last and had the benefit of information.
He don't count.
Cheated, in other words.
The winner depends on whether the commission wanted the person to be under the number or over the number, whether it's the person closest to the number who's under, or whether it doesn't matter if you're under or over, if you're just closest to the...
Closest.
I think it's just close.
Yeah, the one is the closest.
The one that's the closest? The one that's the closest is Commissioner DeChara. She had 23,120. Commissioner Haynes had 22,500.
Oh, no, I want it the other way.
That's why I asked you before.
I thought it was into March anyhow.
Well, anyhow, we got the book in.
220, yeah, so...
Can we share the prize?
We'll tear that certificate in two.
You were just like right at
What did Steve have?
115. He had 23,115.
Yeah, he was just going off of my guess.
And he guessed last, so that's why I sort of,
Just to share with
Reveal
the,
the other numbers, if you will.
what the other numbers?
Reveal the other numbers.
The other numbers were,
We got to have fun, too.
okay. The other numbers were, Bear had 22,235. Janet, 23,120. Michelle, 22,500. Isaac had 23,250. He was close as well. John, 23,347. Wendell had 22,035. Grover had 21,925. Austin had 1. And Dave deferred.
yeah, we did this what month? When
We
do
did this on 12/6 of 12.
Okay. What we're talking about up here, you probably wondering, you licensees back here, what in the devil are they talking about? December the 6th, a December meeting, we guessed how many total active licensees we would have as of February 28th, last week. And this is the numbers we're talking about. We've got 22,945. But 5 years ago, December the 31st, 5 years ago, we had 34,640. 34,640. As of last week, we've got 22,945. We're down about a third of total active licensees. But that's a good thing, because as all these people are getting out, there's more business for those of you who are still hanging in. Didn't mean to interrupt you, Ms. Maxwell, but...
Oh, no, that was fine. I knew that you all would be waiting to see who had...
Couldn't sleep last
With
night.
bated breath.
We'll do a certificate. Or if you think that it was a tie.
No.
And the over person. So the active number of licensees that we had of 228 was 22,945, and that was 15 less than we had the end of last month. Our inactive licensees went up by 7. We had 1,366. The retired licensees, 9,199, and that's 156 less than we had last month. We have 9 more individuals in broker release, so we have 574 in broker release. Our grand total is 34,084, and that's 155 less than last month. The firms, we have 3,919 active firms. That's 7 less than last month. 9 less retired firms. We have 267. So our total number of firms, 4,186, which is 16 less than last month. And our total of individuals who are affiliate brokers, and timeshare salespersons, and firms that are affiliated with those is 38,270, which is 171 less than we had last month. If you flip to the additional statistics, you can see how the numbers that we have this month compare to the numbers in past years of both individuals and firms, and then overall. So you can see that in 2009 we had 29,528 active licensees compared to the 22,945 that we have this month. And the total we had in '09 on 228 was 45,965 compared to the 34,004 that we have in this month. So that was a change of, that's a change of 11,961 individuals. From last year to this year, though, our number decrease has slowed down. Last year, we had just, we had 1,669 more licensees, firms, and individuals than we have this year. So the rate of decrease has slowed, and hopefully that's a good sign that it has. In firms, you can see that our change from 2008 to 2013 was 857. So we have 857 less firms today than we had this time in 2008. So that's a pretty significant drop in the number of firms. And our firm change from 2012 to today is 269. So that's less than some, but that's still a large drop in the number of firms that we have. Then the next page of additional statistics, you can see that the firms that through the years from 2008 to 2013, the number that have closed and the average per month. So you can see we had in 2011 we had 42 firms close in February, and this February we only had 14 close. So that's down. In 2011 we had 101 firms that closed in January and February alone. And this year, on January and February, we've only had 52. So the firm closures appears to have decreased quite a bit.
Mr. Chairman.
Commissioner Northern.
Ms. Maxwell.
Yes.
Would you explain the process of retiring a firm?
Will you just fill out a Truck 1 and retire it? I'm not sure why people do retire. Do you still have to pay the $80 for renewal every 2 years?
Well, the cost of retiring the firm is the same as an individual?
Yes, it is. And as I say,
the cost of maintaining that retirement is exactly the same?
It is. I think some people just want to keep their firm name, and they just want to keep their firm, and they retire it, because it is an expense that you have to maintain every 2 years.
Once that firm is, before that firm can be retired, the licensees affiliated with it have to be reassigned to other firms?
That is correct. They would have to be released to someone else or retire themselves. A lot of the firms that are retired seem to be one-person firms. Maybe they have another person, but normally they're small, like one person, maybe two people firms.
How many firms have you seen come out of retirement in the years that you've been here?
Probably less than 10 that I can think of off the top of my head. Not very many. I've seen more go out than come in. I mean, like just let their license expire or decide to voluntarily terminate both the person who retired and the firm, that they retired at the same time that they decided to voluntarily terminate both of those.
A couple more questions regarding the process. When they are reinstated, if they're not at the same address, do they go through that same process of getting code letters, et cetera?
Yes, they do. So it would be as if you...
so it's like you never had a firm to begin with?
Well, except you've got your name and you've already got your application. So really what you do is you file a Truck 1 to reactivate the license, and then you have the address, so that the address then has to have a zoning letter with it, so that you do have to file that. But, you don't have to file the entire application and pay the application fee. I mean, so that there is a benefit from that standpoint.
I appreciate you asking that question, Commissioner Northern. I didn't know the process either, bringing a firm out of retirement status and activating it and opening the doors again. Okay.
Let's see. If you look at the applications approved and exams taken, you can see that we had 324 people take the exam in February of this year, and we approved 225 applications for the issuance of licenses. The exams, we had more people take the exam this February than last, and more people take it in February than January. So there does seem to be an increase in activity in the taking of the examinations. We'll have to see if this continues on. The next, page 4, shows the total number of licensees that we have. And in this, for affiliate broker and timeshare, the reason this number differs is when I figure this number, I add in people who have bad checks and people who are in problem status. So I add in a couple of statuses that we don't reflect on the front page. So that's why this number of affiliate broker and timeshare is slightly larger than the one that you see on the front page. But when you look at our total number of all of the statuses that we have, the professional codes and statuses, we have 41,321 total licensees. This time last year, we had 43,209, and you can tell in 2009 at this time we had 53,825, and that was before the designated license came into being, so that's not reflected in the 2009 number. Are there any questions about any of the numbers at all?
I like the fact that the number sitting for their affiliate broker's license, I think the market is picking up some.
Yeah, it appears to be. I don't know. It appears to be.
I know somebody asked me a month or so ago, said, Bear, I saw him in a restaurant, he said, things are picking up, aren't they? I said, yeah. I said, it's sort of like, when you go from selling 20 houses a year 6 years ago, and all of a sudden now you're selling at the rate of 5 a year, and all of a sudden you realize you're selling at the rate of 6 a year. It's picked up a little.
I think everyone's working hard.
Hasn't picked up a lot,
Yeah,
but it
everybody's
is
working
getting a
hard.
little better.
I think it's tough. The next, just a brief update on E&O, since I know that we had a long discussion about it this morning. Just the current uninsured numbers. As of 3/5, we had 1,599 uninsured individuals, compared to in 2011 on 3/5 we had 711 uninsured individuals. Hopefully that number will drop considerably before the end of March. That's what our hope is. Rice, we show that they have 16,879 insured licensees. Rice's in-house number is 17,523. So that difference it must be accounted for by the fact that those haven't all been processed and downloaded, because what they have in-house, as I explained last month, is not always what they've actually processed and downloaded into our system. So they, as I say, show that they have 17,523. We show, as I said this morning, the alternate carriers at 6,072. And so the total that we show from our insurance report is 24,450. And the reason why that number is greater than our total active licensees is some people end up having both state insurance and an alternate carrier if they move to a firm where the alternate carrier has to, they have an alternate carrier in place they have to use, and so they end up frequently with two types of insurance. So that's why that number differs from time to time.
Could I ask a question?
Uh-huh.
So at the end of March, let's say it's 1,599 now, let's say it's 1,000 at the end of March that haven't got or provided proof of, insurance. At that point, do we file a complaint against each one of those individually, or how do you process it from that point?
We've requested the list from IS. We requested it last week, and we don't have it, of all the insured uninsured individuals, because we're going to generate a letter to them before the end of the month, to both the individuals who don't have it and to the principal brokers, naming individuals that they might have who remain uninsured. And Rice will send out an email as well. Then on the 30th, or somewhere after the 30th, we'll have IS run another complete list. And I mean, we're going to have Rice scrub this one, and we'll have Rice scrub that one. And then at that point, we'll either send out, and I think we'll have to get with the legal department and decide whether we send out another letter telling them, or whether a complaint is just generated. 2 years ago, I believe we just went straight and generated a complaint, and there was a concern that maybe not everyone had enough notice that they had to get an insurance. And so that'll be the determination that'll need to be made.
So will it be 2 complaints per uninsured person, broker and the licensee?
That is correct. Normally, the licensee complaints go out first. As we sort of work through the list, the licensee complaints go out first, and then the principal broker complaints go out, because we open the complaints in our office, and so Connell can only open so many a day. So it's sort of a process depending on how many there are, how long it takes to get them all put on the system and generate a letter out to them, a complaint out to them.
Will the complaint say pay $1,000 or you can have a hearing? Is that a summary of what the letter says?
Well, it's a complaint, but that's basically it'll reference the policy and the statute. And,
right.
It's a more formal affair, but that's basically what it says.
Make sure that's what it
right.
says.
And then if this law passes next year, how do you foresee that happening? We just send out revocations?
Well, if the statute passes as it is right now, it would become effective July the 1st of this year, so that starting July the 1st, we would be able to suspend people immediately who didn't have E&O as it came due. So say someone from Blue Green, they have a blanket policy, but say someone from Blue Green doesn't have insurance, then and theirs comes due in October, we could then immediately suspend all of those individuals. At the time they're suspended, a letter would be, someday might be generated by the system, but now it will be generated by hand in-house, but a letter would be sent to each one of those licensees who was suspended, telling them that they were suspended and that their suspension would basically be lifted when we get a certificate of insurance proving that they've got insurance. And so once we receive that, then the suspension would be reversed, as it were. And if it were in error, then it would be reversed and they'd be put back as if they were never suspended.
But there won't be any fines with that?
During that first 30-day period, the fines, according to the statute, the way it is drafted right now, they don't kick in until the 31st day. And hopefully, you don't really hope this from a standpoint of getting the letter out, but I'm guessing that a lot of it will cross in the mail. I mean, the letter will be sent, and the person, meanwhile, will be already sending us a certificate of insurance, so that you'll have that before they even get the letter. They will have sent us the certificate. And so, we did discuss during the course of this statute whether, do you wait a period of time for that to clear, to make sure that all the people have cleared and downloaded, and and that's probably something that we'll have to discuss with the state carrier, because you do want to make sure that everything's downloaded into our system on 1/1 or 1 whatever before you start suspending people. That it's not a matter of they've paid and it's sitting up there and at Rice's place of business, but you want to make sure that they've downloaded them all and that everyone who bought is credited in our system for having bought. But the main that problem we won't face really until the big push comes in on 1/1 of 15.
It would be based on the data that we get from Rice, or would it be based on an actual response from the licensee providing us proof?
Well, no,
or
the
not
rice,
providing us proof?
well, the rice would come into play, on, say on 1/1 of this year, of this past, 1/1 of 13. Rice's vendor, it had some problems, their third-party vendor that processes their credit cards, it had some issues on the, at the turn of the year. So as a result, Rice was behind, they were behind in getting the payments, and then they were behind in downloading them. So that it was, I think on February the 17th, we had our last payment or certificate from Rice downloaded that related back to 1/1. I mean, that really related back to someone who actually made a purchase on or about 1/1. So, if you have it, so you have to give some time for that to clear. 1 year Rice had a snowstorm and they didn't have any electricity. So, you want to make sure that if they get, I don't know, 12,000 in on 12/31, that we've given those time to get processed and downloaded into our system so that we on 1/1 don't send out 12,000 notices of suspension that really weren't, they were people who purchased. So that's sort of a logistic problem that we'll have to work out once 1/1 comes, and if we have the 1/1/15, if we have a new system, what it can do, and whether Rice is able to get those downloaded faster. We'll have to see how that works out so that we don't end up sending out suspension notices that are incorrect and suspending people incorrectly. Does that answer your question?
Yes and no. Technically, on March 1 or March 31, if we don't have it in our system, that person's E&O hasn't been considered and doesn't exist as far as we're concerned.
On 1/1 of January, like January 1/1?
No, on 3/1.
Oh, on 3/31. Right. Oh, okay.
If it's not in our system, according to our practices, they don't have E&O. But the lag time between it appearing in our system and them actually purchasing through Rice may be 2 weeks or whatever, but we have no knowledge at that point as to whether or not they're going to backdate it to January. Correct?
That is correct. I mean, because they backdate, you have to request it and you have to have had continuous coverage before they'll backdate it, and you have to sign that, what they call their reinstatement form, in order for them to backdate that. Rice, the statute requires if you have an alternate carrier that you have to give us proof, a certificate that shows proof of insurance. The state carrier downloads into our system so that when you purchase from the state carrier, you plan that it's been represented that they're going to download into our system. So on 3/31, we'll run a list on 3/31, but we'll send it to Rice to scrub and to make sure that we don't have a situation where someone purchased. And normally they get it downloaded much faster than that. There can be, with a vendor, when you have to go through that third-party vendor to take the credit card, there can be a 24 or 48-hour turnaround just with that vendor on the payment, before the payment shows up in the system, whether it's Rice's or, in this case, Rice's system. And so, there is a lag time before they might even see that the person paid for that. And just like us, they're going to wait to see, just like we do for renewals or anything like that, they're going to wait to see the payment in their account before they issue the policy. But we'll have that scrubbed, and we'll have it run, and then we'll get them to look at it to make sure that we've cleared everybody that they have in-house, so that we don't have a problem like some, last year letters went out that where people are, 2 years ago, where people already had insurance.
We have to actually input the data to create the suspension. The computer doesn't automatically do it.
Not the system that we have the computer system that we have currently, it cannot do that. Our hope is that the new one can both do that and generate the letter so that it would be just one process done by the computer. But RBS does not have the capability to do that. And it really cannot be programmed to do that at this time.
Means we're going to have RBS for the next 10 or 15 years.
Yeah, so, they say that we've been told that by 1/1 of 15, the new system will be in place. So hopefully it will be. Are there any other questions about E&O? This is a quick Arello update. Well, I also have something for Kelly. The Arello requests for the meeting in Scottsdale have run the course, and I think they've been approved by everybody now. Where's Kelly? Is that right?
It's kind of, you have to go through different approvers, or everybody's not on the same track. But Chairman Stevenson's is approved. Yours was just, I had to send back for a revision for just, because you're staying that night before. I have every confidence that it'll get approved now. Yours is approved, and Mr. McDonald's got stuck along the way, but now it's moving along too.
So I thought they'd all been.
I think we're good. That's what I'm saying.
I thought they'd all been approved last week, but they'd only gotten 2 of the hurdles, and there was one remaining hurdle to get through. So hopefully that will be finished later on today, maybe.
Yeah, I just checked it, and everything's. You did move along a step, yes. But I think it's going to be fine.
Yeah.
Yeah.
So that's the.
Oh, yay.
That's the Scottsdale trip. And the next trip will be the district, and the individuals who want to go on the district trip, that will have to be sent in late April. Well, no, really early April.
Oh, gosh. So.
Because that's June, early June.
So we should.
60 days, right.
Did we know who wants to go?
Mm-hmm. Grover and Janet, I think. Want to go on that. So that's just an update on that. The May meeting update. The May meeting was scheduled for Pickwick Lake. We got a contract from Pickwick Lake, and I've talked to an individual there, and Kelly has talked to one person, not the same person I talked to. It appears a number of things. We'll have to rent microphones and video equipment from a third party who lives in Mississippi, and that cost some additional monies. But the biggest problem that we appear to be encountering is that you cannot get a conference room if you don't commit to 20 rooms. We only have at most 13 people coming, maybe 14 people that are people that we could, individuals that we would commit to. We don't have 20 people. At 20 people, you can pay $250 for a conference room. At 30 people, you get it free. Below 20 people, you don't get a conference room at all, is what Kelly was told. There is a cancellation policy. You have to cancel 45 days in advance. So we couldn't just say that we had people that we didn't have. When I talked to the girl, she sort of, oh, yeah, the cancellation won't be a problem. When Kelly talked to another girl on Friday, she said, no, this is the cancellation policy. This is it. I mean, there's not any wavering of it. There's no change to it. Kelly has tried for 2 or 3 days to get in touch with the girl that I spoke with, and she's not returned Kelly's call. So we don't know where that stands, but the cancellation policy is obviously an issue, as is the question over the conference room, whether you really have to have these 20 committed rooms to get it. Certainly the contract does indicate that when you read it in light of what Kelly was told. The contract does have the cancellation information in it. So, right now we don't know exactly where that stands, but as I say, I think the 2 biggest hurdles are the cancellation in the conference room. The equipment, but the equipment we've got, mean, we got somebody who gave us a bid for that, as I say, who lives in Corinth, and that's $1,200.
$1,250.
$1,250.
And the only other thing is just the hotels.
Right, and there's then, besides the lodge there, the inn, there is a Hampton Inn, and that's the only other hotel in the area. That's $109 a night.
The lodge is operated by TDEC, right? It's operated by the state of Tennessee,
It is, but it doesn't seem to make
under
a
our state parks. And we're a state agency.
I know.
And they don't want to work with us. Something's wrong.
Administration told us to go with.
And we were told that's what we were supposed to do, use our state agencies. I think we need to get somebody else involved in this besides just you, Kelly, and somewhere up the chain, because that just sounds absurd to me. I don't know about the rest of you guys.
I agree, Kurt.
I know it is a little strange that I have an easier time getting county commission chambers where I don't know anybody.
Right.
You know.
And we're hoping,
And in most cases, the county commissions are honored to have us. And
yes.
Yet we're really being kicked around by a state agency. It's just not right. It's kind of counterintuitive. I mean, we want to use the state parks. It just makes no sense.
And I tried to
Ms.
call,
Maxwell.
I've tried to call her twice, and she's not returned my phone calls either. Because I really wanted to be able to tell y'all something.
Since this was an administrative initiative, has anyone at the administration been contacted to see if maybe this can be resolved so that we can move forward?
No, we were waiting to, we actually wanted to talk to the girl that I had talked to again, because these two girls told conflicting stories, to see whether or not, because this, what Kelly was told by the one girl, as I say, the girl that I spoke with, which is the same girl that you spoke with, said, oh, yeah, the cancellation, she kind of, oh, that won't be a problem. If you'll just tell people that they could stay here, that'll be fine. And then, as I say, Kelly talked to another girl there, and she told her something different. So before, and the contract does say the cancellation, it has the cancellation times in there. We wanted to see whether or not they're going to work with us before we said, oh, this is absolutely what they've drawn in the sand.
But the person who Kelly spoke with is the same lady that I spoke with?
Oh,
No.
it's her
It's a different-
assistant. She works, so she said
So
I
move
work
beyond
with
her to the lady that I spoke to.
I've spoken.
trying.
I've spoken to that lady. I spoke to her like a month and a half.
And you didn't get all of these roadblocks?
Well, she told me that I have the contract that I think you gave us, and so I asked her about the cancellation, and I asked her about the 20 rooms, and I told her, we need this conference room, and she said, oh, well, the 20, I said, we can't commit to 20 rooms, and she goes, oh, well, if you'll just tell people that we're available, that'll be okay. And then I asked her about the cancellation, and she was, well, yeah, that'll be okay. But see, we haven't actually tried to change the contract. So that, with what Kelly heard, it makes you wonder whether or not that really is accurate information.
Well, let's not talk to two different people. Let's stick with the lady who made the original commitment, who is the lady that you're speaking to.
That's who Kelly tried to talk to, and she hasn't returned her call in a couple of days. Yeah, she called her back.
Yeah.
Actually, she never sought out the other person. She sought out the person that you spoke with, Mary Jane. Mary Jane?
Mary Jane.
Mary Jane.
Yeah, but, it's this woman I talked to, she was speaking to me with certainty, I've...
I'd like you need to send a copy of that letter to the Commissioner of Parks, along with the Governor, so that people get their attention, because surely this one person is not going to dictate what this commission can meet there or not. Sound like you need to go higher.
I think the commissioner or assistant commissioner of insurance and the TDEC commissioner need to talk to each other, because if one tells them you need to do this, and then somebody else says that's in the office says, oh no, we can't do it that way, there is a big problem with communication.
Well, my biggest concern is just this having to have 20 rooms. Meeting room at all,
That concern is absurd.
Yeah.
We're a state commission meeting in a state park, and I don't care if we had 3 people there, we need to be able to have a conference room. It's just totally absurd.
Well, that's what we wanted to do, is to figure out, we wanted to make sure that we didn't tell someone that we were told something and then the other, we want to verify what we were, what the real policy is before we tell people that we've been told X, Y, and Z. I mean, if the other girl backs down, then we're good.
Something in writing.
Ms. Maxwell,
Yes.
it is 28 minutes till noon, and we're supposed to take a break for lunch at 11:30. We're 2 minutes past time. Let's continue this discussion after we come back from lunch, and we'll come back at 1 o'clock. But at this time, we stand in recess of this commission meeting, and we'll see you back here at 1 o'clock. We're back in session. Continue on, Ms. Maxwell, with the Executive Director report.
I guess, okay. I, at lunch, went and called Mary Jane Mills at Pickwick Landing. She had been out, and asked her to clarify a couple of those questions. And she said that if we, that normally they do not promise a conference room to anyone who doesn't have 20 reservations, and they don't reserve it till you have 20 reservations. But she said in our case that she would go ahead and reserve the conference room, a large enough conference room for us to hold our meeting. And I explained to her again that we wouldn't have 20 reservations. The most we would have would be 13 or 14, and that we would tell the licensees if they wanted to stay there that was available to them. And she said that would be fine if we did that. We will have to pay for the room if we don't have 20 reservations, but that we put in our meeting request budget in any way. She said that the cancellation, I told her that sometimes that we did have people who couldn't come at the last minute, and that sometimes if a hearing was canceled completely, that there was a continuance or a settlement, that maybe some of the people would go home without staying the next night. And she said that for the first night that there would be a 48-hour cancellation time period for each individual, and that because of a state policy, she would go ahead as soon as we send her the list, which we have to do in the next couple of weeks, she would go ahead and charge each person's credit card for that first night's fee, which is $75 base rate plus the taxes. It's about $80. And then the second night wouldn't be charged until you actually checked out of the facility. And that if we had to cancel the second night, that I said, it wouldn't be everyone, it would probably just be those people who live close by, but we would in all likelihood know ahead of time. But anyway, she said that would be okay too. So that, I'm going to make the changes to the contract and send it to me. And I said, I'll get it signed by the assistant commissioner, but you'll need to initial those changes and send it back. So hopefully that will all then work out, and I'll make the changes to clarify these things in the contract so that we don't end up in a situation that we would owe a lot of money or be committed to something that we can't commit to. So that should hopefully clarify those problems.
Thank you.
Yes, thank you.
So, are there any questions about that?
Now, you're going to be making reservations by the end of this month?
The contract that she actually sent had a date of 3/24. Is that to have it returned? So it'll be in the next. I'll have to make the changes that we talked about to the. She sent a printed form contract, and so.
Very quickly, how many sitting up here, the six of us, is not going to be at Pickwick Landing State Park for our May meeting? Anybody?
That's that Thursday and Friday, the 9th and 10th. May 9th and 10th, that Thursday and Friday.
I'm going to be at Paris Landing.
You'll be at Paris Landing?
I'll be at Pickwick.
I thought we were going to Pickwick. Okay, and I guess Flitcroft and I know Wendell will be there. And
I said, well, if we go ahead and give you a rooming list, and then someone at the last minute has something come up, then, or, at least with 48 hours notice, will you then return that money? And she said, yes, they would. So that money, as long as you're within that 48-hour window, they'll return that money back to your credit card. But I did, I said I'll tell the commissioners, make sure they all know that will be billed, that first night will be billed immediately to your credit card once we send in the rooming list. So it will appear, well before the meeting actually happens. So, as I say, hopefully that'll all work out well. Oh, is it 1:30? Gary Cordell just came in. Do you want to go, he's scheduled at 1:30. Do you want to go ahead and have him talk about the
Yes.
public service announcements? and
Before you
all?
call him up, I just wanted to thank you for your efforts and appreciate that you got it all worked out.
Oh, thank you. Let me just, I don't know if you all know Gary Cordell or not. He is the director of the Consumer Affairs Division, and he was with the Better Business Bureau. I'll let him tell you his history. But anyway, he was nice enough to, I had talked to him about, they do a lot of public service announcement and brochures, some of which I believe he brought with him today. And we had worked with him in the past on some timeshare issues. So I went and talked to him to get some ideas from him, and he was nice enough to offer to come and talk to the commission about some of the things that they've done in consumer affairs to actually reach the consumer. And as I say, I'll let him give you a longer history of his life. But
If you would, Mr. Gary Cordell, come on up, and you can...
He's got a guest, why don't we put him over here?
And then your guest also, yes, sir, just over at that podium. This is the first time that we have used this facility today.
Very nice.
So
Much
we're
nicer than the
we're
old
winging our way
one.
through it.
Okay. I'm Gary Cordell. I'm the Director of Consumer Affairs for the division within Commerce and Insurance. And with me is Kim Selstead, who's my Executive Assistant. And we brought some goodies for you to kind of hand out to you
Are we
to
allowed to
help
accept
explain
those?
some of the things we're going to be talking about. So,
Hey, I'm coming to get this bag of stuff.
and we got enough for the folks here if you'd like. Eve and I met last week and talked a little bit about some of the ways to get your message out. I know the Commission's wanting to look at consumer education involving some real estate issues, and I want to share a few of those of what we've done in the past, and maybe give you some ideas or tell you some avenues not to go down that may not be successful. A little bit of background on myself. I joined the Haslam administration back, it'll be 2 years later on this month. Come from the private sector, ran a holding company for about 18 years, Cherokee Equity Corporation. Cherokee Equity Corporation was a diversified holding company. We owned a real estate entity also, Cherokee Properties, owned a number of apartment complexes and held a lot of mortgage paper. Matter of fact, I wrote my master's thesis on the 86 Tax Reform Act and its effect on commercial real estate in Middle Tennessee. So got a little bit of a background in real estate, understand some of the issues you deal with. In addition to that, we owned a number of other companies, some banks. We were one of the founders of First American Bank, which I think it's Regions now. It's been sold and the like. But left there, kind of semi-retired at a younger age, and went to work for a venture capital firm as their chief operating officer, a firm called Clayton Associates, and spent 3 or 4 years there helping groom the son of the founder to be the CEO, and then thought I was going to semi-retire again, and did a little consulting, but just found that since I don't play golf, had a lot of time on my hand. And then was approached by the administration and the Attorney General to come and see what we could do to change things at Consumer Affairs. And it's been quite an adventure, and it's been very fulfilling because we've tried to make our area of government a little bit more user-friendly and more accessible to the public. In that 2 years, we've done everything from change our website. When I first came in, looked at the website for Consumer Affairs, and it was bland to say the least. Kind of reminded you of the old former Soviet Union, and some of the stuff that you'd see, it was all one color and real drab. But even a lot of the links, if you clicked on a link, it would take you to nowhere, and it would frustrate you if you were a consumer trying to get information. So we put a lot of changes in, and would encourage each of you to go to our website sometime. A lot of helpful information, a lot of consumer information on there that will educate you. some of the things that we've tried to do to get our message out, and by statute, we not only mediate complaints, and we're the clearinghouse for consumer complaints across the state, but we're also charged with educating the public through consumer education efforts. And we've tried a number of avenues to do that statewide. And as you know, most of you from all areas of the state, several media markets in Tennessee. And if you're trying to get free media, the competition's a lot tougher than it was years ago. There used to be a time when if you had a not-for-profit or if you had an organization and you had a message to get out, you could do public service announcements. And the TV stations and radio stations, they'd jump at an opportunity because they had to fill so much of their time with public service announcements to keep their license. Those days have gone, and now, we're, instead of having 3 TV stations, you have 4 major networks, but you have literally hundreds of TV channels that someone can watch and that compete for viewers, which makes it even more difficult to get free public service. I'm probably preaching to the choir when I tell you that there's different forms of media. There's paid media that you can buy through the ads that are on TV and radio and other forms of media. And then there's free media. Free media can be public service announcements if you're able to be successful at that. And it's also public speaking, having newspapers cover you when you go to different areas of the state if you have a message and things of that nature. Eve and I have discussed what might be a good method for this commission to deliver your message. Public service announcements, if you have a source within your own community, could be one area that you could get a message out. Just doing a public service announcement, whether it's on TV or radio, and then expecting the stations to run it is very difficult. Some of the public service announcements that you see are usually 3 o'clock in the morning or 5 o'clock in the morning when most people aren't watching. Where we've had some success, we've targeted certain media markets. We do events across the state, document shredding events for identity theft, where we invite folks to come out to an area, bring their old bank statements, old tax records and the like, and to drop them off in a safe atmosphere where they can be shredded free of charge at no cost to the taxpayers. We use funds that the Attorney General's office was successful in getting through court action that set aside consumer education funds that pay for some of the shredding events. Most recently, we partnered with the county sheriffs to expand it beyond a shredding event to have an expired prescription drug drop-off at the same time. So a consumer can come with 2 needs and drop off some old expired prescription drugs, keeps them from flushing them down the toilet and from those drugs going out into the waterways and hurting the environment. And you can drop off the shredded materials. Where we've had some success, it's been in the area of promoting a shredding event, say, in Jackson, Tennessee, where we've partnered with the sheriff's office and usually some elected officials, and we've got that market to say, all right, we'll help you sponsor this one event, and we'll do some public service announcements, and for maybe 2 weeks prior to the event, they'll run some public service announcements. Some of them are run at a pretty good time. Radio is a good source to do that. A lot of times they have a lot of time to fill on certain radio stations, and they'll run it every 15 minutes sometime. It depends on the market. Where you run into the danger of thinking that public service announcements might be the only way to get your message out is that you send them out statewide, and there'll be pockets of the state that never will hear the message. So one area that we found successful is printed materials, and we've given you some, probably handed out more than you would ever want. But we do a calendar every year, a consumer education calendar. This year, our theme was to not only talk about consumer issues, but to bring in a couple of other divisions from the Department of Commerce and Insurance and feature them for a page. We've had regulatory boards. They have a page in our new calendar. We have fire safety. I think October is their month. The Attorney General's office has a page, insurance has a page, and securities. Other than that, the rest of the calendar pages are made up of consumer information on how to avoid being scammed and the like. Last year's theme for the whole calendar was Don't Get Scammed in 2012, and each month when you pull it up, talked about a different scam and how to avoid it, and that was very successful. We distribute those through our legislative representatives, the local sheriff's departments. When I go out and speak to a Rotary Club or a civic group or a senior center, I bring a lot of calendars, and they love them because in this electronic age, you don't see a lot of printed calendars anymore. A lot of it's electronic, but we're still doing that, and we do it at no cost to the taxpayers because I pull it from my education fund. We are willing to help the Real Estate Commission if you have a message that you want to get out. Maybe we can help you with the funding on some of the consumer education. My advice to Eve was to maybe put together a brochure that is hitting on the issue that you're wanting to educate the populace about, and let us look at it, see if there's a way that we can help you get it printed, and maybe serve as a distribution arm to distribute it as we're going across the state. I'm on an initiative now to go and meet individually with each of the 95 county sheriffs across the state. To date, I've met with about 35, I guess. Is that right? And this partnership, I go and I spend about an hour with each sheriff in their office, tell them about consumer affairs, and talk about the partnership that we can link with them. A couple of things I ask them to do is, one, put a link on their website, their county website, the sheriff's website, to consumer affairs, because we deal with a lot of the same scams and the fraud issues that they deal with. Second thing is, I give them a lot of printed materials that they can hand out at neighborhood watch meetings. Third thing is that I want them to be able to call me on my personal cell or my direct number if they've got an issue of somebody scamming folks in their county, because we want to know about it. And then I ask for things in return. I ask that I get their personal cell number and their direct line, that I can pick up the phone, and if we hear that there's scam artists that have come in after, say, a natural disaster, tornado hits in upper East Tennessee, and you've got the storm chasers that come to town that want to get money up front to repair a roof or debris cleanup, and they take advantage of folks, and then they leave town without ever putting on the roof, or they do shoddy work. They're unlicensed a lot of times. I can pick up the phone and say, hey, we've got a report. Can you send a deputy out? And they're willing to do that, and they've done it on a number of occasions. In addition to that, on scams, we get a report for a scam, and we contact what we think is a legitimate business. The mail comes back. I can pick up the phone, call the sheriff. They send a deputy out, and they've got boots on the ground that tell us that's an empty lot. Well, we know it's a scam, and we don't have to go down the normal path of mediation. We get law enforcement involved. So those are a few of the methods that we use to try to get our message out. I'm all for consumer education, and you have a message if you're trying to warn folks, whether it's resale of real estate or just some of the pitfalls that folks are falling prey to. And there are a lot of real estate scams out there. We'd like to help you get that message out. And I'm here today through this long-winded diatribe that I've just gone through on scam artists to answer some of your questions on free media, if I can help in that way. Yes.
We've got three issues that I'd be good for your department to address, if you could. Is we have a lot of unlicensed people dealing in real estate, and it's really bad for the consumer. And also we have a lot of people that buy without disclosures, and which is a rule, and they just go out and buy, and also we need to get out the message that in Nashville's not a problem, but rural counties buying property without title opinion or title searches, it's really bad in some areas. And that's something I think we need to get out to the public.
Consumer education would be a great method to do that. And you'll find that, where are you from, Mr. Collins?
Pittsburgh, Tennessee.
Okay. I'm sure you have a newspaper there that would love to help you in getting the message out through that one media. You've probably got radio stations that would like to get that message out with you, too. Those forms of media on some of the more rural counties are very effective, because people listen to certain radio stations. They read the newspaper cover to cover sometimes, and
And by using those forms of media, it's very helpful. We, when I do public speaking, especially if I'm in town, if I'm doing a media tour, say after, say a storm hits, and you got folks that are wanting to have repairs done to their homes, when I meet with the media, and if I'm coming in after a storm, I usually get on 2 of the 3 TV stations in each area, or maybe the newspaper or radio. I encourage folks to go to our website or other websites within the state and click on to verify.tn.gov, which will verify a state license. Same thing, you can do that for real estate agents, and if we could get the word out for people to go to that website, and they could verify if somebody indeed had a real estate license. There's where consumer education could nip a lot of this at an early stage, and that's one method. The license activity, that's more, in the regulatory process, but there are ways to educate folks to watch out for those things. The real estate scams are out there, and they're nationwide. Some of them are from overseas. We see organized crime involved in a lot of, the timeshare take-back scams. I've yet to see very few legitimate, effective timeshare buyback operations. Most of them, they have really slick websites, and it might be a building, say, here in Nashville, Tennessee, that you recognize. To give you an example, we had some folks from Canada that filed a complaint with a company that they thought was on West End Avenue, main corridor here in Nashville, of a company that had told them that they could sell their high-end timeshare. They had to wire $20,000 to the company, and they were located in Mexico, and they'd have the closing, they'd send the money back. Well, we had 6 folks, different folks from different areas of Canada, that wired the money, and then they never hear another word. Well, we treated it like any other mediation process, and the way our complaint system works, we get a complaint, we send that complaint to the business, because there's 2 sides to every story. And then when the business replies, we can therefore mediate. On this one, the mail would come back. And then we had an old policy where we'd send it again. And the mail came back again. So we're getting these calls from these folks from Canada and thinking that there's a Tennessee business that has taken their money. And so I get one of our specialists in the car and say, let's just drive down to West End Avenue, see this building, we'll go talk to them. We pull down and drive up, and there's this beautiful building that I'd already seen on their website, and it's the Blue Cross Blue Shield building. So I'm thinking, hopefully Blue Cross is not involved in any way. Hopefully they're not leasing space to this. So I go in, talk to the executives there in the building. They assure me this company's never been there. So then I go a step further, having real estate background. I say, I want to meet your property manager, and I want to look at your records. And the property manager graciously shows me that this company's never been occupied in this area. So we knew that it was a scam. I immediately come back, contact the FBI, contact the Federal Trade Commission, a lot of our other partners on the federal and state level, and we knew that it was a scam. What they had been doing was they had a website that they took a photo of a nice building, and they photoshopped their name over the Blue Cross Blue Shield. So if somebody from outside the state of Tennessee, or even from West Tennessee or East Tennessee that doesn't know Nashville, they look at this building, they think, oh, that's a Nashville building. It's somebody I'm going to deal with. And they find out that it's a scam. We later got that website removed, but 4 or 5 others pop up after that. And it's an international operation, usually tied to organized crime, that's doing that. We've had conversations with officials with the Mexican banking system and the federales in Mexico. Our Attorney General's office has. But a lot of times when money's wired outside the United States, it's gone for good and you're not getting it back. But that was a way that, and we've linked with others to try to get the word out on timeshare scams. But knowing that these real estate scams, they can be international in the coverage that they're dealing with, but they're hitting people here in Tennessee. education's got to be the first line of defense in hopefully stopping some of this.
Mr. Chairman.
Mr. Northern.
We've had a number of unscrupulous licensees whose activities have cost consumers quite a few dollars, and we've referred those individuals' files to local attorney generals or departments of consumer affairs, DAs. And we've not had a lot of success in getting follow-up once we've sent the information over. It sounds like because of your position and because of your relationship throughout the state that you might act as a conduit to help us when we find ourselves in such a situation.
We do have a special relationship with the Tennessee Attorney General. The way that the consumer laws are on the books here in Tennessee, we oversee the Consumer Protection Act and its enforcement, and the education and other areas involving that. The enforcement actually comes from the Attorney General's office, and we work hand in hand with them. We see fraud a lot of times, and will not only involve our state Attorney General, but will involve either federal or local law enforcement. The Sheriff Alliance that we're establishing, and my goal is to meet with all 95 before my time runs out with serving, but it's been a great resource. In some counties, the sheriff may be able to help more so than, say, a district attorney. And I understand the district attorneys, they have a caseload that they have to prioritize just with funding and personnel, that some of the things that might seem minor to them but major to this committee may be not a priority like you would want it to be. We'd love to help you any way that we can in either our relationships and trying to get people to look closer at maybe prosecutions. If you have some prosecutions and they make the media, it's amazing. You send a message that goes beyond just to that one person that's paying the penalty for it, and that can be very effective. And that can usually be free media that you get a lot of coverage on.
One other question. What's the distribution on your calendar? If we were to put something in, how could we somehow meet our target audience?
Why don't we do this? Why don't next year we devote a page to the Real Estate Commission, and you can put whatever message you want to on there. Now, it won't go out to everyone. I'm not naive enough to think that our great calendar is going to go out to everybody in Tennessee, but we do hit areas that a lot of them are opinion makers that live across their elected officials, the media, and others, that if they read that, they may take the message a step further, and we'd be glad to commit to give a page. If you have a state real estate recognition month or something like that, that may be the month to do it, but we'd be glad to work with you on that.
Thank you.
Mr. Cordell, how many of these calendars, I like this calendar, how many do y'all have printed?
Ask Kim. She takes care of that stuff.
Oh, roughly.
6,000. About 5,000 or 6,000. I think we're going to have a reprint. It's been so successful this year. I had lunch with the sheriff from Shelby County. We've developed a great relationship. He was over to speak with me and the Madison County sheriff at the legislature yesterday. And he stayed over for some other meetings, and we had lunch today. We sent back 100 calendars to him to a high school that had requested them in Memphis, and he said, I'll just deliver them for you. We get a lot of requests, and I want to continue to get requests. The more that we can get out, along with our Don't Get Scammed brochures, which I think you have a copy of that, we have that in English and Spanish, the Don't Get Scammed brochure, and we've got a number of other publications that I brought just for you to look at to give you an idea if you want to have your own publications to hand out. But we can always order more calendars. Now, we're 3 months in to this year, so we get to a point where it doesn't make sense to give, you don't want to give a calendar out for 2013 in November. But, as long as we've just about depleted our supply, but we can reorder and get them printed rather quickly if there's a need for more of them. Next year, we'll order even more if we have partners that want to partner with us and we devote a page to their message.
Any other commissioners have any questions of Mr. Cordell while we got him here? It's obvious you like what you do.
I
mean, you can just see the excitement and enthusiasm.
Well, being in the private sector, you work for a paycheck and to try to build your net worth, and when you're blessed in that way, sometimes you get to a point where, there's an area of your life you can give back. It's great to be able to go home at night and say you've retained $20,000 from a senior citizen that thought they lost it forever in a say an investment scam, and you got that money back in their bank account. It's a great feeling, and there's a passion to that. Doesn't always work that way. You see a lot of heartbreak, but we've got a good team that last year alone we returned to consumers $5.1 million in goods and services through restitution through our mediation process. That's a pretty good feeling. And it's just the start. We want those numbers to continue to grow, but the way we're going to do that is to, first of all, let people know who Consumer Affairs is, where more people can either file complaints or contact us. And the more that we can do that, the more people we can help. And I'm grateful for the opportunity to come before a group that may not have ever heard of Consumer Affairs before I walked in the door. I hope when I leave you got a little bit better idea. Encourage you to go to our website. Encourage you to click on free credit report. If you think that you're immune from identity theft, you might be surprised. You pull up your credit report. Each of you, I'm preaching to the choir, you know already that you're allowed a free credit report from each of the 3 credit reporting agencies each year, and that's free of charge. Don't call any of the numbers or go to the websites of the commercials you see on TV because they're not free. The first thing they'll ask you for is a credit card, and it's because or a bank account number, because they want to charge you a monthly fee for some kind of report that they'll send you via email. But you can get a free credit report. And that's the first line of defense in identity theft. Check that credit report, see if somebody's opened up a credit card or bought a house in your name or bought a boat or whatever. And the sooner you discover that, the sooner you can get it cleaned up. But encourage each of you to do that. But please go to our website. You'll see a lot of links that are helpful. We have a lot of partnerships, and we want to partner with this commission to do what we can to educate consumers. So I know I've said a lot. Hope you've retained a little.
You said one word that got my attention, and that was restitution.
Yes.
We can't do that. But is there a way we can link with Consumer Affairs to make that happen for some of the people that we feel have been wronged?
The restitution
without going to the fund?
The restitution comes through the mediation process. The mediation process, the only flaw to it, it's voluntary. So good businesses will step forward if they've got an issue and they think that maybe it was just some salesperson that misrepresented, or maybe they think that we're getting ready to bring further action and they'll make whole the consumer. You get it on both sides, though. There's a story I share when I'm doing public speaking a lot of times to Rotary clubs or Lions clubs that it goes both ways. There was a consumer that filed a complaint not long after I took my office that bought a bag of cheese, and Kim's heard this story 100 times, but the cheese they bought were these little cheddar cheese wedges. I don't know if you've seen them in the dairy case, but these little blocks of cheddar cheese. Bought it at Walmart, filed a complaint saying that when he got to the bottom of the bag that there was mold on his cheddar cheese. So we process it like any complaint. We get some complaints that are in the tens of thousands of dollars, some that are for $1.98 for a bag of cheese. But he had an issue. We contacted Walmart. They immediately replied and said, we're going to give you 3 options. The consumer can bring the bag of cheese and his receipt to any Walmart. We'll give him his money back and a bag of cheese. Or if he just has the bag of cheese or the receipt, go to any Walmart. We'll do that. If he has neither, go to the Walmart that he went to, we'll contact the manager, ask for the manager, and we'll give him the bag of cheese and his money back. We sent the response back to the consumer. He writes back, no, that's not good enough. I want my time, which is 5 hours that I've spent on this process, reimbursed at $15 an hour. I want my mileage to and from Walmart, and that's for 2 trips, for buying the cheese to begin with and then coming back. And then I just want for pain and suffering another, $200 or $300. Well, we closed the file and wrote him back that no, they're not going to do that. No business can stay in business and go that far. The next time it's going to be someone that makes $300 an hour and someone that lives 400 miles away, and so you balance that out. My point is that sometimes you'll get a complaint that the consumer is not being reasonable, but the mediation process gets both parties together. It's only effective, though, if the business is willing to do it. If the business doesn't do that, we have other avenues. If it looks like it's something that they're doing it to a lot of consumers, we have the enforcement in the AG's office. We also have a buyer bewares list that we put on our website of companies that just refuse to even respond. And some of those companies are companies you want to stay away from. It doesn't say this is a terrible company. It just says buyer beware when you're dealing with this company that's on this site. So I don't know if there's something on your website as far as rogue agents that aren't licensed or
we don't have. We've talked about that. It's kind of like what you and I talked about. We sort of reached a point where I'm not sure we could just say that these are bad agents or agents beware when we don't have any charges against them or a complaint filed against them or have reached any final determination against those. And we do get some referrals from you all that I think you all have tried to work out and they haven't come to fruition in mediation. So we do get some of those, and if they work out, then I don't know that we get those referred to us. If you've already worked them out and the person got some restitution for those.
Eve, did we cover most of the things you and I talked about? I know I'm giving my message on consumer affairs, and I hope I haven't blurred anything that you wanted us to talk about.
No, I think that was. I hope that the commission found that helpful. I thought it was great because I think it gives us gives the commission some starting places to go.
Let us help you any way we can. I mean, it may start by just coming up with a brochure that you want to get out, and we can use that as a test, and hopefully we can help you through our education fund, maybe fund it and help distribute it because it is consumer education. Some of the other issues, continue to think about them, and we'd love to be a partner within the statutes of our powers of what we can do to help you, but we'd love to. I mean, these are our partners, not just because we're all under commerce and insurance, but because we see each other a lot of times daily, going in and out of the buildings. But Eve and her group has been very helpful to us on some of the timeshare issues, some of the real estate-related complaints that we get, and it's a great partnership, and we want to be a good partner.
I think you all do the Landlord-Tenant Act.
We do, and we've got some brochures on that, too. So
that's certainly an area where we overlap quite a bit. And property management is one of our big issues, so I think that's a great...
Do you have the landlord-tenant issue with you? Kim?
We brought a lot of things, probably to inundate you. We even brought you some ink pens if you want those, and anyone in the crowd. But,
we got your website on there.
Well, please pull
up
your
phone number, too.
And encourage us, and give us a call. We want to help you.
But as I said, I do think the landlord-tenant management, property management would probably be a good,
That's a good.
because you all do the enforcement for
And
that.
I actually have looked at that a couple of times on their website and printed some off for tenants. That would be a cool brochure for somebody that's getting ready to buy a house.
Right.
Make sure that your agent is licensed. Make sure your agent is this, and this. And we could come up with a nice list to do a brochure similar.
And I think the key is distribution for us, not just having it on our website because the consumers aren't necessarily going to go there, but to have a distribution network so you can actually reach the people who it would be beneficial for them to have that, like through the sheriffs and through the speaking, that you can actually hand that out where it's going to get into the neighborhoods. Because that's the hardest thing is getting into the neighborhoods, as you and I talked about, is actually reaching the neighborhoods where the people are who need the information. And I think, I really appreciate all
Could
that
the
you've
boards of
done.
realty be a resource for you on distribution also, or is that, do you try to?
Yes.
Okay, that might be a way of broadening the range of where you're distributing these, but senior centers, I do a lot of speaking. I spoke to a group in Jackson of about 150, maybe 200 seniors, and it's amazing. They read word for word of everything you get, and they share it with others, and it's, you talk about getting someone to deliver your message, it's very effective, and you better make sure you don't have any typos, because they will read every word and they'll let you know if you've got a typo, which is great. So what we do usually, we'll edit it, and before we do the final print, we'll send it out to a senior center and then see what happens. But
Have them read it.
Yeah.
Yeah, no.
well, it's been a pleasure. I know I've rambled a lot probably, but we do have a message that I'm very passionate about, and want to get it out and see what we can do to help others. So.
Mr. Cordell, it's Cordell, right?
Cordell. Yes.
I just want to say, Gary Cordell, thank you for coming and bringing your assistant Kim with you to enlighten us about what is going on with your department. We appreciate it, and I know, I take it to assume your office is over there in the tower.
They're right
We're
there.
on the 12th floor. The commissioner's on one end, I'm on the other.
They're here.
I got the
They're in
best
this
view of
one,
the
okay.
Capitol of anybody in the building. So
Okay.
Come up and see us sometime.
12th floor. Sometime we will.
Yeah. I think the Real Estate Commission's going to be over here, what, in a couple of months?
Well, when I went back at lunch, I just saw that we'd be moving the first part of May.
You'll love it over here. It's
So it's, that was sort of a surprise.
I mean, this room is indicative. It's clean, the air you breathe is a lot fresher.
Yeah, but thank you for coming and
Thank you very
introducing
much.
yourself to us and what you
Any
do.
questions, feel free to call me, or, even I, have meetings, from time to time, and we rely on her office a lot, and they do a good job, so, thank you.
Thank you, sir.
Did you have some more landlord-tenant bulletins?
If you've got them, leave them. I sure could use some. Leave as many as you want, because I'd love to give them out.
Yeah, now we know where you are, Mr. Cordell. We'll be up there.
Thank you, Gary.
Uh-huh.
Yeah, don't haul them back upstairs.
Y'all behave.
That's what the page of the calendar is.
What I've been doing is just running them off on my copy machine, but if I can get these, I'd much rather have those. I give them out to our tenants.
And one of the things I noticed this coming Saturday night is when daylight saving time starts. So,
Really?
Yeah, when you go to bed at Saturday night, move your clock forward an hour.
Forward, fall back.
Yep, I saw that in that calendar.
So do you want us to start trying to work on a brochure?
I think that would be nice.
Yeah.
That'd be a great idea.
Maybe, the states, I think each part of the state has probably different primary issues, although property management, I would say, probably runs throughout the
I
state.
think property management is probably one of our main focuses right now that we're having problems with across the state.
Well, this is excellent on property management, but also people operating without a license.
Right.
I'm amazed how many folks don't realize that you have to have a license to sell real estate for somebody else.
Yeah, I think a whole lot of people don't realize that.
And we could have several other things that would be included with that.
They don't have to go online to find out if they're legal. All they got to do is ask for their card.
Well, but see, people don't know that. They just don't know that. Somebody, and I know people are operating without a license in Davidson County right now, selling houses for somebody else, and they're buying on these weird contracts and then assigning the contracts, and there's lots of stuff going on that people just don't realize that is not the right way to do it.
Yeah,
Well, some of them realize it and do it anyway.
Well, that's true, but if there's a good brochure with the facts, like is done with this, at least, it's a beginning.
I can't pass this one up. You say they're using that a weird contract. What are they doing? Using that TAR contract? Okay.
No, they're using that weird one-page contract that you old folks use.
Continue right along. Anything else, Ms. Maxwell, you have on our May meeting? I think you covered everything, did you not?
After I talk back with the Ross, I got everything covered. I'll make the changes to the contract and then get it upstairs to sign it and then send it back to
You've
her to
got
get signed.
budget on our...
Well, I'm not finished with my...
No, she's not finished.
I thought you were asking if...
No, I was looking on the agenda, SOP.
For online transfers, there was a question last month about how the online transfers work, and the commission had asked Julie to draw up a policy that would recognize when the online transfer took effect. The idea behind it was that it would take effect once the individual had the confirmation printed out from the online transaction. And included in the iPad is sort of a brief overview of the standard operating procedure for this is just for the online transfer. And then there's an example of what comes through when the transfer confirmation is completed that we see that comes into our office via email. And that shows the affidavit that has to be signed by the principal broker. And the idea behind the online transfer was that, well, what the commission had originally talked about 2 or 3 years ago when when Commissioner Northern was chairman, was that maybe we could set up a system where the principal broker could go in and actually manage their firm, so that not only could you pay online, but you could also yourself move the individual licensees in or out of your firm. The system that got instituted just allowed for the payment online. And as I noted in the information that I wrote up, the payment does not go into our RBS system. So what happens is you pay online, and then the information that you entered and the payment that you made go to the third-party vendor. And then the third-party vendor transmits that information to us. We get an email that the transaction took place, and the cashier's office gets notification on their list of printouts that the money was paid. And then when we receive that information, the cashier's office has to enter the information and the money into the system and the preliminary information. And then once that's entered into the system, then we can enter the rest of it into the system for our end, check the E&O, and then the transfer would be complete on our system. But the individual would go to work when that confirmation that you all have an example of is printed out, which would be at the conclusion of the payment by the principal broker. So that was an effort to expedite that process, at least so that you would have a copy of that confirmation and you could go to work and change firms.
Mr. Chairman.
I like it. Commissioner Grease.
Just a couple questions. Now, last month, I think we talked about the paperwork in within 10 days. And this says 5 days.
Yeah, I thought first we had 10, and then we changed it to, when we very first talked about it, like a year and a half ago, it was 10 days, and then we compressed it to 5 business days.
And that's real estate commission business days, right?
Correct.
Not a real estate company's business days.
Correct. It's business days that would be recognized by the state.
Okay. Second, so I've gone in to do this, and I have to register before I can do it. Is that correct?
That is, you as principal broker have to register to, you're really just getting a ability to get into the system. As I noted in the written materials, you're not registering for anything else. Like what you're registering for truly is to go in and do this transaction. And that's really, it's not to give anybody else any access to your information. But yes, you do have to do that.
I've talked to brokers since last month, and they're very excited about it and appreciative that the Real Estate Commission recognizes this as an issue and has tried to solve it. And so, Mr. Chairman, I'll move that this SOP be approved as written.
Second.
We have a motion and a second that the Commission Policy Statement number 2013-CPS-001, effective date March 6, 2013, which is a policy on transfers of firm affiliation which are completed online. Any discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion passes, and the policy statement is approved.
Ms. Maxwell.
We talk about this at our seminars, but do make sure that people know about it, because Janet was the first person to use the system. That's her claim to fame, I guess, and that was that really was in July of last year. So it really people just, I guess, didn't know about it or didn't use it that much. And since then, as I say in here, we've had about 85 transactions. You can also change your home address, so there are people that do that. But as far as transfer transactions go, so do encourage people to use the system, because it does make it so that you can leave a place on a Thursday and go to work the next place on a Friday and not lose that weekend, which is, I think, really what concerned people previously.
Is this not perfect for our education director to put in a newsletter too?
It is, and we put it in a newsletter, but it's just, as I said, I think it's just kind of one of those things people
Might
read
do it
about it
again.
and they just don't, I don't know, maybe because it popped into your mind, I think, Janet, after you'd already done one transfer, and then it was the next time you transferred people in that you actually used it.
Yeah, I've used it several times, and it's the best way to do it and get everybody up and active quicker.
Right. So as I say, do please encourage people.
You're saying you might put it in the newsletter again?
Yeah, I think that would be a good idea.
It's been in the
Yeah.
last two editions, but I'll make sure.
Well, I think the big thing, Steve, is if they realize that it takes effect immediately once they print that receipt, more of them will probably be encouraged to use it if they realize that it's going to benefit to that extent, that you don't have to stop the practice for 8 days to get approved.
Well, one of the issues in my area has been that lag between, in time between the time that they send it in and when it's actually on the website here in Nashville. It might be good, and I'll make sure that they know of this, but it might be good if we could send a little note out to the TAR, to the associations or whatever, letting them know that it's now instantaneous and does not have that 10-day lag, because they won't transfer within the association's roster as well until it's on the website.
Now, ours will go ahead and transfer them in the association.
MAR will not. If
Okay.
it's not on the website, the transfer is not complete.
We send our Trek ones to the board office, and the board office goes ahead and transfers them in our association, so it's probably going to depend on the association itself. But I think Pug probably would be more than happy to put that in the TAR newsletter.
And then just tell them that they can send that confirmation into the association as well, so that'll show that they completed that transaction. And that maybe that'll give them further assurance, like MAR, give them further assurance. So we'll take care of that.
Mr. Norland,
Yes, sir.
you need to go down there and have a little prayer meeting with your MAR.
They're very good at following the rules.
Now,
Are there any other questions about that online transfer? If the budget is the next item, and you all have copies of the budget, I just didn't, if there are any questions, I can answer those. This is what is of 1/3/13 that we just got, and it's broken down and shows what our year-to-date revenue is, and then it shows what the Education Recovery Fund has and the some of the transactions that have transpired. And if there are any questions, I can answer those about the budget. Right now, we're really spent a little less than our projected amount, which is fine. I'm sure it'll catch up as the year goes on. Not so much less, so it's, but we are, I think we are doing a pretty good job of containing our costs. If there are no questions about that, the next issue was one that Commissioner Grease had brought up on, I'm not really sure co-branding is the proper name for it. That is a good name to call it on here, but it's really about a firm that, say, wants to start a property management or a commercial division. They want to continue to use their firm name, and then every now and again add the property management onto it, so that looks as if it's a different firm name, but it's really the same. Instead of, like Commissioner DeCharlo started a separate firm for a property management firm, so that she has two distinct firms. But some firms just want to add that tagline on every now and again. And Commissioner Grease had someone ask him about that particular issue, and we added some examples of a couple of firms that, what they had planned to do or wanted to do.
If there's a tab on your, what do you call these things? Tablet, iPad?
iPad.
Called co-branding, which is what we'll identify it with. And there's a photo. We can start with that. But I've got some other stuff I'd like to talk about. But I think overall, it appears to me it might be time for this commission to give direction to companies and to licensees within the company about what they can or can't do. At least in my area of the state, it's almost as if, in some cases, the company has said, just do whatever the heck you want to. We don't care. And I think it's about time we address that. So, on your iPad, there's a picture, and this broker knows I'm bringing this to your attention today. This is a 4x5 real estate sign. And all kinds of agents in Knoxville have called different people and said, that sign can't be legal. There's got to be something wrong with that sign. Well, there are a couple of things wrong with it. For instance, I think statute says that Chris Barnes' name, the letters can't be larger than the company's name.
All right.
Now, maybe this commission needs to tell licensees, including myself, what is the company's name here?
I don't have a clue.
I'm not sure.
Good question.
If I were looking at this, I would think that Barnes Commercial Real Estate is the company.
I'd say Real Executives probably would be.
So, just to make the point before we get into specifics of it, if our goal is to protect the public, then our direction to licensees and brokers ought to be make it clear who the company is the licensee is affiliated with. I mean, just for starters, that seems to me to be a fairly basic notion that we need to make sure people understand. I've got other examples, and we maybe over the next several months get into some different topics, but there are teams, and maybe Barnes Commercial Real Estate, Inc. is a team, but I don't think there's any license recorded in Tennessee for an entity called Barnes Commercial Real Estate, Inc. There's a license for Chris Barnes, and there's a firm license for Realty Executive Associates, and this is only as for an example. It's rampant in East Tennessee, where the individual licensees are basically, in my opinion, taking the firm license and using it to springboard off to try to self-identify inside that license. And it's co-branding might be the right term, but in some instances that I've seen, it's basically ignoring the firm and promoting the individual licensee. And so, if Mr. Chairman, if we have time, we just looked at this one sign for a second.
I wouldn't call this co-branding. I'd call this a violation of the statute.
Well, and perhaps we need to reflect in our minutes the sense of what the statute should say, or set up another SOP so that it's clear that this is confusing to the public, or at least it's confusing to this panel this morning when I ask you all the questions.
You got two different answers, who the company was.
In the written materials, there kind of goes through like some questions that one might ask when looking at a sign like that or similar signs about, does it indicate that it's a separate firm? Does it look like, would it be misleading to the average consumer? Would the average consumer think that these people work for a separate firm that's not licensed? I mean, as I say, there are a number of questions in the Rule 1260 that the advertising rule that applies by it, and I think we get asked a whole lot of questions about this particular issue. And, is it false or misleading or deceptive to the individuals if you omit certain facts or include facts that aren't part of the name, if you're not advertising the name that it's licensed with TREC?
Just as a history lesson for me, at one point I believe the rules of the Real Estate Commission said an agent couldn't advertise in letters larger than the company's name.
And that's still true.
I have a statute if you want me to read it.
But
Please.
let me ask this before you do it. Didn't it, at some point, the Real Estate Commission say that only applies to signage and not to other advertising?
That's what the statute says.
Okay, I'd love, and
Want me to read
I
the-
would love for you to, and then I'd like to know what the logic was behind that.
Okay. Well, the statute is Tennessee Code Annotated, Section 6213-310. Specifically, it is subsection B of that statute, and that states, licensees may not post signs on any property advertising themselves as real estate agents unless the firm's name appears on the signs in letters the same size or larger than those spelling out the name of the licensee.
All right, so in this particular case, Realty Executives is a franchise, and the actual company's name is Realty Executives Associates. Which letters would you think that applies to? The associates or to the logo of the...
Those letters.
It says the firm's name in here.
Agent. He's incorporated.
But that's not, and then his name is on there as well. Steve, do you or does some member of this commission know why the rules were changed to allow advertising larger than the company's name on other media?
I don't know why that was added and just it was just applied to the signs.
Some of that,
Go ahead.
did some of it have to do with people like these agents who are getting like moving vans and stuff and wanting their names larger on it? Was that some of it?
I honestly don't remember that we approved the agent's name being larger than the firm's name under any circumstance.
I can't.
I don't remember that.
I've been on here 8.5 years, and I don't recall that, but I mean, I ain't saying that I don't forget things sometimes, but I don't remember that.
Where is it in writing that we did that?
No, it's in the statute, so it was in the broker act. It appears that it was in the broker, it may have been here from 73. It looks like it's...
Last amended in 1990.
Right, so it's been...
A long time ago.
Yeah, a long time, and I don't even know if this was part of what was amended. but
I mean, we don't know that that's what was changed in 1990. That is just showing it's the most recent amendment to this
The
particular.
statute made reference to a particular type of sign. Did it not?
Post sign on any property, a licensee may not post sign on any property advertising themselves as real
So
estate
that's
agents.
a printed sign that's posted in some fashion. Has nothing to do with the internet. And we had the discussion about the internet, 6 years ago?
It wasn't that long ago.
Yeah. And again, I don't recall that there was ever any authorization for anyone's name to exceed the size of the firm's name
Any piece of advertising.
on any piece of advertising.
I know that there was a policy, and I don't know, it was a while ago, at one point, and it actually said if your principal broker agreed, you could have your agent name be larger than the firm name, and that's it was like an old policy, and it appears that it just fell by the wayside, so I don't even know what that was.
1990?
No, that's been since I've been in the business that was.
And I don't know what the reason behind that.
No, I'm not as old as you old people.
Grandmother.
Wendell had mentioned at one meeting, and so I went and I found the policy, but I couldn't find any information that said why it said that and what relation it was meant to have and why it changed that. So I don't know. I don't know.
I don't think we can have a policy that circumvents statute.
Well, but
So even if it is a policy, it's not a policy that was made, under the law.
Yeah, I don't think it's a policy anymore. I just think that at one point there was, and that may have been why it's no longer a policy. I just meant at one point that had become a policy, but then it's not a policy any longer. It just happens that I just meant a long time ago must have been some discussion about that particular issue, but I don't know what it's related to, and I can't find any information that gives a lot of insight. Wendell may know something about it, but it's no longer a policy. I just was saying that, that there was an attempt at one point to discuss that.
So the sign that Commissioner Grease brought to our attention would be in violation on any circumstance.
That one would be.
Am I correct?
Well, it's just because of the name. I'm more concerned about putting entities like the Collins Team Advantage or Barnes Commercial Real Estate Inc. that aren't licensed but seem to indicate that they're a piece of the real estate industry. That's what I'm concerned about. I got another concern I'll get to in a minute.
You know, you're talking about that particular thing about teams.
Teams, right.
I have had a problem with these teams for several years. If they gonna form a team, why don't they just get a firm license and have their own company? I mean, it is like you say, I'm glad you bring this to our attention because this has been confusing to me for a long time.
If we just take what I just gave to you, just for example, the second page, there's no company name on that page at all.
Well, if you look, I finally did find it. Number one agent in 2011 Keller Williams Farragut office is the only place you can finally find that.
I don't know if she's there now or not. Do you? That might have been back then.
And what is KW?
That's
Keller Williams.
No, but that's not but your point
That's
is.
not what they.
That's right.
There's nobody licensed
not what
under
they-
KW.
Yeah.
And if you go to-
Unless they have filed that. Eve, have they filed that as one of their business names, as KW?
No, the KW, when I looked at it, 3 weeks ago for somebody, and they had Keller Williams Commercial, Keller Williams, but they didn't have a K, just KW. As a matter of fact, we've had some questions about their sign, their new signage, because, they've gone to a new sort of logo with the KW, not very large, and usually the name of the licensee larger.
A lot of fines go out on that one.
Yeah, and they're going to love it because they probably spent a lot of money. We need to give them direction because people spend a lot of money on these signs.
They do. And I think part of what Commissioner Grease's question is it the words, the letters, or does it include your logo per se as well? I mean, just the letters inside, or does it include the entire logo that you can't have your name, larger than?
I can accept the fact that they're going to be groups. That's just a
It's gonna
practice.
happen.
Yeah, it's going to happen. So, not trying to police whether or not they're groups, but just like individuals, the groups should be allowed to put their names on the signs, but they still need to follow the rules. And if the statute says that it should not exceed the size of the firm's name, and the firm should be clearly identified, then it applies to groups just like it applies to individuals. Logos may be a different issue. That's not one that we've discussed before, but
Commissioner Northern, point of clarification, you're saying groups as in teams?
Teams, yeah.
Okay.
Yeah.
Yeah.
Teams.
Gangs. I'd say we're a gang, too. I'm not against the teams as such, but they ought to follow the rules. I agree with you.
Well, I'm not picking on this sign, but just because it's a good example.
Right.
Other than Chris Barnes' name being larger than the Realty Executive logo, size-wise, letters-wise, do you have a problem with Barnes Commercial Real Estate Inc. at the top of the sign?
I do. I don't know what that is.
Well,
And maybe that would be the same with a team, for that matter.
I took that to mean that he had incorporated himself for the activities that he conducts as a realtor, as a real licensee.
But would the public look at that and go, that's the firm?
Well, that's why I first said it was Barnes. Barnes was the entity and not executive because it's incorporated. But there is some confusion there.
And hopefully, at some point, the commission can give some direction, either by a policy statement or by the minutes of the meeting. Can I talk about one more issue with this sign? And it goes back to what he was talking about, companies that wanted to set up a property management firm. Within the firm, if you look at this very closely under Realty Executives Associates, it says Commercial Division. Now, do you assume that's a separate office, or what would you make, what assumption if you were the public with that name?
Well, I would assume they had a separate division.
Commercial office.
Would you assume that phone number took you to the commercial division?
I would, but that's probably his number. That was going to be my next question.
Well, that's an office phone number.
That is an office phone number.
That's an office phone number. That's an office phone number for realty executives.
However, the commercial division of realty executives is anybody that wants to be a commercial agent, any office they're working out of can say they're a commercial, part of the commercial division. Is that how you picture that?
Well, since we don't have license that say property management, commercial or residential, I don't know how we're going to differentiate it.
You differentiate because the name that's on record with the Real Estate Commission determines what your actual name should be on your sign, unless there's a DBA. And if it's Barnes Real Estate Management or Barnes Commercial Realty as assigned to the state, then that's the legal name of that firm.
Well, so on this one, Barnes Commercial Real Estate's not licensed with the state.
Oh, it's not.
No. Chris Barnes is individually, and Realty Executives is the firm licensed, but
Well, is Barnes Commercial Real Estate Incorporated name licensed with, not as a real estate? So it's not even incorporated?
no, it's,
I would take this to mean that he's got an LLC operating under
Well,
his activities as a licensee, which is not in keeping with the statute.
But the LLC would be licensed with the state. I mean, they would
With
have
the
it.
state, yes, but not with the commission.
yeah, it's not.
In this fashion, it's not.
And that's not part of our advertising guidelines. Just because he's an LLC registered with the state doesn't mean he can put down his real estate signs like that.
Well, we need to make that clear.
But, I mean, wait a minute. I mean, if somebody's incorporated, there's a difference between an LLC and a being incorporated.
That's right.
I mean, obviously, he has gone out and he's incorporated himself.
That may be true, but Realty Executives, when they cut him a commission check, can't cut it to
Barnes Commercial
Real Estate.
Right.
So he's not licensed, that entity is not licensed.
And it should be.
Or it shouldn't be on the sign, maybe. I don't know. That's what I'm trying to get some clarification on. Want at least to start to think about this issue.
We don't have to think about that. We already know that this is not a legal sign.
Because of the name of his size of his name, or?
For a lot of reasons.
Well, then let's be specific and let's incorporate them in the minutes. We'll at least have something to hang our hat on with some of these others.
Well, and somebody brought up a minute ago about the logo itself. If you look at Chris Barnes, and then you look at the size of the logo, his name is not bigger than the logo. His name is bigger than the letters inside the logo.
With regards to the Realty Executives logo?
Yes.
Okay. Does not the statute speak to the size of the lettering? Right, so that's not an issue. Your logo is...
But that's actually a logo, and that's what she was saying a while ago.
The
It doesn't
lettering
address...
in the logo is where we tie our hat.
Okay.
Everything that he's got exceeds the size of the lettering in the logo, which is the legal entity that we're talking about.
How many agents are incorporated like this? Are there many of them?
You can't, an individual licensee, has to be an individual, so they cannot have an LLC, nor can they have a corporate, I mean, they cannot be themselves incorporated or an LLC.
Well, what is he?
Well, I don't know.
Well, I know he's illegal in our terms, but is he, is that legal with the state terms? Does he have all the documents that you have to file to be incorporated?
Well, I mean, we don't, that's the...
I know we don't care, but...
You know, an LLC or corporation, that's done for the state, but as far as like an individual licensee in the state of Tennessee, that individual licensee cannot become an LLC or a corporation for the purposes of holding their license, because their license is held in the individual name.
And that's our first statement.
Right, and so so, you know, you can't be paid through a corporation, you can't advertise as a corporation, because you hold your license as, like Michelle Haynes, that's how you hold your license, and that's the way the individual licenses are issued. They're not issued in any other way. If you're going to any other way, you're going to have to be a firm and have, have a principal broker and do all the things that are required by 309.
Under the statute, you can be Haynes Realty, and you have a license issued in your name.
Right.
You cannot do business as Haynes Property Management
Incorporated.
because that's not it could be a legal entity, as according
As
to the
long as-
Secretary of State,
as long
but
as-
it's not recognized by the Real Estate Commission.
But I could do that, and if I had a firm license under that name, incorporated.
If you had a separate firm license.
Okay. So
Or
for him to, if he had
it
a
was a
separate...
part of the
Right.
original name that was submitted to the Real Estate Commission.
Right.
And you're doing a DBA as Haynes Realty.
Right.
We have had some good discussion. We have had some good thoughts presented. And does anybody have anything else to say about co-branding right now? John Grease, Commissioner Grease, because we're going to have a break here in just a second.
That's good. I don't necessarily want to get action today,
What's
but
our action step? Should we
but-
ask Julie to come back to us, or start a committee?
I would like for this commission at some point to be able to speak to signage issues and what's in the best interest of the public. And then, I'm still confused about whether we have latitude to give our interpretation about other advertising media. Do we or not?
You mean websites and internet?
Well, or Homes magazines or newspaper ads. Do we have, does the statute currently speak to that media as well?
Just that's
Isn't
part
that
of the
a print
statute.
media?
Yeah.
It's really done by rule, the advertising, there's advertising rule.
Advertising rule, but it doesn't speak to the font size issue. The only place where the font size issue is addressed is in that one statute. There is an advertising rule. There is also a code section that addresses, business locations, talks about somebody not being able to hold their license at more than one place. If there's, more than one place of business, you need a branch license for that. Some of these things are all issues that sort of come into play here, it sounds like.
Is there an advertising rule that says, and everything but yard signs, the agent's name can be larger with broker approval or anything like
It
that?
doesn't say it can, it just doesn't say it can't.
So, should this commission at some point, my question is, give licensees what we think the right answer is?
Would you like to propose something?
Not necessarily today, I'm just trying to get it on the table.
Let me throw out a suggestion.
We need an action step.
Our attorney has been sitting here listening to this discussion, and I wanted to ask her if, I know with all the other things on your plate, if pertaining to this particular issue that Commissioner Grease has brought up, advertising and signage and all that, if you could just pull out the statute, and for our meeting next month, just have a little handout to things that address these specific issues that's in our statute, so we can
Work on a plan moving
and
forward.
work on a plan moving forward. This is something that doesn't have to be done next week. But
What I'll do is, I'll look at this information, try to pull some of the relevant statutes, get something together so we can work toward the best way to move forward with making this clearer. I'm not promising a solution by next month, but I will have something pulled together so we can continue this maybe in a more organized list of concerns, because I think you've put some good ideas out there, and I'll work on that for next month.
I'd like to also say that Mr. Pugh is very well versed in this issue based on his historic involvement with this commission. And if I were you, I'd just assign it to him.
But anyway,
Ask him nicely. Will you help me?
do you have anything else in your report, Ms. Maxwell?
No, I think that's all that I have.
Or does anybody have any questions of Ms. Maxwell with her executive director's report? If not, then we're going to take about a 10-minute break, and we're going to come back, and we're going to go into Mr. McDonald's education report.
May I have your attention, please?
I'm just glad I know.
Yeah, I am too. I never.
Just go ahead and buy it.
Call the meeting back into session. Next thing on our agenda is our Educational Director, Mr. Steve McDonald, with his report.
To look over the education report, there's 31 items.
You need to scoot up, I can hear you.
Oh, my gut won't keep
Or
me.
turn it up.
Yeah, we got some hearing impaired commissioners up here.
Okay, how's this?
Good.
Okay. There's 31 courses for your review. There's 2 from discussion that have been deferred from last month, or we asked for them to reappear after the corrections and the suggestions. I think one of the 2 is a course that I think Commissioner DeChara took with her. But are there any questions with the first 31? I brought the material.
So I've got a question just on the very first one.
Yes, sir.
Okay, so the title of the course is Applying BOMA Standards for Commercial Space.
Yes.
And we're trying to approve the fire marshal from Davidson County or from Nashville Metro, and it looks like his topic is totally different than applying BOMA standards.
He is a speaker, and he's going to be speaking on subject matter.
It may be as simple as I think the course title is too restrictive.
We have a question what BOMA is.
First part of the day, Metro Codes, Bill Herbert is going to be speaking to zoning, land, BZA, jurisdictions, the appeals process, appeal rights, planning department problems, agricultural versus organic, and infill opportunities. Then, Fire Marshal Danny Hunt is going to speak about the 2012 IFC and other code changes to be implemented this year. It's my interpretation that the fire marshal is going to be speaking on behalf of how those changes affect commercial spaces.
I think it's all good. Maybe my question is the title.
Okay. The title of the seminar?
Yeah.
That is what the provider sends forth. Sometimes I shorten it just because of space, but that's Miss Kathy Reed from BOMA. That's how she titled the seminar.
Is there a date set for this by any chance?
Uh-huh.
Am I missing it?
Off the top of my head, I don't have that, but I'm looking for it.
You can email it to me if you want, because it's something I think I'd like to attend.
You can audit it for us.
Well, I have audited before. Yeah. Might just do that. This is.
I'll get you the date, Commissioner Haynes.
Yeah, it's Metro Nashville. Okay.
You want a motion to approve the first 31 items, Steve?
Yes, sir.
So moved.
I have a motion by Commissioner Grease to approve courses 1 through 31. Do I hear a second?
Second.
Second by Commissioner DeChara. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries.
Ones for discussion were ones that we just spoke about last month. One of them is a correspondence course that this provider put together herself, and she was requested not to send out the answers to licensees, that they in fact had to turn in their answers before she submitted credit on their behalf. And she sent along a letter stating that she would in fact set forth that policy with her courses, and she apologized for doing so in the past. The second course, M33 on your education report, is a core, and Commissioner DeChara had taken that with her, and it would be up to you if you felt that the material was strong enough for a TREC core, or if we needed to deny credit for that course.
Her core course, the only issue I have with it is the answer issues. Otherwise, there was some good material in that, and I think it was a good course, with that exception.
Okay. And I believe I sent the letter, and I think I asked you if that or if that was suitable. Okay. So for courses M32 and M33, how would you like me to proceed?
Anybody have any further questions of Mr. McDonald on courses 32 and 33?
Move their approval.
Commissioner Northern makes a motion we approve 32 and 33, and Commissioner Collins second the motion. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries. 2 courses are approved.
The quest for instructor approval, we have one provider, Randall Bedwell of Real Estate Leadership Schools. Provider 1459 requests the approval of Jack Jernigan to teach Builders Are From Mars, Realtors Are From Venus. That's course approved number 6775. And Eva Angelina to teach Value Proposition as a new home buyer rep. That is approved course 6925. Jack Jernigan holds a Tennessee license, that's license number 300555, and has been licensed since 2005. He holds the ABR, ASP, ePro, CRCS, MMDC, SMP, and SRES designations. He earned a BS in accounting and has a master's degree in religious studies. The second individual, Miss Eva Angelina, holds Tennessee broker license 325556 and was first licensed in California in 2005. She's a former high school English teacher. She's a PhD candidate in 2017 in counseling and holds a GRI and the SRES designation. It would appear based on the resumes submitted for the course types that they'll be teaching that these 2 individuals do in fact meet the qualifications for the courses.
Motion to approve.
Second.
Commissioner DeShar makes a motion we approve these 2 individuals, and it's second by Commissioner Collins. Any discussion?
I just have a quick question. We can vote, and I'll ask Steve afterwards. If you'd like to go ahead and vote.
No discussion. All in favor say aye. Opposed, no. 2 individuals are approved. Commissioner Grease.
Steve, do you know what those acronyms, all those stand for?
The majority of them are. Some of them I have to think in the house.
Like a CRCS. Can you help me with that one?
Certified Residential. Let me look up Mr. Jernigan's.
Well, while you're at it, MMDC would be a good one too. SNP.
I think
He just liked those letters, John.
I know. I think sometimes people just put them in there.
I was thinking that same thing, Commissioner Grease, but I wasn't going to ask him.
I was hoping that some of my fellow individuals would know.
Well, there were some of them that were a little unusual.
The reason I was afraid to ask what they were, I figured everyone of you knew what they meant, and I'd be the only one who didn't.
I was hoping that my TAR folks would know. I will look those up for you, and I'll get those to you.
Tell them that we approved them, but they left some of the letters of the alphabet out.
I will.
There isn't a Z in there anywhere.
Which one specifically would you like to know about?
I want CRCS, MMDC, SNP.
Alphabet soup.
I can tell you ABR.
Yes. Do that one.
And ASP, did I say that one? Might as well get that one while you're at it, too.
As soon as possible.
Thank you, sir.
Okay, the next item, either on your iPad or tab, I'm not sure what you have in front of you, is discussion on Tennessee Code Annotated 6213-324. There are some questions that I wanted to get an answer regarding. Whenever we receive into the commission office an instructor request for a course, my action plan is to pull everyone's license that is licensed in Tennessee, and I always check to ensure that there are no disciplinary actions, that their license is in a renewable state. Is it, meaning, is it active, is it retired? An expired or broker release is a non-renewable status. Also, I receive folks' law cards if they're a member of the bar. I do check as presented, I do check their qualifications and try to match it up with what's provided. In 6213-324, A4, the code reads, if the course concerns the principles of real estate, mathematics, or sales techniques, is a licensed broker or with the approval of the commission, an affiliate broker with at least 5 years of experience in the subject of the course, that individual is eligible for approval by the commission to teach. My question is, what is the commission's take on a licensed broker? The situation that came to came to head was before I discovered that an instructor was actually licensed in another state. They're licensed in Tennessee. This person lives in Tennessee. This person that I personally know, and many of you do know, did not have a license. That license was expired. So with this, the question was raised, licensed broker. If it's licensed in any state, then there's no issue, I understand. Or are we speaking to this state, the state of Tennessee?
There is an issue. It's like if somebody said, I violated a crime in Tennessee, in real estate, you say, you have your broker's license? You said, oh, no, I've got them in Florida. Well, the rule means Tennessee real estate license, and that's what they're teaching people in Tennessee. And I don't think you can stretch this or smooth it over anyway and talk about it any other way. They need to be broker licensed in Tennessee. It's the way I feel about it.
Well, we have Arello approved courses that may not.
We have a lot of instructors that teach courses in Tennessee that may or may not hold a license in Tennessee. So I just need to know.
We talked about that before too.
Okay.
We made those exceptions if they were Arello approved. Okay. I believe 2 years ago.
With the IDAC certification.
Right.
Okay. And when you say licensed, are we speaking held a license, hold a license? Is it a renewable license? Help me understand this so I know in the future.
Well, I mean, and this is just a personal opinion, but I feel like an active license is what we're looking at, because if you say an expired license, they could have been expired for 25 years. And they
retired. That it's in good standing, it's retired.
That could be the same thing. They could be retired for 25 years. I don't think they're keeping up with active real estate practices if they've been retired or have an expired license. And if they want to teach bad enough, it's not going to hurt them to pay $80 every 2 years to keep an active real estate license.
I second that.
So do we need to change 4 to say active Tennessee licensed broker?
That's a statute. So
it's a statute. We can't change it. We can't
It's a statute, and, the way this is worded, and you all are certainly welcome to interpret this any way you want. The way that this statute is worded right now, there could be a challenge to this because it just says is a licensed broker. It doesn't say of this state. And while that may be the intent, just be aware there is a likelihood someone could challenge that.
I think we're trying to stretch it.
Well, I don't have as much of a problem with them being licensed in another state as I do them not having an active license. I have more of a problem with them having a retired or expired license than I do if they hold an active license, because I know a lot of the instructors that teach your GRI courses and your CRS courses and all those courses may be licensed in Texas or California or somewhere else, but they still teach all over the country.
And you're okay with that, right?
I'm okay with that. I just think they need an active license.
my other question is sales techniques. What constitute a course in sales techniques? Unfortunately, to me, that it's very broad.
Well, it is broad.
I think it's meant to be that way, so it can be probably interpreted based on the individual courses. Would you? I think restricting that definition could be problematic.
I agree with that.
Okay. Sales techniques can be contract classes. They can be how to list properties. They can be marketing. sales techniques, a lot of stuff can fall under that category.
The other question was the next number 5. If the course concerns the law of real estate, has graduated from a law school accredited by the American Bar Association or approved by the State Board of Law Examiners. And this is where I'm going to defer to Ms. Kropp on number 5.
And that's the one I have the issue with.
I mean, unfortunately here, I think that these courses are all varying far. I mean, to assign a definition to this is going to create problems. It's going to be a case-by-case issue of these courses and what they offer, because there's so much overlap in teaching real estate issues and overlapping with issues that also touch the law. I think there's going to be a lot of push-pull here, and it's going to be dependent upon the circumstances and the details of the individual courses. I think it's going to be hard to set that in stone.
Well, I personally feel like that if you're teaching a class on contracts, or even our core class, where you're discussing law, you're actually teaching law, and you don't have a law degree.
So, you want to know whether we ought to just leave it alone, or do you want us to try to refine it a little bit?
And I have
interpretation.
Steve, I was getting ready to say, what has transpired to cause you to bring this to our attention?
Well, going backwards, number 5 we had talked about, I believe, last month or the month before. That's been a recent topic of conversation. Number 4, through the discovery of an instructor, as I go through the action steps of checking to see if they're qualified, getting their report prepared to present here, I had the issue where there was a Tennessee license that was expired, but another state license was active and in good standing, and I wanted to make sure that I was following the interpretation of 62.13.324A4 and not doing something incorrectly.
What did Ms. Kropp, Julie, what's your interpretation?
As far as the terminology for licensed broker?
Yeah, I mean, for his situation he was talking about.
I mean, it purely states licensed broker. It does not say licensed in this state. It's I believe it's something that it could be challenged if it was restricted to licensed in this state, because the statute just states licensed broker.
You could be a licensed broker in a state that didn't even have any kind of law. Like in Mississippi, you don't even have to have an auctioneer license. But you can get your auctioneer license down there just by doing anything.
Is it so broad that it could be a licensed stockbroker?
Well, I think that would be much more of a push, but I mean, it does say licensed broker. I mean,
Oh, you got your direction, huh, Steve?
The interpretation's a little fuzzy.
I would say, just from my personal point of view, you've got the latitude to make recommendations, and if you think one of them's a red flag, you ought to tell us, but I don't know that we can, I don't think we can force you into a small pocket right now.
Charles had a good friend that wanted to teach one time, and he'd lost his license, and we turned him down. You all remember that?
Yes.
He taught in Gallatin over there, and he lost his license. I mean, he just retired him. He's a great teacher, great man, good friend of his. You remember that?
Yes, I do. But it says active license. I mean, it does say is a licensed broker, so...
So that means if somebody's selling real estate here in Tennessee that's got Florida license, they're okay. That's what you're saying.
No, that's not what it says. It says it's a licensed broker. It don't say they can sell real estate in Tennessee.
Well, they can teach it,
Teach
okay.
in Tennessee.
Oh, without knowing the Tennessee rules.
Well, according to the way that law's written, you can.
Doesn't say real estate broker.
Okay.
All right.
Well, the last things that I would,
It does just mean that they're eligible for approval if they have
Yeah,
this.
that's true.
So it'd have to come before us.
I mean, it doesn't mean that they're approved if they do it. It just means they're eligible for approval if they are a licensed broker. You know, I mean, that's,
But in applying the rules across the board equitably, we might have issues if we denied someone, an individual, who did not have a state broker's license, yet we approve others who do not have a state broker's license. They could raise issue with that.
Discrimination?
I think they'd have to have a basis for it, but yeah, I mean, it just, the statute as written just says licensed broker. It doesn't say licensed broker within this state, so.
If we're going to leave it open to interpretation, we should apply the rules equitably across the board and not do it based on personalities or anything else.
Well, I don't think we do base it on personality.
I'm not saying that
or anything.
we are. I'm talking about with regards to that, the way that's worded. We either accept it for face value or we try to change it.
I make a motion, we discuss it next month.
Think about it for a month, and we'll talk about it some more next month, huh? That's your motion?
What's there to talk about? I mean, I think that, I thought the direction was, it's kind of wide open, and staff would have the latitude to look at it on at least a preliminary basis and advise us if they had a problem or not.
I think that's what they're doing.
And so what, is there anything different we ought to do than that?
Well, think about it.
I'll think about it. Do you want it back on the agenda next month?
It's me.
Steve, are you okay with discussion and how we want you to move forward?
Yes, sir.
Okay, good. What's next?
This concludes my education report. I will tell you our seminars begin next month in Cleveland, Tennessee, and the Great Smoky Mountain Association of Realtors. For those in attendance today, I know you're hearing my back to you. I apologize for that, but you can earn 2 hours of complimentary education by attending a 2-hour seminar across the state. That seminar schedule is posted on the TREC website. You're more than welcome to attend. Please call those association offices to make sure that seats are available for you. The first hour will talk about TREC updates. The second hour will talk about the E&O policy.
Excuse me, go ahead, Commissioner Grace.
Did you send us something about SRES designation, whether that class should be approved by the state?
Those courses are approved. It was a sales technique question, and I think we've already addressed
Okay,
it.
I thought they were related. Okay, thank you.
Have you scheduled Knoxville's?
I did not.
You haven't scheduled it yet? Okay.
Would you like me to come to Knoxville? Typically, I was thinking that our commission meeting would give those individuals an opportunity, but I'd be more than happy to get with Jolynn and the new.
I enjoyed last year coming over to the Knoxville Association and sitting in on the seminar, but I can drive up to Gatlinburg and their Vision Forge and watch you up there.
Yeah, that would be
At that
hard.
one.
That'd be difficult for you to do, I know.
I know, I can get there. I know where it is. Commissioner Collins.
That's northern.
Northern, excuse me.
I just want to report that last month I participated in a PSI course review session, and it was for affiliates and brokers, and the session that I participated in was for brokers, and it was quite an eye-opener to see how detailed they are in preparing these tests and in preparing the questions for the test, and trying to make certain that it's they have a range of questions that's broad enough for everyone who's taking the test, so that, locale may not, it's probably not going to be an issue when you're dealing with real estate terms and actions, and it was quite an eye-opener, and based on what we were told, you will probably see a new test for brokers by the end of next year. And it will go through the Arello process as well.
Ms. Maxwell and I did that for timeshare, and that was a day that was
I would
a
not
long
want to
day.
do it for timeshare.
I did it for affiliate broker. It racks your brain to really try to think of the answers. I mean, really.
Broker I could
the
handle. I
questions.
would not want to do timeshare.
I have a random question.
Okay.
Might be a good time to
Mr.
bring it
Haynes?
up. Miss.
Miss Commissioner Haynes?
I noticed our book is 2008. How expensive is a publication of the new book, and considering everything that's gone on in the last 5 years, should we be looking at possibly getting another printing?
Steve and I met with the people from LexisNexis, was it last year, Steve?
Yes.
And asked them about ebooks, because that seemed like a good
Oh, I
thing
like that too.
to do.
But they don't make money off that.
That coupled with the fact that they then are going to charge each time they update it, so it wouldn't be like you could go in and just sort of update your book. The cost was, I have it back at the office, the cost was much, we had to get like 200 hard books. You had to get at least some hard books. So 200 was about the lowest minimum that you could get. And then they would give you ebooks. At the time, they were just coming into the ebooks and weren't really sure about it. They gave us a quote, and I have it back at the office. It was much higher than we thought. I want to say it was
127,000?
something. It was way higher than we thought it would be, and that was with an ebook. That was just with.
That's an ebook and 200 books?
Mm-hmm, and 200 books, and then the ebook would still cost the licensees. So that, at the time, we had no money. This was at the time last year when we had no money. And so that didn't really seem like we thought it was going to be a great, cheap alternative and not be very costly for the licensees.
Make money out of it somehow.
Well, so at the time, that didn't seem like a very good option. We should probably go back and ask them again this year. They've probably got the ebook down a little bit better. I mean, last year they honestly were just sort of getting into it. I mean, it took them, I think, 3 or 4 months to even get a price because they just hadn't really put them in production. And then it has to be done through MISHI's, LexisNexis and MISHI's, because MISHI has the contract for
with
the
the state.
statutory information.
Yeah.
Then so it comes out like every October, November, or December, sort of once the legislature finishes and all the bills become public laws, then they start working on the statutory information, which would then go into the manual. So it would be published, the ebooks would be updated depending on what their schedule was, October, November, December. And so when we were looking at it, we kind of thought, okay, we've also got to try to make it run with rules that we might have coming up so that we can try to get as much in it as we can. And we do our rules, some of the rules were effective the first part of 2 or 3 days ago that we just passed, that you all passed last year. And then the other ones have 3 months, 75 days to wait, 90 days to wait. So it might be a good idea to talk to LexisNexis again this year and see if maybe the prices come down some so that it's a more workable price. Because I think the ebooks, that way you could run them off and we would have them, they would have them that they could print if you wanted a hard book, or we could print more hard books. It was just we were trying to look at the lowest cost that we could get that would be the easiest to update for the licensees.
Well, if we expect people to study for the test and abide by the law, it needs to be available to them.
It does, and I mean, I agree. I think it does need to be available. And, while it's online and the updates are online, that's still not a perfect solution. They're not wed together there, and it would be much easier if you had it wed together for the people who are coming in to study, particularly. So we'll talk to LexisNexis again this year. I mean, call them and contact them and see if we can get another price. Maybe it'll be a better price that's more workable for the licensees as well.
The quote that you just mentioned, how many updates does that include?
This book?
No, the quote
Oh, the quote,
For the
that
e-book.
was through, that would have been, we talked to them, I want to say last July. We got a bid back from them maybe in October, but it would not have been published until the legislative session was finished for, well, it wouldn't have been published probably till January. So it would have included everything that occurred from, from time beginning to January of this year. I mean, that was about when they thought it would come out. As I say, it would come out when the statutory material comes out, since that's incorporated into that book. And that's kind of the, so that if you had rules that became effective, say the rules that became effective in March, they wouldn't put those in it. That's kind of a draw. I mean, that's kind of a disadvantage, because if we had control of it, we could do that. The problem is, of course, we don't have control of the statutory information. The other alternative is to do what some states do, and that's maybe just have a rule book, not with the statutory material, but just with the rules.
Do you recall how much it cost us to do this the last time we did it?
I have it back at the office. It was it was expensive, like 187. No, I think it was closer to 200,000, and we did it in two separate.
I remember you had Lexus.
But we got, what, 10,000 copies or something?
Oh my gosh, no, we got like 40,000 copies.
40,000.
The decision was made at the height of the market, and
Okay.
and by the
We had
time-
about 40-something thousand licensees.
Right.
So do we still have a lot of those copies?
Yes, but we just had somebody yesterday request a box. So we sent 2 years ago, Steve sent boxes to
So we
all
really don't
the-
want to get rid of, I mean, we want to be able to keep what till we get rid of them, and then that's the time to.
Well, we have a lot of boxes.
I think if my memory serves, it was like $4.10 a book.
It was, yeah, they were pretty expensive. That was the lowest price they would give us. I mean, we don't have, it's not like we can go out and bid it with a lot of other people. We have to bid it with the state contract. And they really, now she told us that they have a set price for the state, and it's not like we can negotiate with her. It's just, this is what we charge the state.
Last time it was like $2.60, and we cut the size of the page down.
Right.
Down to about $2.40 or something like
And
that.
and then we took out, I don't know, something, we rearranged something to get the page numbers down.
And they
Yeah.
cut a deal with you to have pink all over it.
Yes, I wanted it to be all pink, but they did put the shiny covers on for free, so that was an advantage. But it is something that we need to do, and as I say, the other alternative is to have just a book of the rules that's published that we can take control of, but we can't, as long as it has statutory material, we can't take control of it. It's got to be through MISHI's.
I'm pretty conservative. As long as we have a lot of books to give out, the book of rules might be the best way to do it.
And in the books that we give out, we do have our lovely pocket part, our copied portions of the new
Isaac
information.
and I were just playing with that.
But that's not really a great solution for people, because they lose it, it falls out, or it's problematic to look at it. So it would be better and we could do a book of rules that would not be as costly.
Addendum to the 208.
Right. But then as I say, we don't have the statute, and people probably want the whole thing together.
If you want to bring another box to me, I'll take another box home with me.
Okay, that's great. We'll do that.
I carried a box for our board twice.
You did, and Steve sent every board one or two boxes, and every time we go, we ask them if they want some more, and so far, no one's taken us up on the additional boxes.
We also gave them away as prizes by y'all.
We did.
You reckon we could give some to Consumer Affairs so they could pass them out?
Maybe they could do that as well.
During all this discussion, I think it leads us right into our legal report. Miss Julie Kropp, are you ready?
Is it lighting? Okay. Any consent order authorized by the Commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. The first matter on the legal report is 2012-022011. And without reading all of this, this was originally presented at the February 2013 meeting. At that point, the Commission voted to defer the matter for Commissioner DeChara's review at this meeting. She has not yet had the opportunity to review the full file, and therefore this will be deferred until next month's meeting for her to report at that 2, 3, and 4 are 2012-022-051, 2012-022-052, and 2012-022-081. This was originally presented at the February 2013 meeting. The complainant was a purchaser of a property who was represented by Respondent 2, an affiliate broker. Complainant alleges that Respondent 2 and Respondent 1, who was Respondent 2's principal broker, told Respondent at closing that certain repairs would be completed by a specified time and the repairs were not done. Respondent 3 is the same person as Respondent 1. Another complaint was open for failure to supervise. Complainant was purchasing a former vacation rental home, and complainant states that renters in the house were scheduled to stay past the closing date. As it turns out, complainant states that the tenants were out by closing date, but complainant alleges that Respondent 2 told the renters to get out. Complainant states that the closing was delayed by a few hours due to poor planning by Respondent 2. In the final walkthrough a few hours before closing, complainant states the complainant discovered that several items on the inspection report which were supposed to be repaired before closing had not been done, and those that were fixed were done by a handyman that complainant does not think was licensed and insured. Based on the documentation provided, it appears that complainant's list of repairs based on the inspection report was sent on the day before closing. Complainants attended the closing, and the seller and seller's agent were not present. Complainant states that complainant was going to refuse to close due to the repairs not being finished, but complainant states that Respondents 1 and 2 told complainant that they would have the original noted items repaired within a couple of days. Complainant signed a buyer's final inspection sheet which stated that certain repairs would be completed within a specified time period, and Respondent 2 signed the bottom of the sheet. For the seller, it was written not available. Complainant states that the repairs were not completed on time, that Respondent 2 assisted with repairs, and Respondents lied to complainant about what had been done. Respondents each submitted a response. Respondent 1 states that Respondent was unaware of the problems with the workmen hired by the seller after the closing to do repairs, but Respondent 1 had contacted complainant and a resolution had been reached regarding the repairs. Respondent 2 submitted a response denying that Respondent 2 told the renters to get out of the subject property, but instead Respondent 2 informed the rental manager to be sure that the renters were out by closing day, which was done. Further, Respondent 2 states that closing was delayed because complainant did not have a check ready for closing. Respondent states that the walkthrough was done just prior to closing. There was not time to have all of the repairs completed prior to closing due to renters in the property. During the closing, Respondent 2 states that complainant expressed that complainant was not sure that complainant wanted to continue and should have asked for more repairs. Respondent 2 states that respondents agreed to make sure that the repairs were made, but complainant continually kept asking for additional repairs. Respondent 2 states that Respondent 2 assisted with being sure that some of the agreed repairs were done after closing, and Respondent 2 understood that the repairman would complete the other exterior items. Respondent 2 denies that complainant was lied to and believes that respondents did everything possible to meet complainant's expectations. Complainant submitted an additional response confirming that complainant did come to an agreement with respondents to resolve the repair issues, but complainant stands by the allegations in the complaint. Based on the information within the file, there does not appear to be a violation by respondents. At that time, the recommendation was to dismiss, and the decision was that the Commission voted to defer the matter to allow Commissioner Grease to review the file and report at the next meeting, and so therefore Commissioner Grease is going to discuss briefly his findings.
I'm not sure of the protocol here. Can I make a recommendation, or can I state that I concur with staff's recommendation? Is that enough of a report?
Yes.
That's my report.
Your report is the same as what staff says, just to dismiss this complaint?
Yes.
Okay. You have
Move to accept Commissioner Grease's recommendation to dismiss.
We have a motion by Commissioner Northern and a second by Commissioner Haynes to take the recommendation of Commissioner Grease to dismiss. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no, and let the record show that Commissioner Grease abstained from the voting. Number 5.
Number 5, 2012-022-411. This is a Trek Open complaint based on respondents, principal brokers' failure to comply with the terms of a final order of the Commission. Specifically, respondent failed to pay the required civil penalty, failed to complete the specified continuing education, and failed to pay the court cost, all included as provisions of the final order. Respondent submitted a response which stated that respondent was forced to file personal and business bankruptcy shortly after the final order, and the fine was listed as an unsecured non-priority claim. Further, respondent stated that respondent attended the continuing education courses which were required by the final order. Legal counsel obtained information that respondent's personal bankruptcy was dismissed. Further, it appears that respondent did attend a 3-hour ethics course in April 2012 and a 3-hour ethics course in July 2012. However, the final order required that respondent take 8 hours of continuing education in contract writing and 8 hours of continuing education in ethics. Therefore, respondent did not complete the required amount of education, and the courses which respondent did take were not completed in a timely manner within 6 months of the final order. The recommendation is a consent order for voluntary revocation of respondent's license for violating the terms of any lawful order entered by the Commission in violation of Tennessee Code Annotated, Section 6213, 312B14.
Motion to accept council's recommendation.
Collins made a motion, we accept council's recommendation, which is consent order for voluntary revocation of license. Do I hear a second?
Second.
Second by Commissioner Haynes. Discussion.
Discussion.
Oh, I'm sorry, Michelle, go ahead.
You go first. Go ahead.
I'm just curious where it says, legal counsel obtained information that respondent's personal bankruptcy was dismissed. Does that mean it was granted, or that...
It was not discharged. It was dismissed, and therefore, those claims that were listed on there were not discharged, so...
Okay, he has agreed to a voluntary, or we're going to ask him to agree to a voluntary revocation. What if in 5 years he decides to get a license again?
You'll have to come back and see us.
Well, I mean, he would have to disclose on a further application that he had had something revoked, which I presume would then bring him before this commission for you all to consider him for...
As happened today?
Yes.
He would have to disclose that revocation on a new license application.
That answer your question, Commissioner Haynes?
Yeah, but it brings up more questions what I thought earlier, so that's all right. That answered my question.
Any other discussion on the motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 6.
I have a question for legal.
Okay, sir. Commissioner Orr.
Since Michelle brought it up, the wording in this morning's case said that the individual may have to come back before the commission. Should it not have said that he would have to come back in order to be considered for a license?
I didn't have the order, so I can't say it. It said, I mean, when we have an application, we have those 5 questions, one of which is whether a license has been revoked, suspended, things of that nature. When someone circles yes, typically the practice is that we review that information and they have to come in. It really would not necessarily have to state that in the consent order in order for us to bring that person back before.
Wouldn't it be more definite if the consent order said that they would have to come back, not may have to come back?
We can state that if you all would like for me to put that in the consent order.
The intent was to make certain that they came before this body to be reconsidered. And if you say may, that allows the possibility that it might not come before us.
Okay.
Okay.
So you would like for it to say that they must appear before the commission for... Okay.
Is everybody in agreement with what Commissioner Northern just discussed with legal?
Yes.
Good.
So we need that in the form of a motion, Mr. Chair?
I don't. Let me ask Ms. Crop. You don't need that in the form of a motion, do you?
I don't. I mean, I'm clear on what you need. If you all would like to make a motion just so we can put that into the minutes for this one, then that's...
So moved.
Second.
Commissioner Northern makes a motion that we put into the record, and second by Commissioner DeShara. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Number 6.
20120229091. Complainant is the former principal broker of Respondent, an affiliate broker. Complainant states that when Respondent notified Complainant that Respondent was transferring Respondent's license to another firm, Complainant withdrew several listings from the area MLS without Complainant's knowledge or consent. Complainant provided copies of change forms showing the MLS withdrawals. Complainant states that several of the withdrawn properties were owned by respondent and spouse. With regard to the other withdrawn properties, several change forms note the withdrawals were done per phone conversation with the owners. For one of the listings, which was a bank-owned property, complainant provided an email from respondent to the bank representative asking the representative's permission to withdraw the listing and move it to respondent's new firm, to which he responded that he wanted to cancel the listing and meet regarding a marketing plan. Complainant also points to an email from respondent to complainant which indicates in part that respondent's clients are moving with respondent. Respondent submitted a response which first stated that it was standard practice at the firm for all agents to go into the MLS to make any changes which were requested by sellers without getting permission by complainant. I'm sorry, that should say from complainant, permission from complainant. Respondent states that when respondent determined that respondent was moving firms, respondent felt that it was respondent's responsibility to contact the sellers, for which respondent was the designated agent, to inform them that respondent was moving and to explain to them that their contract was with the firm, and when respondent left, another agent with the firm would be appointed to take over their listings. With regard to the withdrawn listings, respondent addressed the situation for each. For two of the individual sellers, respondent states that when informing them of respondent's situation, both asked that their listings be withdrawn, as they no longer wanted the properties on the market and the properties were not listed with any firm, or not listed with any firm. This is at the point of the time when the complaint was filed. This was confirmed by conversation with both sellers. For one withdrawn property with an individual owner, legal counsel was unable to obtain contact information to confirm the reasons behind the withdrawal. For one bank-owned property, respondent states that it was withdrawn after a dispute over the listing agreement's end date, and just before leaving the firm, respondent had been contacted by another agent stating that the agent was listing the property. Upon obtaining a copy of the listing agreement, it does appear that the listing had expired many months before it was withdrawn from the firm by respondent. With regard to the bank listing where complainant had an email asking for permission for the withdrawal, respondent states that in a previous conversation with the bank representative, respondent had informed the representative that respondent was leaving, and the email reflected his response. In a conversation with the bank representative, the representative indicated that at the time he spoke with respondent, he was considering other brokers, and respondent approached him stating that respondent was transferring, so he indicated that he wanted to withdraw the listing. At this point in time, the bank listing is backlisted with complainant's firm. The recommendation is a letter of warning to respondent regarding Rule 1260-02-.02 subsection 3, which states that when a licensee terminates affiliation with a firm, the licensee shall neither take nor use any property listing secured through the firm unless authorized by the principal broker.
What's your thoughts?
Mr. Chairman, I'll put one out there. You know, to me, this is pretty black and white. Regardless of why, an agent leaving a company started contacting clients of the company, and they can make an argument that he wasn't trying to solicit that business to go with him to another firm, but it appears to me there's no question that he contacted these owners of property that were listings of the firm, not of the individual. And I just from a broker's point of view, the statute is clear on it. Is the statute or the statute?
This is a rule that I was referencing here.
And it basically says on your way out, you don't have the right to contact.
It says that you can't take or use any property listings.
I'm all about that, but the only way you take it is to contact them. I mean, they're not going to just know by osmosis that you're leaving a firm. There had to be an effort by this licensee to contact these owners.
I would disagree with you on that, because if it's a client that you've established a long-running relationship with and you've had more than one listing, wouldn't you want them to know that you're no longer going to be representing them?
I think there's more detail in here, but I think the intent of the regulation is that listing belongs to the company, not to you.
Well, I agree with that, but the matter of contacting them prior to your leaving, I wouldn't agree that you shouldn't be allowed, that you should not be allowed to contact them, because, as I said, the relationship, even though the listing is with the firm, the relationship is probably with the licensee. And if it's a long-term relationship, I would certainly want them to know that there's a change.
They'll know it soon enough, I'm sure. I think that in my world, the way that should work is the broker of the guy who's leaving would contact those owners and say, hey, we're going to reassign you to another agent. I mean, that's how I would think they should find out.
But there's no guarantee the broker would do that.
No, there's no, and a lot of times the broker will let you take your listings with you anyhow. You just have to have that understanding between the broker and the agent. In this case, we got the broker filing a complaint, so it's clear to me they didn't have that understanding before this complaint was filed or even before the agent left town.
But the complaint is based on prior contact. It's not based on stealing a listing.
Well, I think that's probably what the broker, the previous broker, thinks was going to happen. I mean, all of a sudden there are a bunch of listings that are no longer in his inventory.
And I think that's just going to vary from firm to firm, and I don't know that we can say, you have to do this in your firm, but I'm going to do this in my firm.
Well, I don't want to say it, but here's I think the regulation says you can't, at least in my mind, the way I've always thought, you can't contact the owners on the way out trying to get them to go with you. That's my interpretation.
Julie, would you read that rule, please?
There's a rule that addresses kind of a number of things, but do you want me to read that entire subsection?
Just that section about that.
Subsection 3 of Rule 1260-02-.02 states, when a licensee terminates his affiliation with a firm, he shall neither take nor use any property listings secured through the firm unless specifically authorized by the principal broker. That's the
Contacting your customer is not a part of that rule.
And I don't see that's a problem.
Mr. Grease, do you think that the recommendation of counsel is sufficient, or do you think that something other than what has been recommended should be in order?
I'm open to listen to the rest of the discussion, but my first impulse after reading this was that there ought to be a fine involved in this.
I'm sorry, I didn't mean
go
to
ahead,
interrupt
if I
you.
misread that.
No, there is, I do want to state that there was an affidavit that was submitted along with the response here from an individual who had worked at this firm, an office assistant in the past, that stated that it was standard practice that the agents handled their listing information input into the MLS, changing information, changing the listing status, and doing those things themselves. So, that's just a piece of information. I can't put every single thing in here, but that was something that was submitted with the response here, that perhaps this was an understanding there that this could be done.
Where are we on our motions?
What,
We don't have it.
what rule again was that, Julie? 1260-?
-02-.02, and it is found at subsection 3. The title of that rule is termination of affiliation, so it deals with a variety of issues, but it's subsection 3 here.
Those listings are inventory of the firm and an asset of that firm. And
But that agent has an obligation to contact. I would feel wrong as an agent if I didn't contact my listings and say, I'm not going to be with this firm any longer. And
Let me pose a question like this. Would it make any difference whether that agent talked to the clients before he left or after he left? Is there any control over what he does after he leaves?
His new broker, and that's it.
So if I'm going out the door and I'm not allowed to say goodbye, I can call you later and say, I'm gone?
Right, and in theory, the previous broker should have immediately made contact with those owners of those properties and said, so-and-so is no longer with us. Here's who we're going to assign to your listing. At which point that buyer, that owner might say, God, not me. I want to go with that guy. And at least then it's done in the right order.
so are we fining the broker then?
No, you're finding the agent for contacting.
Well, you just said the broker should have been the one to contact
No,
them.
I'm saying
And
in
he
an
didn't.
ideal world, he didn't have a chance. The guy withdrew him without him knowing it, according to his testimony here.
And this is real everyday stuff.
Yeah.
I mean, it happens all the time.
Oh, yeah.
So are you saying the status was changed in the MLS system without the broker's knowledge?
Yes.
That's his,
The
that's,
status was changed. The withdrawal forms were submitted along with the Trek 1 form for the transfer to the new,
Basically, this licensee stole an asset of this company and moved them.
well,
Moved
now,
the listing.
none of them at this
just
point
wondering.
were listed with the new firm. It was just that they were withdrawn without consent is the issue here.
But it was a valid listing agreement still in effect.
There was one that when I got a copy, there was one bank-owned property that it appeared that the date had expired, and that was the reason why
Okay.
it was removed.
Right.
For the other ones, they were still under the listing terms, I believe. However, I spoke with two of the individuals that I was able to get in contact with, and they confirmed what this respondent said. This respondent purely called to say, hey, I'm your agent on this. I'm getting ready to leave. What's going to happen is somebody else is going to get assigned to you. And in both cases, those two listing agreements were very close, within weeks of expiring. For various reasons, the owners explained to me we didn't want it we didn't want it listed anymore anyway, due to just things going on with them, the time of year. They said it was our decision to pull it. We were not solicited. That's the best information I could get from those owners through speaking with them.
Let me make sure I'm clear. The issue is not that this individual contacted someone before he left. The issue is that he made some changes in the MLS system before he left?
The issue is, the way the rule describes it is taking or using any listings. These listings were withdrawn without the specific prior authorization of this principal broker. However, there was some information submitted with the response that this was typically done there. So that is a factor.
We don't get involved in a broker's policies regarding MLS. That's not our job.
Well, but he
Sounds
was
like to me, too.
he was contacting those sellers who still had active listings with that firm, and it
the
would
rule
have,
didn't prevent him from contacting.
see,
Now,
I
the
agree with
end
John.
result-
I think it does prevent you from contacting them when you're moving, because you're doing that in an effort to take listings away from the firm you work with.
Not
To take them to the
necessarily.
new firm.
Not necessarily.
It's my duty to inform them I would be moving.
But I'm like John, you do that after you've made the move. You let the broker that owns those listings contact them first.
But it wasn't the company policy that's what the
How do
broker
you
did.
know?
We
Well,
don't.
it wasn't presented.
It wasn't presented.
It
He
wasn't
said
presented.
it wasn't company policy, and he didn't do it. I think we're getting involved in company policy that we just need to stay out of.
I agree.
I don't think
Well,
that's,
I understand the concern, and I understand
I
the
do too.
listings belong to the firm and that there are ways that it should be handled. But in this situation, I haven't seen anything that said that this person violated a policy. And we don't get involved in policy violations anyway.
Was there a broker's policy submitted to us that said, my policy is that this is what they should
well,
do?
I don't care what the policy is, but we're not arguing about policy. We're arguing about law here, whether he did the right thing by going in and talking to that broker or talking to those sellers prior to him leaving that firm.
And there's nothing in the statute that
There's
says he
nothing that
cannot
says he
talk to
can't.
someone before he leaves.
I agree with you, Isaac.
well, let me just put something on the floor for a vote, okay?
Make a motion.
I just want to read one sentence of this one more time. It says, with regard to the other withdrawn properties, several change forms note that the withdrawals were done per phone conversation with the owners, by the licensee, not the broker, before he left. He withdrew them before he left. So in my mind, he was contacting owners for the purpose of at least freeing listings up that he could maybe relist when he gets to his new firm. This is just how I think. So I also...
If you showed me a policy, a company policy that says that he wasn't allowed to make changes in the MLS, I would say that would speak to him having some ulterior motive in contacting those individuals. But you haven't shown me that.
Well, I can't show it to you, nor can I show you the policy that says he can't do it. I mean, we don't have a policy either. And you're right, we're not to judge on company policy.
Was there an independent contractors relationship written?
Copy of that agreement.
Was there one, though? Most companies have one, and it addresses those things.
I didn't
That would
receive
be
that
real
information.
important to know.
I think the broker's falling down on supervision all the way.
Well, not if he had a contract.
Then he should have
And
submitted
it
it.
said
And he
that.
should have submitted it.
I agree. He may have not had one.
Somebody,
We don't know.
Somebody want to give the chair a motion?
I thought we already had a motion.
No. I'll move that the respondent be fined $250 in order to attend a Tennessee Real Estate Commission meeting.
For the motion, do I hear a second?
I'll second that.
Discussion. Motion made by Commissioner Grease, $250 civil penalty, and attendance of a TREC meeting within 6 months. And seconded by Commissioner DeShara. Now some discussion.
Call for the question.
Do I push this little button here, or do I just?
You don't
speak
have
out
to
loud?
push it, you just speak.
Is that for violation of this rule that's listed here?
Yes.
Okay, just.
Awful precedence.
Vote it down.
I will.
All in favor, say aye.
Aye.
Opposed, no.
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 So who's gonna break this tie?
Well,
We ain't gonna break it.
Motion fails.
Motion fails. Would anybody like to make another motion, since that one failed?
I make a motion, we accept council's recommendation.
Do I hear a second to that motion?
Second.
Have a motion and a second. We take council's recommendation.
Which I might add says, licensee shall neither take nor use any property listing secured through the firm unless authorized by the principal broker.
Well, but a letter of warning is not something that's on their record as having done something wrong.
Right.
Where is that letter of warning?
We're not
This is a
required
matter
to
of
build a
warning.
case for the complainant.
Ah.
The complainant has to bring the information in so that we can make a judgment.
I'm going to vote for the motion. I'm just saying, I think, as Janice said, this is an everyday deal where agents are figuring out how to get listings away from their broker and into a new brokerage.
Well, then the broker needs to have something in writing that they sign when they take an agent on, saying you cannot do this or you can do this, and it needs to be something in writing, an agreement that they have.
I wish that.
I'm going to vote on the motion, but I didn't make this.
So there was a second, right?
Was there a second? You write it down.
No.
I think somebody seconded.
I'll second it.
Call for the
Barry won't change his vote on that last vote. He said
Call
he
for the
wished that.
question.
And call for the question.
You've got the right to move to reconsider.
I got the right to reconsider.
Let's just call for the question. It's not that hard.
Motion, who made that motion?
I made it.
You made the motion, take council's recommendation, and
I seconded
and
it.
seconded by Haynes, and we've had discussion. Any more discussion? Hearing none. All in favor, say aye.
Aye.
Opposed, no. Motion carries. Moving on.
I voted aye. It might have been 5-1.
It's 5-1.
72012022811. The complainant entered into a purchase and sale contract with the builder to purchase a new construction property. Respondent, affiliate broker, was the broker for the builder, and complainant had a broker. Complainant states the complainant was aware of a high-voltage tower near the property. Complainant applied for financing, there was an appraisal, and a closing was set. Complainant was applying for a conventional loan, which complainant states that complainant told respondent. But shortly before closing, complainant found out that the complainant's lender for the conventional loan would not approve financing due to FHA guidelines and the fact that the property was within the fall line of the tower. Therefore, the contract was canceled. Complainant then tried to negotiate with the builder to build a new home with the same specifications and compensate complainant for moving expenses, rent, and additional appraisal, which was denied. Complainant states that another potential buyer before complainant had been turned down for FHA financing for the same reason, and complainant alleges that respondent failed to disclose the fact that the high-voltage tower would make it ineligible for a loan under FHA guidelines, which complainant states affects the marketability of the property and would have made it difficult to resell the property. Complainant attached a number of documents, including but not limited to a copy of the appraisal and a printout which complainant accessed from the Internet, which states that it outlines the requirements for FHA-insured mortgages and states that the dwelling cannot be located within the fall line of the tower. Respondent submitted a reply stating that it is respondents and the builder's understanding that the FHA guidelines only preclude financing for a property in a tower easement and not the tower fall line, and the subject property was not located in the easement and was therefore not precluded. Respondent states that respondent told complainant when complainant first viewed the property that the financing should be done through a conventional loan. Respondent states that complainant's lender did not approve a conventional loan, but respondent communicated to complainant that the builder's preferred lender would offer a conventional loan for the property. Complainant did not opt to apply for a conventional loan through the preferred lender. The contract was canceled and complainant received a return of the earnest money. Respondent states that while respondent understands that the property is not precluded from FHA financing, respondent later removed FHA from the accepted financing on the MLS listing to avoid confusion. Respondent states that the subject property was later sold to another buyer at the same price with a conventional loan through the preferred lender. Respondent also attached a copy of a letter from the builder's corporate counsel which was sent to complainant in response to a letter to the builder, which in part states that the FHA guidelines indicate that FHA financing will not be precluded unless the home is located in a tower easement, which the property was not. Complainant submitted an additional response stressing that complainant was never told that the property would not finance FHA, and because this information was not disclosed to complainant, complainant states that complainant suffered from unnecessary expense of multiple appraisals, temporary rent until complainant could find a home, and additional moving and storage fees, etc. Complainant also questions why the preferred lender was willing to finance the subject property when other banks would not. Further, complainant states the complainant was unwilling to do business with the preferred lender because complainant does not like the bank's business practices. Additionally, complainant states the complainant did not want a home that would not meet all lenders' underwriting guidelines. Based on the information submitted by the parties disagree as to the FHA financing requirements, and there does not appear to be a violation by respondent. Therefore, the recommendation is to dismiss.
Motion to dismiss.
Second.
Motion by Commissioner Collins to dismiss and seconded by Commissioner Haynes. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries. Number 8.
2022991. Complainant entered into a pre-sale agreement and a joint venture agreement with an LLC with respondent, unlicensed, as its managing member. Complainant and respondent also entered into a commercial purchase and sale agreement on a TAR form. Complainant states that complainant paid $40,000 earnest money to respondent, which the TAR form states will be held in a real estate firm escrow account. Complainant states that respondent is the president of the real estate firm. Complainant states that respondent represented the LLC in the transaction. After the LLC did not complete the acquisition of the property referenced in the agreements by the agreed-upon date, complainant determined that the deal was not going to go through in the near future and made requests for the return of the earnest money, which complainant states have been ignored. Based on copies of the documents provided, it appears that complainant entered into the joint venture agreement with the LLC, wherein the LLC was acquiring a number of units which were to be renovated, and complainant agreed to pay an upfront cost for 10 units to be acquired by the LLC, with the balance due when the units became ready for occupancy. The joint venture agreement specified the expected initial lease rate, the expected monthly costs, and explained that disbursement of the profits to joint venture partners would be based on the gross profit. The agreement specified the LLC as the managing member and stated that the real estate firm would be the property manager. Respondent submitted a reply stating that respondent is not a real estate agent and has not been licensed in approximately 10 years, and respondent has not represented himself as such. Respondent states that respondent is the managing and sole member of the LLC, which owns the real estate firm referenced in the TAR purchase and sale agreement as the holder of the earnest money. Respondent states that the contracts between complainant and the LLC relate to a separate operating unit from the real estate firm, and the real estate firm was to be retained as the property management company for the project, but was otherwise not involved in the transaction between the LLC and complainant. Respondent states that the LLC entered into a pre-sale agreement with complainant for 10 units, and the real estate firm was not involved in the transaction. Respondent points to the TAR purchase and sale agreement, which does not include a listing or selling company, to show a lack of agency relationship. Respondent states that respondent wired a down payment to the real estate firm's escrow account in 2 separate wires. Respondent states that this was not earnest money as referenced in the TAR form, but was instead a down payment, and the only reason that the money was sent to the real estate firm was to use as an account for receipt and disbursement of the money, and the joint venture agreement controlled the contract. Further, respondent states that the money was not to be held in escrow by the real estate firm, but only received and disbursed to the LLC, to be returned to the LLC by the LLC to complainant only upon certain contractual circumstances. According to respondent, the money was wired into the real estate firm's account, and respondent transferred the money to utilize it for the project for items such as appraisals, etc. Respondent states that respondent has replied to complainant's request for return of the money, but there was never earnest money involved, and the money has been utilized for the project, so the LLC no longer has the money. Further, respondent states that complainant's request for the return of the down payment was instrumental in causing the LLC's purchase of the units to fail, and therefore respondent states that the LLC does not plan to return the complainant's payment. Complainant submitted an additional response through an attorney, which stated that complainant was led to believe that respondent was licensed since respondent was the owner of the real estate firm and respondent never informed complainant otherwise. Complainant states that respondent chose the real estate firm to hold the money and the real estate firm should not have relinquished control of the money to the LLC without complainant's permission. Complainant states that the money was not a down payment, but even if it was, the deal failed and the money is owed back to complainant. Based on the documents submitted, it is unclear whether the money was a down payment, earnest money, or an investment, and this is likely a determination for a court of law. However, respondent's use of TAR contracts creates the appearance of unlicensed activity on the part of respondent, and therefore the recommendation is a consent order for $500 for unlicensed activity in violation of Tennessee Code Annotated, Section 6213-1024A and B, which defines broker, and Section 6213-301, which prohibits unlicensed activity. Said order to also include an order to cease and desist.
I have a question.
Yeah.
The respondent owns a real estate company that serves as the property manager.
The respondent is the sole member of an LLC which owns the real estate firm.
So on one hand, he's not licensed, and on the other hand, he is licensed.
He does not hold a license.
He's operating a real estate management firm.
He's the owner of it. He's not the principal broker.
He's the owner of a
So
real
who's
estate.
the broker of it?
The principal broker of the firm,
Yes.
I believe, is the spouse of this respondent.
That's the rub. If the money made it into the real estate company's escrow account, then it can only be dispersed, in theory, by what the document says at the direction of the broker. And so maybe there may need to be another complaint filed here.
The spouse needs to be here. Well, not here, but and I know we can't tell them what to do about filing complaints, but
Well, the firm, we can
we
open
file a complaint.
I spoke with this respondent just because there was a lot of information submitted, and I wanted to be sure I was clear on this. This respondent, this is the information I received from the respondent, was that this principal broker was not involved in any way, shape, or form in this, except later to realize that this respondent, the owner, used the account just to take the money in and take it back out and use toward the project.
Sign the check transferring the money out.
The respondent states that the respondent transferred the money out.
So the respondent has access
That's
to the escrow account?
It can happen.
I know it can happen, but does
It's
it?
still a principal broker.
And they were actually, the respondent was actually a little bit unclear as he did not recall whether it went into the escrow account or the firm's property management account, but one account or the other, it went in and then was taken out.
For that.
Yeah, I think we need more. Yeah, I agree with you.
I think this one needs a little more
Investigation.
investigation and clarification. I think we need some copies of those checks, where it went as far as deposited and the money and what it came out of, Julie, because if it was actually deposited into that escrow account and then he wrote it out of that escrow account, he shouldn't have access to that escrow account to be taking money out of it.
And would that additional information be obtained for purposes of a complaint against the principal broker? Because this person's unlicensed, and all we can write this person for is unlicensed. This particular respondent is for unlicensed activity.
That's going to be for the purpose, that broker needs to be taking care of her escrow account.
Do you have the purchase contract in your file?
The TAR form, the purchase and sale agreement?
And
Yes,
who
I do.
signed that?
It was signed by this respondent and the complainant. Those are the signatures on it.
So an unlicensed used his wife's TAR contract.
An unlicensed individual used TAR contracts. I don't know who provided them to this person or how they were obtained, but TAR contracts were used by this unlicensed
I
individual.
think we need to dig a lot deeper.
And the contract stated who was to hold the earnest money?
Stated that it referred to it as earnest money. It said it would be held at this real estate firm. But
So
the
it
joint-
does-
It was earnest money, and it was to be held with the real estate firm.
There are other documents, though, that refer to it as a down payment. There's a joint venture agreement and a pre-sale contract that all refer to it differently.
But I guarantee, I'd be willing to bet the TAR contract, where it says it's earnest money, also says the only ways it can be dispersed from that account.
Yep, sure does. And he shouldn't have had access to that TAR contract anyway. That's another.
And how many agents are at this firm?
Sounds like a file that Mr. Grease needs to review.
I don't need, I think we ought to open up a new file. I mean, we.
I agree.
This particular respondent is concerned, there's no license, so the only possibility here is unlicensed activity, which by using these TAR forms, there's a good indication that there was a representation to this complainant that the person was licensed. So
Absolutely.
with regard to this person,
I'm not convinced that the actual broker of the firm that received the earnest money didn't have any knowledge of what was going on here.
I just think we need more information, and that fine is not enough for somebody that's doing unlicensed activity.
It's maximum.
I understand that. I understand that, but we still.
Would you think that a motion to open a complaint against the principal broker of this firm?
Before we
If the TAR contract was submitted and both of them signed it, we still need copies of the checks and where that, just like you requested, because that needs to be, if they both sign that, we still need that information.
Because we're going to have to decide whether we've got anything to open against the principal broker. But my guess is right here that we need to open a case against the principal broker. Well, it's looking like that, because if they're using TAR forms, he got them somewhere.
And he's yeah.
I'm going to put a motion on the floor, Mr. Chairman. I move we accept council's recommendation.
Second. Motion has been made by Commissioner Grease that we take council's recommendation, and seconded by Commissioner Collins. Consent order $500 for unlicensed activity. Any discussion?
You do?
Hearing none, all in favor say aye.
Aye.
Opposed, no.
And just as a quick follow-up, Wayne, I'd also let staff know, I believe it's consensus of this commission that you open up a case against the principal broker.
okay,
Thanks.
got it.
Do you need that in the form of a motion, Julie?
No.
No, I think we're okay on that. I'm clear on what you all want.
We can recognize them.
Are y'all ready, or I didn't know if y'all were talking?
Go on, or
Yes,
you going to call on my checks or something?
Before you go on, Ms. Crop, I'd like to recognize in the back of the room Commissioner Steve Myshak. It's good to have you here. Is there anything, we're enjoying our new digs here.
I was just here to say hello. I wanted to come. This is actually the first commission meeting I've seen down in the new conference space down here, so I was visiting just to make sure everything was going well. I think the tables are a little high, but we'll be working on that a little bit. It might be just a fine view for you all, but it's probably not as good for everybody else. But just wanted, as usual, come by and say hello and how much we appreciate all your hard work and all the good things you do, and hope everything's going well. So it was Wayne and I have been in a meeting, and he said he was coming down to address a couple of things, and I just took the opportunity to come down and say hello.
Thank you, Commissioner.
This sound system certainly works much better than the other one did.
It should. Well, thank you. No questions. I'll leave you back to your agenda.
Okay,
Thank
Commissioner
you.
Myshak. Mr. Pugh? Okay.
Okay.
Okay, Ms. Crop, carry on. Number 9.
Well, wait a minute, we got,
What?
wait a minute.
No, no.
Okay, yeah, we got it all.
Yeah, we're in good shape. Go on to 9.
9, 10, and 11. 9, 2012-023131. 10, 2012-023132. 11, 2012-023151. Complainant was the seller of a home, and Respondents 1 and 2 affiliate brokers were the listing agents. Respondent 3 is the principal broker. Complainant states the complainant told Respondents 1 and 2 that the fireplace gas line was not plumbed to the exterior of the crawl space, and complainant states that when asked by complainant, Respondent 1 told complainant that complainant did not have to disclose this, and therefore complainant decided not to give an allowance in the listing for this. Complainant also states that Respondents 1 and 2 told complainant that if Respondents 1 and 2 brought a buyer and became transaction brokers, complainant could have another agent from their firm represent complainant. Complainant states the initial listing price proposed by Respondents 1 and 2 seemed high, and complainant had to reduce the price a number of times. Complainant states that later in the listing, Respondents 1 and 2 introduced the idea of complainant offering an agent bonus to the buyer's agent, and so complainant agreed to do this by amendment to the listing agreement. Complainant states that a few months later, Respondents 1 and 2 notified complainant of an offer from a client of Respondents 1 and 2, which included stipulations for complainant adding a privacy fence and plumbing the fireplace gas line, which complainant states means that Respondents 1 and 2 told the potential buyer about the issue since it was not visible. Complainant states that complainant, when notified by Respondents 1 and 2, would become transaction brokers, asked for another agent from the firm, but complainant says this was denied, so complainant signed the form disclosing the change to transaction broker facilitator status. After some issues with an appraisal and someone hitting the mailbox during the buyer's early occupancy, which complainant states were resolved, the closing was set. Just before closing, complainant states that it was first addressed with complainant that complainant had to pay the agent bonus to Respondent's firm, which complainant refused to pay, said it must be removed or complainant would not close. Complainant states that the agent bonus was removed from the settlement statement and the house closed. Later, complainant received a debt collection notice from Respondent's firm and was served with a lawsuit for payment of the agent bonus. Respondents 1 and 2 submitted responses disputing complainant's allegations. Respondent states the complainant bought the house at foreclosure and did not want to disclose that the gas logs were not plumbed, despite respondents telling him that it should be disclosed. Respondents, on the advice of their managing broker, included the information on the MLS input sheet, which was part of the listing agreement and was reviewed by complainant, since complainant did not put it on the property disclosure. And Respondent 1 states that the prospective buyer asked about the gas logs. Respondents state that respondents explained to complainant the options available to complainant with regard to representation if respondents brought the buyer and became facilitators. Respondent 1 states that all price reductions in the agent bonus were confirmed in writing via amendments to the listing agreement. Respondent 1 states the complainant never asked anyone about having another agent assigned to complainant when complainants defaulted to facilitator status and signed documents to that effect. At several points throughout the process, Respondent 1 states the complainant acted belligerent and was difficult to deal with for respondents as well as other individuals. Respondent 1 states the complainant refused to close with an agent bonus included on the HUD statement, so it was decided that the bonus would be removed from the HUD and dealt with later through the court system so that the closing would be able to go forward, since the agent bonus was part of the listing agreement and not the purchase and sale agreement, which Respondent 1 states complainant was aware. Respondents stated that they at all times acted appropriately and kept their managing broker and principal broker informed of the difficulties and sought advice on how to proceed. Respondent 3, as principal broker, submitted a response to the complaint for failure to supervise. Respondent 3 states that Respondent 3 was kept informed of the situation with complainant, and Respondent 3 agrees that the situation unfolded as Respondents 1 and 2 described. Respondent 3 states that in Respondent 3's experience with the complainant acted in an unacceptable manner. Respondent 3 states that respondents acted professionally and properly as facilitators, and the complaint was filed due to the lawsuit for the agent bonus. Based on the documentation contained within the file, there does not appear to be a violation by respondents with regard to the allegations in the complaint. However, it appears that Respondent 2 was broker released in September 2012 due to relocation to a northern state, and Respondent 2 did not take action to change affiliation or retire the license. Respondent 2 states that Respondent 2 was informed that Respondent 2 did not need to do anything with regard to the license, but Respondent 2 does not plan to return to the state or renew the license. The recommendation is to dismiss as to Respondents 1 and 3, but as to Respondent 2, a consent order for voluntary surrender of Respondent 2's license based on a failure to complete administrative measures as required by Section 6213, 312B16, and Rule 1260-02-.02, subsection 2.
Accept council's recommendation.
Second.
Commissioner Grease makes a motion, we take council's recommendation, and Commissioner Collins seconds that motion. Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed, no. Motion carries. Ms. Crop, if you could hold up just for a minute. It is 4 o'clock, and I'd like to turn the meeting over now to our educational director, who's in charge of all of our licensees being here, and let them know what.
Are we going to finish tomorrow?
Yeah. No, we're going to finish. We're just going to.
Okay, ladies and gentlemen, we're going to go ahead and let you leave for today. Make sure that you sign out for today. The meeting begins at 9 o'clock tomorrow. And just a word before we start tomorrow's meeting, we do have a trial set. It is like a court, so come prepared. If you've got anything that's got to happen to go in and out, it's going to disrupt the court reporter and the judge. So keep in mind when you come in tomorrow that we actually are going to have it's going to be a court set up. Be careful on your ride home. We begin at 9 o'clock tomorrow morning.
Be sure and sign out as you leave.
Don't make them feel like they got to go if they want to
You can
stay.
stay.
Yeah, you can stay if you want to. We'll finish this legal report, but it's
It's really interesting.
It's been customary that at 4 o'clock we go ahead. If we continue past the 4 o'clock, we give you licensees the option of staying and/or you can go ahead and leave. We figured you've heard enough for one day. But if you want to stay, you can.
And we're not kicking you out.
No, we're not. As Commissioner DeShara said, we're not kicking you out. We're just giving you the option of staying or going.
There we go again.
I hear a woodpecker.
Here, Woodpecker.
That's a one big woodpecker.
We're to number 12 now, I think.
Okay. 12 and 13, 201202338 201202332. Complainant attempted to buy a bank-owned foreclosure property as an investor, which was listed by Respondent 2, a broker. Respondent 1 is Respondent 2's principal broker. Complainant states that Respondent 2 told complainant's broker that there was a 5-day waiting period before the offers could be taken. On the date of the listing, complainant states that complainant's broker emailed a cash offer for $1,000 over the listing price to Respondent 2 and later delivered a hard copy of the offer to Respondent 2's office. A few days later, complainant's broker went to Respondent 2's office, and complainant states that complainant's broker was informed that complainant's broker was supposed to enter the offer directly on the website. Once complainant's broker visited the site to enter the offer, the property was already under contract for the list price by another buyer. Complainant states that Respondent 2 never submitted complainant's offer, and there was never a 5-day waiting period for the property. Respondent submitted responses to the complaint. Respondent 2 states that Respondent 2 received the listing from the seller, and the listing was posted on the MLS. On the following day, Respondent 2 states that Respondent 2 received a notification that the MLS sheet should read that all offers should be submitted through the website in the agent-only remarks, and the MLS sheet was updated immediately. Complainant disputes this. When complainant's broker brought the offer to the office, complainant's broker was told about submitting the offer online. Respondent 1 states that complainant was represented by complainant's spouse, who was a very new licensee and did not read the instructions on the MLS sheet, which stated that all offers had to be submitted through the website. Instead, complainant's broker emailed Respondent 2, which was not received, and came the next day to submit an offer in person and was told that the offer had to be submitted online through the website, and by the time complainant's offer was submitted correctly, another offer was already accepted. Respondent 1 states that complainant's offer was ultimately submitted as a backup offer by complainant's agent. Respondent 1 states that the listing agent in this case does not present the offers, but are emailed when offers are received, accepted, rejected, or if there's a need for multiple offers. Based on the documentation in the file, there does not appear to be a violation by the respondents, and therefore the recommendation is to dismiss.
Motion to dismiss. Second.
Motion by Commissioner Collins to take council's recommendation to dismiss, and second by Commissioner Northern. Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
023-481, 2012023-482. Complainant booked a vacation rental through vacation lodging firm for which Respondent 2, affiliate broker, works. Respondent 1 is Respondent 2's principal broker in the designated, sorry, that should read designated, no I.
Motion to dismiss.
Commissioner Collins.
DLS, there's nothing you're going to do about it. Talk about it all day
Second.
long.
Have a motion by Commissioner Collins and seconded by Commissioner Northern. Any discussion?
Open question.
Breaking with protocol.
It's up to you all, if you've all had a chance to review it.
It'll be voted up or voted down.
When Commissioner Collins says there's nothing we can do about it, what does that mean? I mean, it appeared to be agreement with his statement, but I don't...
This is open, this is actually a complaint that's opened against an affiliate broker and a principal broker. This principal broker is also the designated agent for a vacation lodging firm. As you can see, they allege that when the charge dispute was there, that this Respondent 2 was pursuing payment from the credit card company on the side was their issue in this complaint. I can continue reading if you want. I know you all have had a chance to review this. It's up to you if you want me to continue reading.
Feel very strongly about dismissing this one.
That's my recommendation.
Okay. That's all I wanted to know. Question has been called. All in favor say aye.
Aye.
Opposed, no. Motion carries. Number 16.
2012023-631, a complaint opened by Trek based on information received which stated that Respondent, an affiliate broker, had been arrested for theft over $10,000 and Respondent had entered into a judicial diversion agreement regarding the charge. Based on the documentation received, it appears that in early 2012, Respondent gave a conditional plea of nolo contendere, no contest, to the felony charge, and the court deferred further proceedings without entering a judgment of guilty. Instead, Respondent entered a judicial diversion program, which in part provided for a 3-year probationary period. During that probationary period, Respondent is required to complete a number of items. If Respondent violates any condition of Respondent's probation, the court may enter an adjudication of guilt and proceed accordingly. If, at the end of the probationary period, Respondent has successfully completed the diversion program, the court will discharge Respondent and dismiss the proceedings, after which point it is possible for Respondent to petition for expungement. Respondent submitted a response stating that there was no conviction with regard to this legal matter, and therefore Respondent was not required to inform Trek of the situation based on Trek's rules and regulation. Respondent appears to be correct that Tennessee Code Annotated Section 6213.312F's notification requirement within 60 days of conviction does not apply at this point in time, since at this time there has been no conviction. However, it is possible under the diversion agreement that if Respondent violates a term of Respondent's probation within the probationary period, the court could enter an adjudication of guilt, triggering the notification requirement. Therefore, the recommendation is a consent order for litigation monitoring.
I have a problem with this one. He was arrested and pled guilty for over $10,000, and really they're just doing a plea with him.
It did not plead guilty, pled no contest.
Played no, well, that's in place of pleading guilty.
I move to accept council's recommendation.
Second.
Have a motion by Commissioner Northern to accept council's recommendation and seconded by Commissioner Collins. Any discussion on complaint number 16? Which is
Yes, he's also uninsured. He has basically, theft over $10,000 is pretty big.
And he still has an active real estate license.
And he still has an
uninsured.
active real estate license. He's uninsured. He's basically pled guilty for a theft over $10,000. Then they're putting him on probation, whoever this is, or she, on probation.
Can I just state one thing, too, that's on here? This individual, we were notified because the individual was broker released because of this. At this point in time, the person has not completed steps to change the affiliation and is still in broker release status. Therefore, the staff is sending out an agreed citation for failure to take administrative steps, but there is no active license at this point because the person is in broker release status, is not affiliated with a firm.
Staff is doing what now?
They don't have an active license right now. It's in
Yeah,
broker release.
But
Do you want to change your recommendation?
I still think that a consent order for litigation monitoring would be the best way to keep track of whether there ends up being a conviction in this case, considering the fact that there's a lengthy probationary period, at which point, at any time, if this person violates the probation, there is a conviction, which then triggers the notification requirement.
Would it also trigger, though, okay, so let's say that he pulls his license out of broker release, and all we're doing is monitoring him for litigation procedure.
What she's saying is he can come back into the business before this litigation concludes, and we still haven't done anything to, in the way of oversight.
Well, we can only automatically revoke if he does not notify us of a conviction within 60 days, which there's no conviction. And then under 6213-312B12, it allows the commission to discipline when a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of, and it lists being convicted of a number of offenses or pleading guilty or no contender to any offense or offenses. But the problem here is if this person completes the diversion successfully, this matter is expunged, there's no conviction, it's off the record at that point.
But if he comes back and takes his license out of broker release, then he'll have to get E&O insurance or be fined, correct?
I believe so, yes, that's correct.
You won't be able to transfer without E&O,
Okay.
come out of broker release without that.
still have.
And the indication, the court paperwork we received, that the felony theft, the matter was not related to a real estate transaction. It was a different side job. It was not a real estate client that was involved in it.
Either which way, somebody doesn't plead that unless they're guilty.
That's not true.
I think our issue here is just that it's under diversion, and if he successfully completes this, it's the way that the statute is written, there's never an adjudication of guilt entered. It's expunged. It's as if it never existed.
Somebody call for question on the motion.
Call for the question.
All in favor say aye. Of taking the council's recommendation, consent order for litigation monitoring, say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, can I ask another question or pose an issue with council?
You can ask anything you want to.
When we deal with people applying to get a license or take the exam, nolo contendere is one of the things that triggers them having to come before us. Yet it's not a part of proceedings after they get a license. Should they not mirror each other? I mean, if we're going to require them to come before us on one set of rules to begin with, and then later on those rules are changed, should they not match?
If someone were to apply that in the past had pled no contender to something under a judicial diversion agreement which had been dismissed and expunged, they then, if that had already been done, they would not have
But
to.
we're not talking about it being expunged at this point. We're talking about mirroring the requirements. Maybe that's a discussion for another time, but it just seems to me like we got one set of rules on one side and a different set of rules on the other side. Because on what we're dealing with now is not as stringent as it is in the application process.
I think they're looking at you, Robin.
Don't hide.
We can discuss it later. We can
Yeah,
move on.
Yep. Number 17.
(2012023741). Complainant, a licensee, was one of the sellers of a property. Complainant was represented by another broker acting as the listing agent. Respondent, affiliate broker, was the buyer's broker. Complainant alleges that respondent tried to increase respondent's commission from the 2.4% offered in the MLS listing to 3% and told complainant's agent that respondent would divert respondent's buyer elsewhere if complainant's agent did not agree to 3%. On the day of closing, complainant told respondent that complainant would not close because of respondent's 3% commission demand. Complainant states that respondent apologized and agreed to take the commission down to 2.4% and let the sellers net 0.6% more, but the parties agreed that the 0.6% would be donated to a charity. When the title agent said that the paperwork would have to be reworked to address this, the parties agreed to leave the commission the same with the understanding that respondent's firm would disperse 2.4% of the payment to respondent and the remaining 0.6% to the charity. Later, complainant learned that the full amount had been dispersed to respondent and the money was not paid to charity.
Commission disputes. I make a motion we dismiss this.
Second.
Is there anything else besides a commission dispute?
Just looking through it, I don't see anything other than that.
It's, I can continue reading it if you'd like for me to. It's all outlined in here, and I can continue reading it if you all would like for me to.
Like Wendell said, just go ahead. We only got 3 more, and let's.
Wendell's not listening today.
I know, but his legacy's here. Keep going.
Yeah, I'm going to get
Right.
water.
Does anybody want any water?
Yeah.
Go ahead.
I'm good.
Commission dispute wherein complainant disputes the difference in the 3% commission negotiated between the parties by agreement and accepted by the parties in the purchase and sale agreement through a counteroffer which specified a 3% commission to respondent and the 2.4% commission offered in the MLS listing. Respondent states that respondent's buyer was elderly and needed to close quickly or the buyer would have to move on if an agreement could not be reached quickly. And respondent states that respondent told complainant's listing broker this. Once there was a counter from the sellers, respondent states that respondent assisted the buyer in preparing a counter offer with a revised price and provision stating that respondent should receive a 3% commission from the purchase price, which was accepted by all sellers, including complainant. The closing quickly followed, and respondent states that complainant accused respondent of threatening to take the buyer to another property unless respondent received the 3%, which respondent denies having done, and complainant cursed respondent and threatened not to close. Respondent states the complainant told the closing agent that respondent should donate a portion of the commission to charity and was informed that this would alter the closing papers, so complainant and the buyer signed the closing papers. Respondent denies threatening to divert the buyer to another property, and respondent denies agreeing to any concessions with regard to the commission. Based on the documentation contained within the file, this appears to be a commission dispute, and there does not appear to be a violation by respondent, and therefore the recommendation is to dismiss.
We still have on the floor a motion by Commissioner Collins to dismiss and a second by Commissioner Northern. Now that you've heard it all, any discussion? It's sometimes I find myself almost amused at some of these complaints and how they're crafted and wind up with us. Hearing none, all in favor say aye to dismiss. Aye. Second. No.
They need to file an ethics complaint. What they need to do.
What did you say, Commissioner Grease?
I'll recuse myself from that vote.
You recuse yours. Let the record show that Commissioner Grease recused himself.
He wanted that 6%.
You wanted all that 6%.
18 and 19, 2012023791, 2012023792. Complainant states the complainant viewed a number of homes for complainant's daughter. Complainant contacted Respondent's firm. Respondent 1 is an affiliate broker. Respondent 2 was Respondent 1's principal broker and met Respondent 1 at the subject property, a Fannie Mae property, where complainant asked Respondent 1 to prepare an offer as soon as possible as complainant was leaving town. Later, complainant states that Respondent 1 informed complainant that Respondent 1 had asked her broker about the situation and the offer could not be submitted until that Friday. Complainant states that complainant emailed Respondent 1 with the information for the contract on the evening that the house was viewed, and after not hearing back from Respondent 1, complainant realized that complainant had sent the information to the wrong email address. It was forwarded again to Respondent once complainant realized this, which appears to have been several days later based on copies of the emails submitted by complainant. By that time, the information was given to Respondent 1, and the offer was submitted with complainant's daughter as the owner-occupant as directed by complainant. A higher offer had been... By the time that information was given to Respondent 1 and the offer was submitted with complainant's daughter as the owner-occupant as directed by complainant, a higher offer had been accepted on the property. Complainant states that Respondent 1 did not properly present the offer and complainant did not get a contract on the house because of the lack of timeliness of the offer. Respondent submitted respondents to the complaint denying complainant's allegations and stating that everything was done properly by respondents. Respondents state that Respondent 1 met with complainant and spouse at the property. Respondent 1 states that there was never any mention that the property would be owner-occupied by complainant's daughter as the buyer, but only that complainant wanted to buy the property for the daughter to live in. Respondent 1 never met with or spoke with the daughter. And complainant would not be a permanent occupant of the house since complainant lived in another state, which Respondent 1 states indicated that this was an investment purchase. Respondents state that Respondent 1 described the situation to Respondent 1's principal broker, who advised that the first look period would not end for several more days and complainant would have to wait to submit the offer after that time since the complainant appeared to be an investor. Respondent 1 told complainant this, and they could handle the offer by email once complainant returned home. Respondent 1 states the information for the offer was not received from complainant until several days later, due to the email that complainant sent to the wrong address. When it was received, the name of the buyer was another person whom Respondent had never heard of or met. Respondent 1 prepared the offer in that name with the information given and indicating that it was for an investor. At that time, Respondent 1 states that complainant said it should be owner-occupant, and Respondent 1 sent the owner-occupant affidavit for signature by the buyer, which Respondent 1 says was not received back from the buyer. Respondent waited for the documents, then prepared the offer to Fannie Mae without the documents, which had not been received, signed by the buyer, and the offer was rejected, and so complainant told Respondent 1 to submit the offer at a higher price. Respondent 1 later received information that Fannie Mae had accepted an offer which is several $1,000s higher. Respondent 1 states that complainant is angry that the offer was not submitted on the first day that the property was viewed, but Respondent 1 states that Respondent 1 was abiding by the rules regarding owner occupancy, and per the conversation on that date, Respondent did not qualify for that. Respondents added that complainant states in the complaint that complainant is not and has never been a licensed broker in any state, but complainant made reference to being a retired broker in the correspondence between the parties. Respondent 2 states that complainant did not timely return documents and that complainant changed the paperwork to owner-occupant solely to avoid the waiting period for investors. It does not appear that there was a violation by the respondents, and therefore the recommendation is to dismiss.
Accept council's
Motion by Commissioner Greaves to accept council's recommendation and dismiss. Second by Commissioner DeShaw. Any discussion on this complaint or questions of Ms. Crop? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries. Number 20. 21.
201202441 and 20120243131. This is a TREC open complaint at the direction of the Commission regarding a situation where Respondent 2, a principal broker, represented a seller who entered into a purchase and sale agreement with unrepresented buyers which did not proceed to close. TREC was provided with information that Respondent 1, an affiliate broker, may have been related to the unrepresented buyers, that the unrepresented buyers were Respondent 1's mother-in-law and father-in-law, which was disclosed verbally to the seller but not confirmed in writing. Respondent 1 filled out some of the paperwork with the unrepresented buyers. The confirmation of agency status and the lead-based paint disclosure all contain the signed name of Respondent 2 as the licensee for the selling company, with the notation that Respondent 2's name was signed by Respondent 1. And the purchase and sale agreement contains the signed name of Respondent 2 as the licensee for the listing company as well as the selling company, with the notation that Respondent 2's name was signed by Respondent 1. This complaint was opened against Respondent 1 for potential personal interest disclosure issue and a potential failure to supervise issue for Respondent 2. The respondents did not submit responses to this complaint. The recommendation is a consent order is recommended for each respondent on the issue of failure to respond to a complaint filed with the Commission in violation of Tennessee Code Annotated Section 6213-312B14 and Section 6213-313A2, plus attendance by the respondents at one entire meeting of the Commission within 180 days of their execution of the consent order. It's also recommended that the Commission discuss the personal interest disclosure issue and supervision issue in light of the information received.
What do you mean by the commission discuss the personal interest in disclosure
Well,
issue?
there's a number of issues here because I'm looking at, I've reviewed the statute. The statute is 6213-403, and that is titled A Duty Owed to All Parties. And what that statute states is, a licensee who provides real estate services in a real estate transaction shall owe all parties to the transaction the following duties, except as provided by 6213-405, in addition to other duties specifically set forth in this chapter or the rules of the Commission. And Part 7A of that section states, not engage in self-dealing nor act on behalf of licensee's immediate family or on behalf of any other individual, organization, or business entity in which the licensee has a personal interest without prior disclosure of the interest and the timely written consent of all parties to the transaction. There are two questions here. We received information when the first complaint was opened, which had a variety of issues that couldn't be gone. The only thing potentially to go forward on was this personal interest issue. I received information from the principal broker that this was a mother and father-in-law. The first question is a mother and father-in-law immediate family? Because that's not defined in here. Second issue is these were unrepresented buyers that were related to Respondent 1, the affiliate broker. It appears that Respondent 1 filled out paperwork for them, filled out at least the offer, the lead-based paint disclosure, and the confirmation of agency status. Some of these things were filled out. The second question, that is whether this is providing real estate services. These people, the reason it was opened on this issue was hoping that these people would, the first complaint was a variety of other issues where there was no confirmation of violations. The idea behind opening this complaint was to have these people respond, give us some more information, and we have good service on them. Somebody signed for them at the firm address, and there was no response submitted. So at this point, this is all the information I have to go on because they did not give me a response to these specific issues. I wanted to make you fully aware of these things just because there are a couple questions within this statute to see how you all would like to proceed. There's a definite issue of we have service of the complaint on these people. They did not respond. That is a clear violation of our law. Whether this is a immediate family and whether this person was providing real estate services by perhaps just purely filling out the offer for these people are two questions that we have that...
You want us to consider and discuss those two issues prior to making a motion?
Well, you know, if we're
Or
going
do
to
you
do a
want us to
consent order,
accept
we
your
need to
motion?
include everything together, and that's why I wanted to have a discussion on that with you all.
Say father and mother-in-law?
Mother-in-law and father-in-law.
Mother-in-law and father-in-law.
Would you restate the other two statutes, 6213?
It's 6213-403 is the duty owed to all parties.
I don't necessarily have a problem with it being an unrepresented buyer as much as I do the personal interest disclosure. I feel like a mother-in-law and a father-in-law is close enough family that you should disclose it. And what's the harm in disclosing?
And the information we received was this was verbally told to the sellers. That was told to me. However, beforehand I confirmed with the principal broker that there was no written disclosure provided here. The issue is if this person purely filled out this offer for an unrepresented buyer or seller, the question becomes whether that is providing real estate services. You know, you all are industry members and know much more about that side of it than I do.
Well, I mean, you can provide real estate services and the buyer still be unrepresented. I mean, if you're representing the seller, you're still going to do all the paperwork, and the buyer can still be unrepresented, and you're providing real estate services.
Talking about being a facilitator?
Well, no, you can be an agent for the seller and the buyer be unrepresented, and you're still providing real estate services to that buyer.
And based on the confirmation of agency status sheet that was filled out here, respondent to the principal broker was the designated agent for the seller, and it was marked that the buyers were unrepresented. So there is no facilitator issue here.
Right. I mean, so, and that's a doable thing. I mean, we
You
do
can
that
also
in my
say that-
office all the time.
You can also say that writing the contract was a service for the agent's client and not necessarily the unrepresented person, because without the contract, you have no deal.
And if it personally was my mother and father-in-law, I would have disclosed it, but I don't know that that's really the way the statute says.
Well, it says you have to disclose personal interest. The problem is it does not say what is considered
Personally.
your family.
Yeah.
I mean, is your mother-in-law and father-in-law your family? Some would say yes, some would say no.
Immediate family, and I'm not sure that it is. I think we just need to go with what your recommendation is.
I was going to say, not ever having a mother and father-in-law, I guess I can't even speak to this.
Yeah,
I
you
don't.
need to recuse yourself.
I'm going to
Yeah,
recuse
definitely.
myself from this discussion.
So, can I go back to your recommendation for a minute? Here's why I'm confused. It says a consent order, and it goes down to the third line and says plus attendance. What would the consent order say?
It would say that a complaint, I would keep the facts simple in the fact that if you all don't see a violation of the personal interest or failure to supervise, I'm not going to get into all of those details in there. It would just say complaint was sent to them on such and such date. It was signed for so-and-so. At this response, they failed to submit a response, and our statutes require a written response to any complaint.
Here's why I'm confused. It says plus attendance. So there was something in front of that.
Oh, I didn't assign a civil penalty value to it because I didn't know if it would include just the failure to respond or also the other issue.
If it was just failure to respond, what civil penalty would you recommend?
The range for failing to respond is $50 to $1,000.
Well, they've not cooperated at all, have they?
There was no response received to this complaint.
I Googled immediate family, and the definition provided by Google does not include mother-in-law and father-in-law. Now, that's not Wikipedia, that's not Webster, that's Google. So what is the legal definition of immediate family? If I go with what Google says, there was no violation.
All right, so I'm going to make a motion. Do we have a motion on the floor?
No.
No.
Okay, I'm going to recommend that a consent order, the recommendation be a consent order for each respondent with a $1,000 fine each, plus attendance by a respondent at one entire meeting of the commission within 180 days, which is typical what we do for people who do not respond.
Maximum.
Right,
There
but
have been times for people failing to respond that there have been lesser amounts for that. And considering the fact that you all did not see an underlying violation of what the complaint was originally opened against, might ought to be something that you would consider in weighing the civil penalty for failing to respond in light of the fact that you all are leaning
I don't think
towards...
we've made that decision. I just think we've discussed it. But what is clear to me is they didn't respond.
No, there was no response received.
Either one of them.
No, there was
Family,
not.
are they family members?
Of each other?
Yeah.
Not to my knowledge. It was sent to them separately at the firm address on file with the commission and was signed for by a representative at that firm.
We basically ignored it. It was basically ignored.
It was not returned unclaimed. When I receive one that's returned unclaimed or undeliverable, I always try to give a second opportunity, thinking there could be a problem with the mail. This was signed for.
I'll second your motion.
So, Julie, what is the legal definition of immediate family? What do you consider immediate family? Don't look at me like that.
I would have probably Googled it like Isaac did. I don't know that immediate family is in Black's Law Dictionary. You know,
I guess it depends on whether you like your mother-in-law and father-in-law or not.
I don't think they're immediate family.
Well, I think if they're your husband's parents, they're pretty immediate family. You're going to take the day off to go to the funeral.
Ain't got nothing to do with it.
Depends on if you like them or not.
We have a motion by Commissioner Grease and seconded by Commissioner
And we're
Haynes.
discussing.
Yes.
And we're discussing the motion.
And by the way, if these guys don't like it, they don't have to agree to the consent order, and they can come in here and we can have a hearing. if they
That's
get
right.
These answers.
Well, but Julie still needs to know whether we think there was a violation on the personal interest or not.
I don't think there was, give you my opinion.
You never had in-laws. You don't count, remember?
I'm going by Google. It's not immediate family.
We got one
It's an
more.
extended family. It's not immediate.
I agree.
I'm glad somebody
I
agrees
think
with me.
the discussion was the severity of the fine relevant to the original
That's all.
offense, not just the failure to
Didn't we do a
respond.
500 earlier?
We have done 500.
No, I'm talking about earlier today.
We've done
We
250.
We did a 500 for failure to respond.
We didn't have one. Would anybody
Not
like,
today,
Okay.
but
would anybody have any
License
interest in
activity.
amending Mr. Grease's motion?
What about voluntary revocation of their license? You wanted a substitute? I want to get their attention.
I think $1,000 to get their attention.
I'm going to put you, question I have is, does the crime fit, does the punishment fit the crime? Punishment fit the crime? That's the question I have.
Be that the complaint was opened for the potential of the personal interest and failure to supervise issue, hoping that we would get some more information on this.
They're still ignoring us.
And based on the information that we have, which, you know, is the relationship we were told they had and what was done, you all have determined that you don't think there's a violation. So I guess
Personal interest part of it. We've thrown that out. We all agree that it.
We didn't all agree to that.
No, we didn't all agree to that.
You're right. So you want to bifurcate this and come back?
I want to just talk about the fact that guys did respond to a request from the commission.
Okay.
And they're
That's
just
all I'm
totally
talking
ignoring us.
That's the only thing we got.
All right. Call for the question.
All in favor, you know what it is, $1,000 civil penalty, and you including in that attendance,
The broker and the affiliate.
Yeah, they have to attend.
and then each one of them have to attend a TREC meeting within the 180 days. That included in your motion too, Commissioner
Yeah.
Grease?
He
Absolutely
did.
is.
Okay. Question has been called. All in favor, say aye.
Aye.
Opposed, no. No.
You wanted to get their attention.
One
You
no.
got it.
That's exactly.
5 yeses and 1 no.
Ignore it.
I thought you were going to abstain.
Abstain, no, same thing. I know.
Okay, does
He
is
was
Wayne,
only abstaining
does
on
Wayne,
the
Yes, Wayne.
Wayne
We're going to.
very patient.
If I could, call on Wayne Pugh.
Finally.
He gets, it's past 4:30.
A for patience.
He's going to get time and halftime again if we don't get him on the floor.
Oh, he's got another meeting, too.
He's going, yeah, he'll be getting overtime. We don't get any, he does.
Well, we get big money.
Is yours on? It's not turning red. There you go, there we go.
Didn't do anything, but now it's on, okay.
It moved. It's motion sensitive, I guess.
I believe they've given you all the information. We spoke about the E&O bill this morning.
Mhm.
There was another bill out there regarding fingerprints. taking fingerprints, and doing criminal background checks for applicants for real estate licenses. I was handed an amendment today. We'll make sure that we get it out to you. I don't have copies. When we looked at the first bill and the amendment to it, we looked at it that there was some awkward language in it, but it clearly was applying, or we thought it was applying to new applicants. The amendment that was handed to me today makes it clear that it is applying to all licensees, that you either get your fingerprints when you initially apply, or if you've not done that, then you have fingerprints submitted when you renew. Now, you only have to do it one time.
But now, you're saying all licensees, just real estate licensees, or all?
All real estate licensees.
Just, okay. I didn't know if it was, you were talking about anybody who had gotten auctioneers and anybody who was getting a license with.
This is just amending the real estate
It's a
statute.
bunch of crooks in the auctioneer business.
I think that's a violation of our personal rights, actually.
I'm just kind of getting your feel for this. And
Carry a gun, you gotta have your license with your fingerprint.
Do what now?
You gotta have your fingerprints to get a carry permit.
Well, I'm not carrying anything.
Carry a real estate license.
I personally don't have a problem with people having to be fingerprinted. It would stop some of this people having to come before us because they did something stupid when they were 20.
Now, who's going to administer the fingerprinting?
Yeah. Who's going to pay for all that? What's the fiscal note with it?
have to pay for the cost of the fingerprint.
Oh, that's lovely.
Where do you
go take your grandfather and your fingerprints?
I mean, where do you go? Down to Sheriff's office?
And the way that it's written right now, I think we would have to go in and talk to them for sure. We do have some programs that do criminal background checks. And the way we want it set up is to where you can go down and do an electronic fingerprint and have that submitted directly to the TBI.
Does it look like this is going to pass? Are realtors in favor of this? I can't imagine.
Yes, the realtors are in favor of it. They
are?
Yeah.
Everybody about it. It was just, the amendment was actually handed to me today. I know I've had discussions with Julie, and I just wanted to make sure that
Okay,
you
now wait a minute.
guys
This
were
is
aware.
an amendment to the other bill we were looking at?
This is amendment to the original, I believe you discussed.
That's just, it's two bills.
Originally, the fingerprint bill was just for new agents, and now they've amended it that it's going to be everybody.
Current licensees, upon renewal, you would have to submit fingerprints.
We at one point had TBI in to speak with us, and we talked about the cost of background investigations and fingerprinting. And if I'm not mistaken, the cost of fingerprinting was quite high. Do we have any idea as to what this would cost? Not that we got any control over it at this point anyway, but
I think it's about $75, isn't it?
I don't know. I can find that
Deanna,
information and make sure we get it to you.
I would venture to say there'd be a fiscal note attached to this,
Yeah.
just because a lot of these old-timers who are barely keeping their license around, if all of a sudden we said, you've got to go down and get fingerprinted, they say, screw it, I'm just going to retire my license. And there would be a cost. Then there's
Looks like
someone.
to me.
What did she say?
Does it say that they would have to renew a retired license even?
It says to renew a license.
And you have to renew it.
So even
So
retired
even if they
people-
retired and wanted to renew, it could potentially.
Excuse me.
I'm sorry, say that again, Julie.
It's my understanding that even if you retire a license, you still keep renewing it. I'm not sure if this bill would even require someone who retires
I would
it to
think
do
so.
the fingerprints in order to renew, even in a retired license status.
Looks like it'd be hard to make a new person do it without old people doing it too.
I'm just bringing this to you guys. I have no opinion on this whatsoever.
That'd be
As far
the-
as your comment to cost, it does authorize the commission to enter into an agreement with the Tennessee Bureau of Investigation to administer a background check. And it also authorizes the Tennessee Bureau of Investigation to collect from each applicant the cost incurred by the department in conducting the criminal background check. So it's a pass-through right to the licensee.
When they came before us to talk about their services, it was quite expensive to have them do background checks and fingerprinting.
I can get that information for you because we do have other programs, and I can make sure that we get it disseminated out to you.
A lot of states are already doing it, and I'm in favor of it. We've had a lot of people come before us. If we'd had that, they wouldn't ever been before us.
Well, then, after we get the
I don't think they ought
fingerprints
to
from all...
single out real estate licensees when there are other people who are involved in fiduciary positions.
I can't do nothing about that.
By golly, don't you dare go have an
Just gonna-
auctioneer's fingerprinted. They won't anybody get an auctioneer's.
Well, I told you,
This
you're a bunch of crooks.
Will this include vacation lodging and...
Oh, Lord, that'll clean them out.
That may be one way to get rid of them.
Maybe one way to get rid of them. And then what happens after the department has all of these 23,000 licensees that we've got fingerprints on, you're going to go and background checks, and who is going to sit down at the desk and look at all this and determine what is to be done and what is to be done with this? They're convicted of a felony. We get rid of their license. I mean, is it all of them going to come before us? I mean, gee willikers.
Well, I mean, quite honestly, if they've got a criminal record and they're out there selling real estate, they're already supposed to have told us that.
Yeah, that's
I mean-
true. But
There could be some licensees who might have had just a one-night discretion.
Well, like a 2-week thing.
No, I'm just talking about myself. You know,
Do tell.
to get my
He
Kentucky-
spent a night in jail.
yeah, that's right. We heard this
to
earlier.
get my Kentucky real estate license, I had to get fingerprinted and sent up there, and the FBI found a match, which, come to find out, was an event I'd forgotten about years before. And it really didn't play into my character. It was just one of those deals where I had to go down and get the local sheriff to explain what I'd been incarcerated. I mean, I would stop for that night.
We could get them to include DNA and see how that affects Bear.
You're out of order, Commissioner.
He may have some in-laws.
Okay, and where is this in the line of being? Okay.
Wayne, you can tell them the commissioners without a record are okay, the ones with a record were opposed.
I'm not opposed. I'm just telling you, it's a little embarrassing.
I will tell y'all that, I'm the person that talks to every single person that has addiction in their past, and there have been quite a few people over the course of my time here that have said, I wish I had never told you. How would you have ever found out? NARC, yeah. Someone will tell on you, is what we do.
Well, I was going to say, that's how we find out. That's that guy we took his license away from him because he didn't tell.
But they do say that. So, I'm sure that,
I think it does have, we've put a physical note on it along the reasons that Michelle and talking about who is going to sit down and look at all of
That's what I'm
this.
thinking. It's going to
will
have to
require
have something on it.
Was it a House bill or a Senate bill?
Well, it's both. I've been following in both houses, and it does have companion bills. It's in
What's the
both
number?
houses. Senate Bill 942.
That's Bill 944.
There you go.
It's on y'all's out.
And are we the only occupation being picked on?
As far as this bill is concerned, you are. I know real estate appraisers is going to be asking for it, and they actually asked for it to be included in an administration bill this year, because there are going to be federal requirements that require it for real estate appraisers that go
Okay.
into effect in 2015.
Okay.
So they are going to have to.
What
in
about
order to
attorneys?
comply.
Do they have to do it now?
No.
I didn't think so. They get exempt from everything.
That's because they're good lawyers.
Yeah, they write the law.
Well, they do. Escrow accounts, you name it. They get exempt from all kinds of stuff. Nobody checks their escrow accounts.
Let's go home.
None of them got any money.
Is that all you have for us, Mr. Pugh?
Thank you.
Michelle
Yeah.
don't want to be fingerprinted. I'm thinking she's got
Now-
something she's hiding.
Next-
I make a motion
Next
to
thing,
recess.
next thing on our agenda, we're not finished, we're not finished with Julie, we're not finished with Julie's report.
It's in order log. I was just going to give you a quick update on the rules, which wasn't on there, but I had some new information, but it won't take but a minute or two.
Okay, go ahead, Julie, you're in charge.
We had, as you recall, we had two sets of rules that we did rulemaking hearings on back in June. There were the VLS rules and then what one would call the non-VLS rules. The non-VLS rules, which were, I gave, you each have a copy of a printout of the rules, and I've highlighted the new ones. On page 5 of your smaller stapled stack, there's highlighted a subsection 6. You all had expressed interest in the amendment to the fees, where there would be a $10 fee to be paid into the Education and Recovery account for an original license. This rule was effective as of Monday, March 3rd. This is an effective rule now. Also effective on Monday, March 3rd, in the second set of documents, page 10, the civil penalties were the civil penalties rule 1260-02-.32 was reworked to where the maximum civil penalty for all of the violations is $1,000. It was to clear up some issues with the previous rule. It was kind of misnumbered and things. That's also effective as of March 3rd. And the final rule is on page 14, the last page of the bigger stack, the death or extended absence of the principal broker. That rule is effective as of March 3rd, 2013. The VLS rules, I received back signed from the AG's office withdrawing those fees that we discussed last month. The rest of them were sent ahead, signed off on by the AG, and I hand-delivered them over to the Secretary of State's office on Monday, which I believe was the 4th. I believe I haven't gotten back the signed page stating when the effective date will be, but approximately 90 days from that date should be when those rules go into effect. But I did want to let you know that these 3 rules were effective as of March 3rd. So.
Last meeting, you were going to update us by email on what was transpiring on the Hill, and I haven't received any email.
There were no more bills, and the only 2 amendments we had were the E&O bill and this fingerprint bill. There were no further, there were no other bills after the last meeting. Today, the one.
And understand, we try to be careful about what we send on to you, because a lot of times people are getting into where they're drafting, and you're really not sure what's going to go on a bill up until the time it goes on to it.
Yeah,
and
caption
goes
bills.
Yeah. I know on the E&O, we had about 3 or 4 drafts that were kind of floating around before they put the last draft on. So
And
we
the
try to
thing-
be careful. We don't want to give you false information, and you looking at a bill that is really not, or an amendment that's not going on the bill.
And the fingerprint amendment that we had that I was prepared to update you on today apparently was just changed today while we've been in this meeting. So
That's why I wanted to come down, because I got new information today while I'm sitting up on the Hill.
those are the only amendments that we've gotten any notice of at this point, and there were no other bills since last meeting.
Boy, I think we all had background checks before we were accepted as commissioners.
All you lacking is the fingerprints.
Okay, is anything else to come before this day's session of this Real Estate Commission? Hearing nothing, then we are recessed until 9 o'clock in the morning.